Ladies and gentlemen, thank you for joining us. I'm Rob Litz with Miles Mediation and Arbitration, formerly of U.S. Arbitration and Mediation. And our company has been providing quality CLEs now for more than 20 years. This best practice program is our 91st program that we've provided, I like to say generally to the St. Louis community, but since we've been doing these by Zoom over the past 5 years, we have folks from around the country joining us. It's wonderful to have you with us today for this great program. We've stretched in a few areas, and we're doing a few things that are a little outside of our norm, but we think it's going to add to both the quality and the breadth of the programs that we have presented. And I really do look forward today to moderating this program and speaking during one of the sessions. You should have had the link to our material for today, and it's a good inch and a half worth of material. Some of us older lawyers grew up thinking that we are supposed to kill a tree a day. We're saving some trees by not sending this to folks, but it is outstanding material, a lot of reference material, and we think you'll get a lot out of it. I really can't go forward without thanking Kelly Spiller of our team here in St. Louis and Tangela Richmond, who heads the education division within the Miles organization. Both were so helpful in this, and Tangela leads this effort throughout all the dozen Miles offices around the country, mostly in the Southeast, with providing quality legal education. So thank you so much. Kelly will be sending an email with an evaluation that both Missouri and Illinois require for CLE credit. That will come to your email. Those who are looking for Illinois credit, just send an email to Kelly, and then she'll get the form back to you, the certificate form. Today's program on for for Missouri credit is CLE number 767249. If you missed it, it's on the first page of the seminar materials. It's probably in some of the emails, and I'm sure Kelly will include that number when she sends out the eval to all of the attendees. So we ask you to mute your audio and turn off your video as we go forward. Coming in this morning, I had a reminder on the radio that today is D-Day, and 81 years ago, so many of the greatest generation risked their lives, and many gave their lives for our freedom. And it was something that I thought I would mention, that it just gives us pause to be thankful for those before us, because we all stand on the shoulders who came before us. So let's get started with our first program. I met Zach Graham just a few months ago, highly recommended to us, and we thought that we've never done a program on the psychology of negotiation, and it would be something, I think, of interest to you lawyers and those who mediate and negotiate. We all negotiate. So Zach is a PhD, undergrad, master's, and PhD degree from University of Missouri, Columbia. A good part of his practice involves coaching, some of it in the sports area, but he's worked in a variety of industries. Now, Zach, you'll get to put law as one of the others. So healthcare, construction, real estate, private equity, hospitality, military, tech, all part of your consulting and coaching practice. And we welcome you to chatting with a bunch of lawyers and some retired judges and mediators. And it's great to have you this morning. Thank you so much.
Absolutely. Thanks, Rob, for having me today. So I apologize in advance, folks. As you can probably tell, I'm fighting a bit of a head cold. Uh, of course, that always happens, right? Is you have a conversation with Rob, think about how I might be able to offer some value during this time together. Not sick throughout the whole winter, and then the week leading up to this conversation, coming down with the head cold. So I appreciate your all's patience in advance, and I'll try to mute myself before any loud coughs or sneezes. So as Rob shared today, psychologist by training, most of my practice is in leadership development and executive coaching. Also a self-described entrepreneur and a bit of a kind of serial entrepreneur growing up, started businesses for fun during the summer, which led me to the hard truths of getting swindled quite a bit on those first few negotiations and being behind kind of where I needed to be as far as making that situation a good opportunity for me. And so excited to talk to you guys here today about how we think about the psychology of negotiation and how considering some of these more human elements might serve you in your practice. So I'm going to get started here with sharing my screen. Rob, can you see that screen okay?
I sure can. It looks great.
Awesome.
Very good.
Since there are so many of you here today and hard to raise our hands and communicate more verbally, I am hoping that we can participate a little bit in the chat. And so I know Rob is going to keep an eye on that. I've got my kind of chat box open, but would love to get some feedback from you all kind of along the way regarding your experiences. So as Rob mentioned, I worked for a firm named CMA. We're based out of the St. Louis area. We're a business psychology firm founded in 1975. So we are coming up on our 50th anniversary, and we now have offices in Kansas City, St. Louis, and Denver. Our clients are a wide variety from Fortune 500s, private and family-owned businesses, and not-for-profits. And we typically carry somewhere around that 400 to 500 active clients. Something we're really proud of is 95% of our current client roster are repeat customers of CMA. A lot of the business we do is around organizational effectiveness, coaching, and assessment. So a lot of assessment for selection. We take people through kind of the best in class psychological assessment, understand their strengths, their growth areas, and then we do a lot of coaching around that. And so a lot of our executive coaching is for high potential leaders, performance management, and helping people really kind of step into their leadership identity. And then we do a fair amount of organizational development services such as DEI work, strategic planning, change management, talent management, training and development. Some of the things that I'm hoping we can consider today and work together through is to understand kind of some of those underpinnings of the key psychological principles that are included in negotiation. Think about and talk about how we might be able to apply the persuasion triangle. So I'm sure you all are familiar with this: ethos, pathos, and logos. And reflect on some of your personal negotiation tendencies and think about what actionable strategies might be helpful as we approach mediation. I think when Rob asked me to talk on this subject, it made me kind of step back and think about what the work you all are doing, and many folks in the mediation and law space on a regular basis is, and the human elements of that, and how even with my understanding of psychology and human nature, in situations where I've been represented by lawyers or in a negotiation, I think the expectation can be really high for you all, right? As people want to come out with their dream scenario with the best possible result for them independently. And when you have multiple parties partaking in that, I think things are kind of foundationally keyed up to be hairy, right? To be challenging. So we're going to get started with a poll. The easiest way to do this is to do a QR code on your phone, but also feel free to join over it. You can just type in slido.com into your browser and use that code below. But I would love to just take a few minutes here and see what percentage of your day-to-day work involves negotiation. And as people kind of get an opportunity to answer that poll question, if a couple of you can just start throwing some thumbs up in your on your screen there, just so I can kind of know if people are making headway on this. Awesome, thank you. Ellen, so just joining at slido.com and then typing in that number allows you to answer the question, or you can use the QR code on your phone, which I find is the easiest. You don't need to log in or create an account or anything like that.
Zach, looks like you have a pretty good response rate.
Hopefully we jumped. Okay, there we go. Okay, so it looks about 0 to 25%. Some of you in that kind of 25 to 50, and then higher numbers as well. And so I think that's something really interesting to think about as we kind of think about this conversation today is, you know, a fair amount of you, a considerable amount of your time is in kind of active negotiation, right? And so this is managing a lot of competing priorities and personalities, and not to mention your own experience. And I think that is one thing, both as a psychologist and mediators, lawyers, that we can really share is we're often helping people navigate challenging times, right? For many people, some of the most difficult times. And so when we're taking all of those kind of competing interests into consideration and having to manage the logistical, ethical, legal implications, it can be a really challenging environment to be in. Okay. So one thing I think a lot about when I think of negotiation and just interacting with other humans is that inherent kind of discomfort in negotiation, right? And I think that is something that oftentimes too, I would imagine from your all's perspective, this starts to become more routine and regular in your life. And negotiation becomes something that is more just kind of your day-to-day work, right? It's really easy to think about it in terms of the logistics of the situation and getting the deal across the finish line, helping get through this project and moving on to your next one. So just another quick poll. I appreciate you all engaging with me. Again, QR code there. But I would love to know a little bit about your thoughts on why negotiation can feel uncomfortable. So if you just want to throw 1 or 2 words in there, that would be great. And we'll kind of see a word cloud starting to populate. Yeah, seeing contentious and uncertainty, conflict. Yeah, seeing that conflict and uncertainty and fear really kind of present themselves as a common experience that people are having. Expectations. I think that is such a wonderful one, right? Expectations for everybody in the room, all the various parties. Mannerisms, right? Dealing with different personalities and people, lawyers in all caps. Yeah, fear of not being the objective. I think those elements of conflict, uncertainty, are things that I hear so often when I'm coaching people who are navigating difficult situations and negotiations, right? And how to manage everybody's expectations in the situation. You know, I just think about this situation I was in recently is my wife and I were really fortunate to have an opportunity to move to Kansas City for a job, but then we had a home to sell in Columbia as I finished school. And one thing that we noticed is, you know, we had bought, it was our first home we purchased together and had fixed it up, had this kind of once in a lifetime opportunity where home values increased at such a pace, and how emotional, even though I was looking at the property as a kind of a business arrangement and investment, something that helped us get our footing as we kind of started to build a life. And I thought a lot about the emotional elements of that, right? So you get these offers from folks, and it's hard to not be a little offended at times, right? And you know, we go back and get the inspection and go through this process, and they're asking for more money off, and et cetera, right? And I noticed how my emotions varied so much in that, right? But as I took a step back and looked at the numbers, the investment, and saw the return that we were going to see on this, it really, actually, we had a lot of flexibility. There was a wide zone where I really felt like I would be happy with the outcomes, right? Thanks so much for taking part in those polls as we kind of get started today. So why is negotiation uncomfortable, right? And what are the elements that make it uncomfortable? I think from human nature, right, we prefer saying yes and fear hearing no. And we saw a lot of that as participants answered questions in that word cloud, right? Is that inherently, as humans, we want to be part of the group, right? We typically crave a sense of belonging. And so it is much easier to feel a sense of belonging by conforming and saying yes. Now, I think there's another element that's also really important, and my wife will tell you this is a big one for me, but a concept we call psychological reactivity, right? Which is, you tell me what to do, I'm instantly going to be defensive, right? Or, you know, I can't tell you how many times I've probably been asked to do the dishes and they'll get done when I get a chance, right? You know, having that kind of initial reaction and defensiveness. And so in a situation such as a negotiation and mediation that you all are in so often, it can be really complicated, right? Because you're managing both elements of that. Your own desire, right, to find a common ground, to find an acceptable solution, multiple other parties, right, who are both not wanting to budge, being defensive, but then also wanting to kind of please, right? And it depends on who the stakeholders are, from those primary stakeholders to the secondary stakeholders, and so on, of how many different people they may be trying to please in that situation. So you can see how quickly, with all these different connections, things can get really complicated. So I think uniquely as well, as professional mediators and attorneys, the dilemma you all face is a big one, right? Which is, there's this pressure to be objective, assertive, to have a command of the ethical and legal considerations in this situation. Yet, I really think when we think about the psychology, the foundational elements, the human elements of negotiation, emotion and empathy are really most important. And I think that, you know, often we think about emotions, right, and feelings, kind of like a faucet, right? So when you have a faucet, it typically, right, it doesn't have a hot or a cold spout. It's just one spout. And when you turn off the faucet, both the hot and the cold water turn off, right? And I think that analogy is always helpful when we think about emotion and empathy, in the sense that uh, we can't just turn off one, right? We can't distance ourselves too much from the situation. I'm sure many of you have read and listened to many TED Talks and books around distancing yourself from emotion, right? Creating some distance between you and the other person when you're trying to negotiate effectively. Um, you know, based on our experiences coaching folks at the highest level, negotiating acquisitions, hiring across a wide range of industries, we actually really see so many folks who take a more emotive and empathetic approach, who are more connected to those emotions that they're experiencing, have some real success, and really get to that bottom and kind of clarity around what does each party want, right? So I think those are really interesting things to think about. So I wanted to present a framework for how you might approach negotiations, considering this kind of human element. So I'm sure many of you are familiar with this to some extent, which is the triangle of persuasion, which refers to the ethos, refers to the appeal to authority or credibility, right? Which considers reputation, status, qualifications, and experience. So for all parties, and I think particularly in the case of you all as mediators, this ability and credibility is important, right? Just even as Rob introduces me today and I introduce myself, trying to establish a little bit of credibility, right? Why do I even get to be here to talk to you about some of these things today that contribute to negotiation? And so I think that's important too, right? Establishing both your past experiences, your training, your education, what elements help you kind of connect and establish that credibility with other partners in this negotiation. Pathos refers to the appeal of emotion, right? Using feelings, vivid language, and stories. And so that's kind of the rapport building part, right? How you're connecting with those other humans, and how those kind of elements of emotion and the human experience are contributing to this specific negotiation. Logos refers to the appeal to logic, right? Inherently in the negotiation, we also have to apply the logic. We have to use the facts, statistics, or logical reasoning and make clear connections, right? I think about this often, right? Recently, I just sold a car because it made sense for us to get rid of it. And, I'm kind of sitting here thinking, I wonder how long I can go without a car, right? Because the element of going to negotiate for a car feels so unpleasant for me, right? And it's not because I lack confidence, because I don't love cars. It's actually kind of a hobby and passion of mine. But going into a dealership and negotiating and doing the games back and forth feels hard for me, right? It feels uninteresting. And so I often think about what are those kind of factual elements, right, that I need to show up with? And how am I going to connect with a person in this situation to make sure I get the kind of deal that makes sense for me, right? And I'm sure many of you can relate to that throughout your kind of daily work. Okay, so as we think about applying this triangle of persuasion, I think about it in first, right, establishing that credibility, understanding of why you're here, how you can help. The second piece, building rapport, so connecting with others, how you can get them to open up, give you clarity on both what they truly want and where there kind of might be a middle path where you guys can connect. And then leveraging data, right? So good facts and understanding of the situation at hand and what a reasonable outcome is based on a variety of different factors. And then from there, kind of taking those action steps. So when we first think about credibility, how you show up in negotiations matters, right? Advocating for yourself while maintaining professionalism. I often think about this in terms of confidence and entitlement, right? We've probably all been in situations where we've experienced both. And so, confidence is key, right? Where you can project your knowledge, preparation, a collaborative mindset. Entitlement looks a little bit more like you assume your request should be granted, right? Without demonstrating that value first. And that can really kind of turn people off, right? We often see this with executives we work with when they're going to the board or whoever they report to for a contract negotiation, right? Is when we ask them, why should their comp package shift and be increased? And a lot of times it's kind of a simple answer of just because, right? And it's not that they're inherently wrong in that situation. It's more so though presenting the facts, right? Connecting what their value add to the organization is and how they've made relationships and how they can leverage those relationships in showing up. So I think some key questions to think about as you consider this is, what is my unique value proposition? What am I able to do that brings some value to the situation? What leverage do I have, right? Where is there elements of what the other party needs? And have I done my research? So we thought about the elements that need to be included to help make sure that all the parties in this situation feel as though there's a reasonable solution. I think a lot of times establishing credibility can include framing requests as a win-win. So show an understanding of the situation's goals and constraints. Use specific examples of the value, right? Again, bringing that kind of elements of logical and facts to the situation. Building rapport. I think this is really more of an art than it is a science, right? So a lot of times people use logic to justify decisions, but they end up acting on those decisions emotionally, right? So whether it be buying a house or like you said, I said earlier, a vehicle, right? It's usually something we want, right? Or need in a situation. And so that it creates emotion inside of us. And if someone connects with you, they're more likely to find a way to say yes, right? Because they're viewing you not just as an objective, kind of faraway party in this situation, but another human, right? And that is where you can activate some of those elements on the other side of the equation of people wanting to connect, right? People wanting to say yes. So one thing we think about a lot in our field with fostering connection that I hope serves you all well is really kind of considering what we call the matching principle, right? So matching people where they are at. Using empathy to show you understand the other person's constraints, right? So when coming to a conclusion to find the middle path for both parties, I think approaching the situation where you're going to match their energy, how they're approaching the situation can be really helpful. So, there's a concept in psychology called neural entrainment, right? And it's when people connect on an emotional level, their body language, their breathing, and even their brain waves start to sync up, right? In modern culture, we kind of call that catching a vibe, right? Where there is an element of connection, and you probably have people in your life where you felt really connected to quickly, and other folks where it was harder to feel that connection. And so it's a deep level of kind of neural mirroring where there is really a biological connection. I know that this, time today is filled with folks from across the country, but for most of you in the Missouri, kind of Illinois area, right, we're very familiar with that term Midwest nice, right? Where you're walking down the street and a lot of hellos and haze and small waves, and you notice yourself probably smiling before you even noticed it, right? You think back to those situations, and it's really interesting that there's been a lot of brain imaging studies done. When someone smiles at you, our nervous system reacts and smiles back, right? As kind of like a friendly, non-threatening person. And so this is an element that's interesting to apply and consider as you're connecting with others. Is what is your body language? What's the tone of your voice? How are you presenting? And what are you doing to connect, right? I think another thing when we think about fostering the connection is keeping the conversation collaborative, not adversarial, right? Listening closely, being honest and authentic. And what's really remarkable is research shows that humans can often tell when others are not being authentic, especially in their kind of presence. And so while that may seem surprising, I think that's something really to consider and think about is how you can approach each situation honest and authentically and keeping and listen closely for what they're saying. It might help you uncover an understanding that you didn't previously have. So I would love it if you could just think a little bit about a recent negotiation or situation you were in and how you could have tried to foster a connection with the other person, or how do you think that may have impacted the outcome? So I'm just going to give you a couple minutes here and then go ahead and feel free to pop something in the chat for anybody that feels like they're willing to share. And we'll see what we have. So a situation where you could have tried to foster connection with the other person and how you think that might have impacted the outcome. Well, it looks like some folks are maybe having issues with the chat function, not being able to reply. So Ellen had said that eating at a restaurant owned by the plaintiff, the restaurant was not part of the suit. Ellen, can you give us a little more context around that of how you think either your ability to connect or not connecting with them may have impacted the outcome? Yeah, establishing a sports team connection. Yeah, Ellen, I think that's a good point, right? Is you genuinely like the restaurant, so it offered an opportunity for you to connect with them and build a relationship. Awesome. Thanks so much for throwing some ideas out there. So, how can we leverage data, right? And I think this is a really important element of this situation, particularly as it relates to humans, right? And so, data can add credibility to your negotiation. You can use comparisons, industry benchmarks, and performance metrics to support your case, right? And I think that's another thing too is you've created this connection with them, you've established your credibility, and now it's part of the kind of process to get down to the facts, right? What is basing your position in this negotiation? So providing a logical case to the other person helps really achieve this desirable outcome, right? As I think a lot of times, especially when people are open to it after you've built this rapport and connection with them, it helps them kind of be more open to the facts that you're going to present. I really like this diagram here because I think it is such a nice visualization of the work you all do, right? And so we think about here we've got, kind of seller settlement range, right, as an example. So of course the desired price is over here on the very right end of the spectrum, right? And the kind of very left side, seller's worst case. And then you see the same with the buyer settlement range. And here under there is that common ground, right? The zone of possible agreement is what we call that. And so I think that's finding that range of where both parties can agree is really interesting. And that takes a lot of connection building, fact finding, and really allowing yourself to be open to creative solutions and possibilities there. And I think that's something that's really interesting to think about, right? I mean, one of the biggest phrases I use in my work, especially with people who are having a hard time understanding what they want, right? It is really encouraging people if you feel like they're right there on the precipice or you're not getting the information you need, is the simple phrase of, can you tell me more, right? And it's really remarkable how often that can help people pause for thought and think in a deeper way about what it is they really want, right? And so I would encourage you all to really use that phrase or something like it that feels right for you in allowing people to really explore what it is they want and you helping them come to that conclusion. I think so much of the work I do in executive coaching really comes down to what people want, right? And then with that data, we can move forward, right? We can always find a path forward once we're clear on what it is somebody wants. So what I would love here is I'm going to set you guys up in breakout rooms just very briefly for about 5 or 10 minutes. And think about these questions. You know, thinking of a tough negotiation, what felt most challenging about this negotiation? Which triangle element did you use, right? Either credibility, rapport, or facts? And what did you learn from the situation that took you to the next negotiation? And I will get everybody set up in these breakout rooms. Thanks for bearing with me as I get this set up.
And Zach, we have about 15 minutes or so.
Okay. Well, instead of doing that, since we're running just a little bit behind, why don't some of you throw some ideas in the chat around, I'm just going to pack this up a little bit, sorry, around some of these questions. So thinking of a tough negotiation, and maybe some of you can share what some of these elements were for you. So if anybody has any input on a tough negotiation and what felt most challenging about this negotiation. Unprepared parties and their expectation that I could move them past the lack of preparation. CJ, I think that is such an awesome one, right? And really kind of echoes what I was just speaking about, right? Which is first, both parties have to really understand why. And that's a mix of both what they want and kind of the elements of the facts, right? And using the logic. Any other folks who had a recent tough negotiation and what felt most challenging about this? Yeah, Ellen, great point, right? So an additional charge or complaint that wasn't included. And I'm assuming that kind of really changed the direction, added an unforeseen element, right? Yeah, long-term litigation created barriers. That makes so much sense to me, right? Is like, how are we going to get this solved? And the element of it's going to be a long process. So people are maybe not as motivated, right? And I think that's another thing too, is thinking about how to motivate and why we should move forward in this negotiation. Yeah, Maggie, great point. So Maggie noted that rapport and credibility and facts are all important, but when the other party ignores facts, no amount of credibility will save the day. I can really understand that. I think that makes really good sense and something that's hard to overcome, right? Maggie, if you got a second, tell us how you handled that situation. So Frank said reliance on liability determinations that were flawed and made by property damage adjusters on an injury case. Yeah. So facts that don't feel factual, right, Frank? So things that don't feel true and impact how people are viewing the case based on misinformation. Yeah, Mark, another great point about pre-suit mediations where the parties have not done the discovery and don't have a great deal of information, right? I think thinking about that as you approach the situation is, what information do you want? What information do you want to find? Follow up from Maggie, right, with kindness and patience. I think I really appreciate that position, Maggie, because I think we often think about in situations like this, like road rage is a good example, right? Where we would all have a safer experience on the road and be better off if we were able to kind of manage our emotions as we move through those challenging situations. And so a little bit of kindness and patience can go a long way. I think especially when you're trying to appeal to the other side's kind of willingness to negotiate, right? Is connecting with them and building on how you're thinking of it, right? What are the facts you're using? Anyone have any experience that they might just be able to share where they really changed the way they did negotiation, right? So even briefly, if you had an experience where then you really have started to approach your work in a different way. Yeah, I think Maggie added another, I think, great point, which is to get the people to separate, right? If there's more than one person, kind of separating them and getting some space and distance, either to kind of calm things down and also to get to the root of both of them, what both of them want. Excellent. I really appreciate so many of you throwing some ideas in there as we thought about this. So as I think about next steps and what might be valuable and helpful as you all kind of consider how to apply this model in your own negotiations and thinking about the human elements, first stopping to think, what is your unique value, right? What value can you add in this situation, either as an attorney, a mediator, right? What are you here to do? What are your goals, right? Are they financial, relational, reputational? I would imagine many of you are in situations where all of those things are equally important, right? And so what are the goals of this situation? What emotion might the other side be bringing in? Again, a really common thing that we discuss and work on in the coaching work I do is understanding how the other person might be perceiving the situation and feeling, right? Because then that allows us to get to why they have the position they do when we understand more. What data supports this case, right? So is your argument factual? Is it grounded in reality? I'm sure many of you have been in situations and negotiations where they were not grounded in reality, and those were particularly challenging. And what will you do if you can't agree, right? What is that zone of possible agreement that you might come to? So just as I'll leave you all with a hope that before your next negotiation, prepare a little bit how you present yourself, how you think about connecting emotionally with the other parties involved in the situation, and how you might justify your request with data. Again, thank you all so much for letting me come in and chat with you briefly today. I really appreciate it, and hope you guys have an awesome day the rest of your time. So thanks again, Rob.
Zach, that's really outstanding. And you raise so many points, why people feel the way they feel. Some of that we're actually going to get into later this afternoon on empathy-informed practices for lawyers. The trauma-informed approach, understanding where do those emotions come from, and if you are a lawyer with a client, or if you're the mediator in the room, having to unpack why do they feel this way. And I think that's really a great point.
I really appreciate that connection, Rob.
The other thing, Zach, that triangle maybe reminds us, so many folks come into negotiation, or specifically mediation, thinking it's all about the law, especially when we have law students who come and observe many of us, and especially when they're in their second year of law school, all they've done at that point is read appellate cases, and it's only about the law. And when you look at them before you walk into the first caucus and you say, look, this is really going to be 90% psychology, and the student looks at you like you have three heads. But by the afternoon, they'll pull you aside and say, oh, you were right.
Yep.
Yeah.
Yeah, Rob, I really appreciate that. I think that is such a common thing we see, right? So in training, like many of you would go to grad school for a long time, and I think at some point in time, they're going to share the secret with me, right? To quality therapy and coaching. I want to work with high-level leaders and folks in the military and sport. And really what it always came back down to was my ability to connect with them, empathize with them, and support them, right? And if I was able to do those things, whether they were a law student navigating that second year and how they're kind of stacking up against their classmates, or a high level executive, right? Trying to figure out how to manage a merger and all of the competing interests. It really came back down to the kind of emotional side of it. So thanks again, Rob, for that point.
No, and I also want to just mention Judge Mark Siegel referenced what happens when we're mediating, or when lawyers are negotiating without having the necessary information. Not all the information, but the necessary information. When I started with mediation, I thought we had to do that right before trial because we had to discover everything. And what we learned was we really need to know the material items that apply to the case. What was instructive was the federal court in Kansas City has this early evaluation program, their MAP program, and there's an in-house director who will help mediate. And what they did in a case that I had, an employment case, they wanted to know, okay, in order for you all to have enough information, what do you need? Plaintiff says, I want to see my file. I want to depose the supervisor. Great. The defendant says, I want to depose the plaintiff. Great. Come back in 30 days when you've done that. The case settled within an hour because we had the information that we needed. Not necessarily everything for trial. And as Judge Siegel mentions, sometimes we mediate disputes that are before a suit is filed. And the key for us is making sure they have enough information exchanged so that they can make decisions. People make decisions with information. And, personal injury cases, when perhaps the plaintiff's counsel forwards all the medical information after the accident. Well, what does the defense really want? They want that plus the medical before the accident if there were the identical problems. So if, that's one of the things we're doing more and more is speaking with counsel before we get to mediation so that they're exchanging information. It's not unusual for information or documents to be exchanged at a mediation. Why? Because they can make a better decision. So anyway, you raised super points. And Zach, thank you so much for this. I think it's going to give many of us a little different approach on both how we negotiate and how we mediate. And by the way, if you need help buying the car at the car dealer, there are a whole lot of the 94 people on this Zoom who would just love to try to out negotiate. I don't care who it is at the car dealership.
I so appreciate it. Thank you all so much again for your time and attention today. It was great to be here with you, and I wish you have an awesome rest of your day.
Great, Zach. Thank you so much. Feel better. Be well.
Thank you. Bye.
Okay. Kelly, would you pause our recording, please? Folks, next up on our lineup, always important to have a good second place hitter, is a group of outstanding trial lawyers. All of them in the room that you see have decades of trial experience, and most importantly for us at Miles Mediation, they're members of our panel. So as the folks at home are looking from right to left, Ted Williams has been litigating for, like I said, what, Ted, just about 50 years plus?
50 years, yes, sir.
A good majority of that in various transportation areas, and a great member of the panel. Tom Magee, also 35 plus years of litigating. Tom is going to moderate this panel, and he and I had talked some time ago about the importance of the timing of mediation, and this is a great topic. Melvin Kennedy, not a stranger to many of you. Melvin was a senior lawyer at the EEOC, still in private practice and also a neutral. But most importantly, he's giving back and bringing in the next generation and teaching mediation at Washington U Law School. And Melvin, a couple of your students did come and observe this past year, and they're thankful for your leadership there. Steve Hughes, also a very experienced trial lawyer, been on both sides of mediation as mediator and as a trial lawyer. And we just have these decades of experience. And Tom, I'll let you take it away. Thanks so much.
Thanks, Rob. Do I need to, are we good on the video then?
You're good.
Okay, sounds good. Thanks, Rob. You kind of hit on the timing issue, Rob, in your last sort of wrap up of the previous session, and we're going to expand on that a little bit. And I thought about, you're always supposed to open these a little bit with a funny story or something, but talking about timing, I was talking with these guys, and I said, about the two-bit comedian who thought he was great, and he wanted to explain comedy. So he said, ask me what the secret of comedy is.
What's the secret
Timing.
of comedy?
Which of course the timing was off, but that's luckily we can't hear the groans from the audience. But anyhow, so timing is kind of it, and we talked about different ideas of that. We've submitted some of the paperwork, and whether you brought up the Western District, and for those and I've been involved in that, where they want you to go to mediation before you even really almost have the complaint in your hands. But so we thought we'd kind of expand on that and give us some different viewpoints. Melvin has had in our discussions before this mediation has had a lot of experience with what's, for lack of a better word, the early mediation, where almost you think, how can you mediate a case when you don't have, as you said, all of the information? And as you talked about, Rob, with maybe, we can mediate the day before trial or the week before trial. But Melvin, maybe you can talk about the experience and what Rob has suggested in terms of talking about the material information, and tell the group a little bit about the early mediations that you've been involved in, where they work, where they don't work, and what the pitfalls are and what the advantages of that are.
Okay. Well, to begin with, let me just say, I'm not an advocate of early or mid or late mediation. I'm an advocate of mediating when the time is right. And both sides, you know, the parties, the lawyers, everybody has to be in the right space, ready to mediate, the situation has to be right. Sometimes that's early, sometimes it's late. My experience with early mediation, a lot of it is with the EEOC. Some with the federal courts here in the Eastern District, because they will send cases out for mediation, in particular when there's pro bono, a plaintiff on one side. But the EEOC started doing their mediation program, I believe it was 1999. And so when I left the EEOC in 2013, I took a contract to start doing mediation. So I've done a ton of these, and all that has been done at that point is there's been a charge filed. And anybody who does any employment cases and works with the EEOC understands that the large majority of those charges will never see a courtroom. You know, it's probably somewhere around 5% maybe get to court. And so for the most part, the individuals who would file a charge with the EEOC, their sort of day in court, as you would have it, would be being mediated through the EEOC mediation process. And they've done a ton of them. I think that's in the materials I shared with you, between 1999 and 2017, they had over 200,000 mediations. So there's some people out there who think it's a good idea to mediate those cases early. One of the factors that I found, both as a mediator and as a plaintiff's lawyer, is that you just have one side of the story. It doesn't matter how fervently you believe in that person that you just met. You only have their perspective. And sometimes in early mediation, particularly before a lawsuit, when it doesn't cost you anything, is a good way to hear another perspective. And I think that's great. I think another time when I found early mediation to be really effective is when there's nothing really you need to know to resolve the case. You don't need to know. If you already know, I had a case in particular where I was an advocate, and I had a Black female HR director who went to her CFO and CEO and said, I've been doing some research. It looks like we are discriminating against Black females in our promotions. And the CFO, in terms of timing and the joke that you were talking about, he was intending to joke, but he said, well, not just Black females, all females. And she did laugh. And that was a case that should very well have mediated, because everybody knew it was said. He didn't deny it. The case was going to rest on whether it was funny. We did mediate it, but it should have. We got all the way to this federal district court on that one, and there was an offer of judgment made. There was nothing that could have been learned. All that could have been done was put it to bed quietly. Maybe save the relationship. I've done some early that have just been complete failures because it was a little early in the process. It was too early. Sometimes
You're early. I'm
go ahead.
Here, Jared Roberts. Yeah.
Yes, hello.
Mr. Robertson,
Is
we
it-
know you're trying to ask a question or make a comment, but we can't hear you, sir.
I just think he was unmuted. So,
Oh,
okay.
yeah.
so
go right ahead, Melvin.
yeah, not always the best scenario to mediate early, not always the best scenario to mediate late. I was thinking about this as I was driving in this morning. Whenever I use the words always and never, I've taken the thought out of the process. I'm not allowing myself to give consideration to that particular instance that is warranted. if I'm always gonna do it, it's a habit now. And, like I habitually go to work the same way. But, there are many different ways to get a thing done. My experience is, early is best in a lot of cases, just because you know what it is, you know.
Melvin, I was wondering if you mentioned the employment setting or example, is one of the reasons for early mediation in employment cases so that the fee of the attorney representing the claimant doesn't become the largest part of the claim? In other words, I've had cases where they're doing a fair amount of employment law where, yeah, there may have been some violation, but the value of the claim isn't that great. But if you wait a year into the case, suddenly now the recoverable attorney's fees sort of are more than what the value of the case is. Have you ever heard that in your position with the EEOC as a justification for early mediation?
No, I don't think so, because generally speaking, unless you're talking a really high profile employee, high level employee, it's a contingency fee. And so, nobody, no employer is paying attorney's fees as part of the settlement. That's coming out of whatever they're giving the claimant in that case. Now, you may hear arguments about how the fees are this or the fees are that, but in all candor, it's, you're working the case to the extent that you feel you need to work the case, and you're driving the fees, you know, as a plaintiff's lawyer. If your case doesn't have a lot of merit and it should be settled early, driving up the fees doesn't put you any closer to getting those fees. You still have to survive summary judgment. Now, that's another point. You know, a lot of cases, people say, well, I want to wait till summary judgment motion's been filed. Well, sometimes you don't want to get there because it's in an employment context, you know, absent. Let's say you're in a forum where summary judgment is going to be granted more often than not. That might be a good strategy. But let's say you're in a municipal court where the judge is going to have to read that extensive brief. They don't have clerks to do that for you. Your likelihood of getting summary judgment is a lot less. And so sometimes that's just money that might help get a resolution over the top early if you apply that to the resolution.
Melvin, I was thinking in terms of what you're doing, there are a lot of unrepresented people in terms
Yes.
of those. Is that another consideration? And I think it may play over into, I'm thinking of domestic cases where it seems to me, without being in that area, there's a lot of hurt feelings and bitterness, and the sooner you can mediate and try to resolve the issue, like in a divorce,
Mm-hmm.
before those feelings get amplified and multiplied. Is that something that is part of the consideration, you think, or does that help?
I can't speak to domestic cases.
Okay.
I don't do any domestic cases. I do community mediation, and it's similar in that regard when you have family disputes, because there may not actually be a cause of action that anybody has. They've got a dispute, and what it turns into, quite frankly, although you know, people will call it mediation, I like to think of it as a facilitation at that point, where you're just trying to help some people who have a dispute figure out how to move forward in spite of that.
Sounds good.
Yeah.
Ted, Rob introduced you and talked about all your experience. That was a polite way of saying you've been around for a while.
I'm saying I'm old.
But you know, just thinking about, we were chatting about your career a little bit and your experience, and you know, I've been doing this for close to 40 years, and you know, no one ever mediated 30 years ago or 25 years ago. And so maybe you can talk about, and what Rob said about, you know, and maybe you can even talk about how in your mind the mediations have changed, where people wouldn't mediate until everything was done. And now you're at a point where maybe we should ever, so where do you fit in terms of the timing? What do you think is, and it changes obviously with every case, but where do you see, and as Rob, I think you discussed it, is the material facts. What do you need in order to have a good mediation in your mind?
Well,
Well, I appreciate the question. Going back a bit, mediation, at least for me, started probably in the early '80s with me, I thought. And frankly, one of the first places I came to for mediation was USA&M. And you learn a lot when you're just starting this thing out. But one of the things that for me was critical, because I was primarily a defense attorney and reporting to corporations and insurance companies. Rightfully so, they always want information before they make the decision to put up money. And so the question is, it's a balancing act, because on one side, the purpose of mediation is to find a resolution that both of the parties, the point where they may not be happy, but they agree to something. But another part of that is to try and minimize court costs and the deposition costs and attorney's fees getting to that point. And so you're trying to find sort of the magic time. And in my experience, there's a way to do that very short of getting everything done and being ready to go to trial. And because that's where the real expense is, because you're doing everything and all of a sudden, just before trial, let's go mediate. Well, you wasted a lot of money, maybe, if you can settle the case. So for me, it's always been get some good, strong initial discovery where you know the facts of the case. I was primarily a defense lawyer, and the companies I represented, they had an investigator or somebody who look at the case and all that, even before we got involved. And so you had some basic information, but you didn't always have the basic information you needed from the plaintiff's side. And that's what you need to make an informed decision. An informed decision in the sense of advising your client as to what the factual and legal issues are. So they can make, after you make a recommendation, informed decision about how much they should or should not pay. Frankly, even before that, whether or not they want to go to mediation or take the case to trial. And I think you can do that, all of that stuff, get some basic information by just getting basic information, but also looking at the legal issues. So for me, mediation is sort of a midstream thing in the sense, because I think frankly, the first thing that you should do is try and have the lawyers work together and try and get the case settled and avoid the mediation costs. But many times with high profile and very serious personal injury cases, it's hard to do that. So you get the basic information that tells you the medical records, maybe a plaintiff's deposition, and you may or may not need that. It depends on what basic factual information you have, objective information that you can put over here from your side, and put over here from the plaintiff's side. Again, I was a defense lawyer. The plaintiff's side, and then you can sit down and look at the legal issues, the factual issues, and make a decision that whether or not you try to go to your client for mediation. And secondly, what's this thing worth? And even before the plaintiff makes a demand, I think you should have an idea of what this thing is worth. But that's a process I think that you can perform adequately and objectively before you spent an awful lot of extra money on experts, depositions, all the doctors' depositions, all the stuff that really runs on money. And that's sort of been the way I try and practice as far as mediation is concerned. But before we had mediations, this is something we did anyway, because you had to advise your client as to what the value of the case was early on, as soon as you got some good basic information.
Sure.
This isn't much different than that.
Yeah, no, I hear you. And those are all good thoughts. Steve, one thing we had talked about with just something maybe you can comment on, and you guys, we've heard this as mediators where, you come into the room and the other side says, well, we have a summary judgment pending. We think we're going to win. And so I guess from your standpoint, Steve, in terms of if you're on the defense side or even on the plaintiff side, or maybe the plaintiffs say, well, we're going to depose a doctor, we're going to take their experts. Is there some sign where you would say, I absolutely have to have something done before we can mediate? I mean, the downside, of course, of summary judgment is if you lose it, then the value goes up. So why don't you, maybe you can talk about that, or is there any non-starters for you in terms of mediation?
Well, I think that many times when we mediate, and maybe too many times or too often, it's dictated by our clients. I have done work on both sides of the aisle, much more defense work than plaintiff's work. But many times, from the defense side, whether it's an insurance carrier or a corporate client, they're the ones telling us, hey, we want to mediate this case, or hey, schedule mediation, that sort of thing. So, and obviously their decision can be based on whether they want early resolution, whether they want to control their costs, or what's driving them to want to resolve the case at that time. I think that as lawyers, sometimes we sort of, to quote the late great Richard Pryor from Peoria, Illinois, which is where I grew up, he had this comedy skit where he'd say, "I'm macho man," and go on from there. Well, a lot of times as lawyers, and recognizing obviously that as there are as many female lawyers as male lawyers, we sort of do this initial dance of, I'm the macho person and I'll, kick your butt in this case and that sort of thing. And maybe we don't spend as much time talking with each other about what we need in order to be in a position to come up with our number. And that doesn't mean sharing your number, or I think this case should settle at, but it's finding out from your opponent in the case what they might think that they need, and maybe sharing what you're going to need based on what your client's telling you, in order to be prepared to come up with that number at a mediation. We've probably all experienced the circumstance as trial lawyers where we're on our way to a mediation and we have the thought, why am I doing this today? What's going to be accomplished? Maybe the other side is at $10 million and you're on your way with $20,000 in your pocket. So I really think when it comes to agreements to mediate with your opposing counsel, it's important to have those discussions, and probably not something that we do enough. When is your client, what do you need to have? And some of this is repetitive of what has been mentioned by others today. What do you really need to know in order to come to a mediation and be able to try to reach your best number? And each side, or if there are multiple parties, what does each party want or need to know to satisfy their client that they have the information, whether it's pending motions, whether it's the law in their favor, or that they believe is in their favor. And we've heard it mentioned a couple of times today about the summary judgment. We all think when we file that summary judgment, if we're on the defense side, well, now I've got them because I've just shown them our position. Well, we also know that very few of those motions, especially in state court, even if they appear meritorious to those of us that filed them, very few of them get granted, except in the employment setting, it seems. So I really think that having a conversation with your opponent, once you get past the bravado and the sort of feeling each other out about how their approach is going to, what their approach is going to be to the case, is talking about, what do you need? Here's what I'll need. And I don't think this happens enough. I do a lot of trucking work, and in Missouri, the standard demand is the policy limits demand, particularly if you're working with $1 million policy, let's say 750 is required, that you get a policy limits demand in almost every case. But maybe the most important thing to do is to find out from your opponent, if it happens to be you're on the defense side, well, what's your real demand? And I don't think we maybe extend a demand and an offer early enough in the case so that when you go to mediation, you sort of know, yeah, we have a chance of settling this case, and you can be honest and straightforward with the mediator about those likelihoods. And so I think really finding out from your opponent what they need and maybe exchanging a demand and an offer before you even get there to look at your likelihood of success.
Yeah, that's it's interesting that you talk about that, because I was thinking about that for my next thought, is where the parties discuss mediation, and the one side will say, well, before I agree to a mediation, I need to hear a demand from you at X amount, or I need to hear an offer from you at X amount, and until we do that, we're not going to go to mediation. I've always resisted, as an attorney, I've always resisted trying to make a commitment, just say, look, and it depends on my relationship with the other lawyer. But Melvin, what do you think have you had those situations where people sort of want to pre-mediate the mediation and say, I need this before I go to mediation?
Yeah, I've had it. A defendant, as a plaintiff's lawyer, I've had the defendant say, yeah, I want a number from you. I'm not opposed to giving you a number, because the first thing I'm going to do when I get to mediation is give you a number.
Right.
So I wouldn't necessarily resist it as the mediator. I think, as Ted was saying, before there was mediation, there was lawyers talking early on and trying to get things resolved. I think what I've seen more of, in the 30 years or so that I've been doing this, is lawyers talk less and sort of advocate at each other more. And if there were, mediation isn't the only time to get things resolved early. I actually, quite frankly, anecdotally, I'm responding to a summary judgment motion. I was looking at this thing last night, and this was a case that in early mediation at the ELC, I had decided, because sometimes you just got to put the lawyer thing away and just be human. There was a guy working at a place who he has dyslexia, and his advancement opportunities were being blocked. And all we wanted was a list of career paths, job opportunities that he could apply for when he became eligible. That's all we wanted, a list. I was going to walk away and call it pro bono. He was going to continue being with this company. And I'm looking through a summary judgment, and I remember that just before the corporate rep deposition, they provided a list. It would have gone away early if they'd have just given us a list. All we wanted was an advancement path. But lawyers just don't talk anymore. And no, I have no problem as the mediator, as one of the parties, with the demand. Now, sometimes I bristle at the well, I'll mediate, but they have to start at X number. Because it doesn't tell you a whole lot other than the least they're willing to pay. Because it could start at X number and not move very far, and you've already set a tone that I think in mediation, as the mediator, what I find is a lot of it is getting the parties not comfortable with you, although you have to do that, but comfortable with that communication between themselves, the lawyers and the other parties, and making they don't have to like a deal, but in some respects, you kind of have to start to like the person you're dealing with. If the parties are annoyed at each other all day, that's just going to create a barrier to getting a resolution. So I try to avoid anything that is going to be an annoyance.
Yeah, and Ted, maybe you can talk about that. I mean, I'm sure you've been in situations where, as a defense side or even as a mediator, plaintiffs say, well, we'll mediate, but we need an opening offer from you of $1 million before the mediation. Or as a mediator, if you see that, what are your thoughts on that? Is that obviously a case by case basis, but is that a good sign, bad sign, or trouble sign, or what would you think?
Well, I think it's a problem, because the lawyers are practical, particularly in defense work. It's a practical reality in dealing with their client, where their client's expectations are based upon the evidence that you've developed in this earlier stages, and as well as the legal arguments and the ones that you anticipate the other side will do. But in the issue about, well, I'm not going to do mediation unless you make a demand of $10 million or whatever the number is, that's silly. It's just silly, because you know, the case is worth $120 million, well, maybe that's not silly. But that's not the way things work. That's not the way the human brain works. And I believe you have to have, before you start a mediation, from the defense side, you have to have a demand from the plaintiff. Because I don't want my client walking into a mediation not knowing what the demand is, so they can react to that. Because as we know in mediation, first step is, if the plaintiff hasn't made a demand, first step is to take them aside and say, okay, you gotta make a demand. But we're just wasting a lot of time here. And the problem is, if you wait until that morning of the mediation, the client representative you have with you probably doesn't have the authority to address whatever that demand is. Now, it doesn't mean you have to pay it, but it means you have to respond, I think, at some point in a meaningful fashion to the demand, or say, okay, we understand you made a demand of $10 million. We don't believe the case is worth $10 million, but here's our offer. And that's how you get the ball rolling on the mediation.
Ted, if I may, you know, one of the, I agree with you about having a demand going into mediation. One of the things that used to happen, you don't see it as often today, is that the lawyer might informally tell you kind of, I think we're gonna need and $1 million or whatever the case may be. And I would imagine that any of you at the table have had this experience, anybody can chime in, of the lawyer tells you what they need, you relay that on to your client, and maybe it's $1 million, and then you show up on mediation day and the demand's $3 million. And as a guy who does defense work, you've shared with your client to try to prepare them, and then you got to go in and say, well, the demand's $3 million, and it feels like you spend half or 2/3 of the day just trying to get to where you thought you were when you came in that day. So not to step on your toes, Tom, as the mediator, but I'm sure you might have some thoughts on this too. What happens with the backwards demand?
Yeah, I mean, I think and I've always gone again, I don't have as a plaintiff, I don't have a problem making a demand before the mediation, so they know what's coming. But again, I think as Melvin talked about, we come from the era where we still pick up the phone, unlike our children and grandchildren. But and so you might tell the other attorney, look, I'm coming in with this amount, but my people are not greedy, and we hope to get this done. I've often, and I guess I've seen this more now as I've started doing more mediations. I mean, and I don't know if it was Mike or Rob who told me this, or maybe, but mediation to me, and I've really learned this doing this as a mediator. It's really a process, not an event. So in being with someone for 4 to 5 hours as a mediator, you really see the value of the negotiation, the value of them being able to tell their story, the value of understanding what the other side is doing. So when you short circuit it by saying, I need this and this and this before the mediation, I think you lose some of that process. And, I think since we're doing this for, that's sort of my thoughts on it, but as we're doing this for Miles, and the training I got from Rob and Mike was, you want the mediation position paper in from both sides, but it doesn't stop there. You just can't read that and show up at the mediation. You've got to look for what Rob and Mike have always told me. You've got to look for, if the two sides are talking past each other, you've got to solve that before you get to mediation, I think, because, or at least let them know what's going on, or maybe have a call with each of them and say, look, this is what's happening. Or if they both say, the expert said this, and the other attorney says the expert doesn't say that, as a mediator, I think it's my job to maybe get the transcript of the expert and read it for myself to see exactly where we are. But I think so Melvin, in your practice, when you talk about the mediations that you do, is it set up that one side will normally ask for it, or both sides ask for it, or how would you?
Well, if you're referring to the EEOC meeting.
Just in general, you're gonna talk about your entire practice.
Yeah,
We don't have to
no,
go
well,
into the EOC.
Yeah, no, the ones that come to me in litigation, both sides have agreed to it or the court's order.
Mhm.
And what I find is, that it's, I don't know this to be the case and I've never asked, but in the Eastern District of Missouri, if there's a pro se litigant, I have a sense that some of the judges will send it out to mediation, as an opportunity for that plaintiff to maybe get it resolved before they have to start really holding them to the rules of court procedure and evidence. I mean,
Right.
there's been 4 or 5 attempts to get the complaint right. And maybe there's a summary judgment motion pending and there's been no depositions and discovery's about to close, and the judge will send it out and say, hey, will you mediate this thing? And what they're saying, and sometimes you get a call or from the judge's clerk saying, hey, judge wants you to help out with this one, to see if you can take one stab at getting it resolved before that pro se litigant is faced with the hard reality that you're going to be held to all those rules. And as a mediator, that's it's really helpful to me when I'm in that situation because while I can't advise the person, I can tell them the facts. I'm looking at your discovery schedule. If you haven't deposed anybody, you're gonna have a hard time defeating summary judgment because you just can't say it ain't so. And sometimes that's the first, even though I'm a lawyer and I'm not their lawyer, if they haven't been granted a lawyer by the court, that may be the first time they're actually talking to a lawyer. And it's helpful, even if you're not advising, and I think, I've had these, when I was, briefly on the defense side, I think the worst case scenario to be in as a lawyer is to be litigating against somebody pro se, because the court kind of expects you to kind of hold your hand a little bit, so, I think back to early, that's the ones you should get out of early if you can, because you're basically playing both sides of the fence for a little bit. Judge is not going to let you just run roughshod over that person.
I smile when you talk about an unrepresented person in federal court because I think of the late great Judge Shaw, who used to when they'd hear motions in front of everybody and say, being up here without a lawyer is like going to a hatchet fight without a hatchet. That was the best line ever from Judge Shaw. But Ted, what about the situation? And I've seen this happen, and I failed miserably as a mediator on one case, and I guess I didn't pick up on it when I initially talked with them. But we go into the mediation, and one guy's at 5 billion, and the other guy's at 5,000, and their excuse to me, I said, "Well, why are you guys here?" And their excuse to me was the defense attorney said, "Well, the plaintiff said they wanted to mediate," and the plaintiff says, "Well, the defense said they wanted to mediate." It's almost like, and maybe tying in with Steve, if you ask for mediation, how do you avoid sending a signal to the other side that means you're going to do whatever they want to do?
Well, when I'm a mediator, what I do is I after I get the position papers and all that, I call each of the attorneys and say, okay, I understand each of you, putting aside the court requirement, I say each of you want to have a mediation. And I want to hear what their answer is. And I expect it to be, we're not saying the case is going to settle, but we're willing to go through the mediation process. We send you our position paper. Sometimes you have to chase people for that. But that's something that you really have to give to the mediator, a thorough position paper, legal and factual issues. But you've got to get a commitment before you walk into that mediation room with both of the sides. And you, of course, have to believe the people are telling you the truth. If they're not, that starts us out on the wrong foot to begin with. But that they all want a mediation. It doesn't mean the case is going to settle, but what it does mean is they're coming here in good faith. And they're here in good faith to try and get this thing settled. And I get that commitment from the lawyers individually in a phone call initially. And then that morning, when we all sit down together, not necessarily to make a presentation. That's seemed to be going out of
Sure.
fashion now. I'm never crazy about that anyway, but in that situation, the first meeting we have, I say, well, my understanding is, I look at right at the plaintiff, the right at the defense counsel and his representative. I understand you all are here and you want to try and mediate this case, and you're going to work in good faith to do that. And if there's any hesitation, I take them aside. Because we're not going to waste time or money playing a game here. We're here because we both, in good faith, want to try and find a way to resolve the case. And that's for not just the plaintiff and defendant case, that's for multiple defendants or multiple plaintiffs.
Yeah.
But you have to get that commitment.
What can lawyers do in terms of communication with other lawyers, and maybe you all in your experience where, and Melvin, you and I kind of touched on this, but someone has a meritorious claim and it's a statutory claim that allows for attorney's fees and costs and that sort of thing. And so you have the lawyer showing up and laying out their damages, and maybe a huge portion or maybe even more than the value of a legitimate case is less than what the fees and costs are going to be. I've been in mediations where the lawyer will sit there and tell you, well, we're going to take all these depositions, all my fees are going to be recoverable. Have any of you experienced that, where it seems like a lawyer might have their fees and costs as a larger part of the overall claim than the actual plaintiff's claim? Has anybody experienced that and then had to try to bring the person back? Maybe the lawyers haven't talked about it in advance, and bring the person to what's the true value of the case to their client.
You know, I've not had that, Steve, but on the flip side to I mean, that is a risk of the defendant. I mean, you know, that's the nature of the beast. You know, there's been a number of lawsuits in St. Louis recently by an attorney out of Florida who's filing ADA violations, asking for attorney's fees, and his demand to settle is fairly minimal. And so the risk, of course, is, well, we think we can defend it, but you know, if you go all the way to trial and you lose, you've got a potential big ticket.
Is this one of those cases where they show up at a particular restaurant, they know the layout of every one of these chains, and what they have and don't have?
Right. So, but you've also got, you know, in the civil rights cases as well, where, you know, I think that's part of the damages that the defense has to recognize, where you've got a police officer stop someone and searches their pocketbook when they shouldn't have. Is this person injured? No. Is the person, you know, garden variety stress? Maybe. But clearly it's not but yeah, I mean, attorney's fees are part of the process. And I think, you know, maybe that's from the defendant's standpoint, they could certainly try to shoot for early mediation in that case.
And I agree with you. And it seems like that's where it's appropriate. I recently had an experience, not to tell war stories, but once we got past the issue of whether or not my client might have exposure under a statute, the damages were pretty well capped, but we were on our way on the fast track to a trial, and the discussion and the negotiations was, well, these are what the attorney's fees and costs are going to be through trial. And that became really the negotiating point, because the lawyer had it on a percentage. It's like, well, it's just going to mean a greater recovery if I get these fees for my client, and what do you do about it in those circumstances? And that's a case, I think, where clearly early mediation, a more aggressive approach than maybe what we had would have and could have been helpful to try to get the case resolved.
And that goes back to the issue of getting enough basic factual and legal information in the initial discovery to really have that answer to make that decision. And that's why, again, I'm the advocate for sort of a down the road a little bit mediation versus something early, because what you said is absolutely true. I'm not totally discounting all early mediations, but I'm uncomfortable in a situation like that. For example, if I didn't have enough factual information from either my client or from discovery from the other side, plus looking at the legal arguments, so I can properly advise my clients of, this guy's claiming $10,000 in extra attorney's fees. The question is that really a factor in this case that we have to consider, or is it he's just blowing smoke?
Yeah. Rob, we've got a few minutes, maybe 6 minutes left. I don't know if there were any questions or you were going to have.
There was a comment, Judge Siegel mentioned the benefit of mediation early or otherwise is the exchange of information the parties may not have been aware of. And I think, Tom, you touched on first the benefit of position papers, and then perhaps more importantly, the follow-up with the lawyers before the mediation, because it's not uncommon, for example, in a personal injury case where the plaintiff says the medical bills totaled $125,000, and the defense lawyer's position paper says we show $67,000 as the total amount of bills. Well, it's pretty clear that they haven't shared all the bills, and if they haven't shared all the bills, the insurance rep or corporate rep need time to review those. So it's great in that opening call, as we've already reviewed position papers, to point out, gosh, the plaintiff shows this amount, but the defense only shows another amount. And I think that's, Tom, a really important part. And do you all also make inquiry in your calls to the lawyers in advance of mediation to maybe share some thoughts about where their clients are coming from, or what is motivating their position, or what their clients' expectations are? What do you think, Tom?
Yeah, I think that's always important to discuss with the attorneys. Maybe get a feel of, a common question is husband and wife, who's running the show, or a couple, it's a business, who's running the show from the business, who's the decision maker, that sort of thing. And obviously you have to have the nuts and bolts of all that down. You have to know the policy limits, the excess carriers, all that have to be on board. I do think in this world of Zoom that we live in, even though we're probably all critical of younger lawyers for not talking to each other more and doing everything by email, I think Zoom has helped with mediations in terms of getting more of the senior people for insurance companies involved, that they don't have to come travel here. And so you do get more decision makers involved. I know when we started doing mediations years ago, I'd get a warm body from the defense, but the real decision maker was on the phone. So, I think that's one help with regard to the timing of it. We don't have to worry about that. Obviously, we talked about from the plaintiff standpoint, you need the medical bills. The defense needs to know what the medical bills are. You need to know the liens. You need to know the expenses. The defense might not need to know the expenses, but obviously, the plaintiff has to know the net amount they're going to get from a settlement. So, and that decision needs to be able to be made in the room with the plaintiff's attorney there. So,
Tom, you're absolutely right about that, because that injured plaintiff has one question based on each offer: what goes in my pocket? And when the plaintiff's counsel hasn't really sharpened the pencil and looked at, okay, here are the providers, maybe there's a hospital bill that's 6 years old that's been written off. Have they made an inquiry about whether they could settle that for pennies on the dollar? All of that pre-mediation work will help them answer the question from their client: what goes in my pocket? We've got just a couple of minutes left. Let me ask all of
Rob,
you. Yeah,
I would offer one additional point about the timing and having conversations with the other lawyer or lawyers in the case. And we've talked about it many times. It's come up today in the context of personal injury and what are the medical bills. And as a guy who did a lot of defense work in 37 years, we got to get the medical bills. We got to find out what the medicals are. And that on the defense side and lost wages has always been a huge component of what drives the calculation of the value of the case. I wonder how often it comes up these days with people who have mediated more than I have, whether there's an open disclosure. Well, we're not going to claim those medical bills. So in the defense side, people base their evaluation and have forever and probably will continue to base their evaluation based on the medical bills. But more and more often, those medical bills and costs aren't even going to be presented at a trial. And so I wonder how many times that comes up during mediation, if at all, and maybe the decision isn't always made that long before trial. But well, that's all well and good to share those things, but that's not going to be a topic of the value at trial or the verdict potential. Anyone in the room or Rob, if you have a comment?
Yeah, I just think that's all part of the discussion, Steve. That's part of, same thing where they say, well, the defendant's the prior incident's going to come into evidence or prior accident. You say, well, that's not going to be admissible, and argue about that. But yeah, I think you just need to know what each side's going to claim.
And I've had
Go ahead,
discussions
guys.
actually,
You have.
yes.
How often have you had maybe the plaintiff share that with you that, well, we're not going to claim any of these bills they're so worried about anyway?
I can think of one so far. There may have been two, but because we were close on the settlement and the plaintiff backed off on claiming those. Now, they may have decided to back off long before we got close, but we got close and that helped bridge the gap.
Fellas, this has been really great. Having your experience and sharing the ideas about both best practice in helping to resolve, but most importantly, the timeliness. All of us get cases at different stages still. There are still some of the federal judges who order mediation, frankly, too early, and the lawyers, for whatever reason, are afraid to write to the court and say, Judge, we really want to mediate, but we really could use 30 days so we could take the plaintiff's deposition, for example. So, one practice tip I would suggest is when you get the order of referral to mediation, and it truly is too early, if there's a key deposition or a key exchange of some written material that will provide the information so that both parties can have the decision-making ability. Lawyers, let's, contact the court and say, could the judges put this off for 30 days or 60 days? We would love to mediate, but we want to get to completing that discovery. Thank you all for sharing your time and your expertise and experience. Folks, we will get back together in about 9 minutes. Kelly, if you would stop the recording. Well, folks, another one of the areas that is new for us is to talk about collaborative problem solving. Many of us collaborate in things we do. And when we chatted a little bit about this program, this one came to mind. Last August, a new book came out, and I met the authors at a book unveiling. Rob Fersh, who is with us, and I'll chat about him in just a second, and Mariah Levison. That last name may ring a bell with some of you. Mariah is Mark Levison's daughter. Mark, a former president of the Bar Association of Metropolitan St. Louis and a partner at Lashley. Rob was the founder of an organization called Convergence, and it's Convergence Center for Policy Resolution. Back, if I'm not mistaken, Rob, that was 2009 thereabouts.
Yes.
You were the first CEO. Mariah is the current CEO. And folks, Rob's background is number one, a lawyer, worked on the Hill for various congressional committees, worked in the executive branch, and in some other roles. And last summer, wrote this book, From Conflict to Convergence, Coming Together to Solve Tough Problems. I read it. It was the subject of a book review column I did for the St. Louis Bar Journal last year. And it's something that I think resonates with all of us because of various issues that surround us every day. And I thought that we would bring this to you to talk about collaborative problem solving. The lawyers who are on this Zoom, perhaps in the family law area, have touched on the collaborative process. But Rob, introduce yourself more and tell us, how did you get into this?
Yeah. Well, thanks, Rob. Thanks for the opportunity to present. I hope this is of value to all those who are participating. You covered a bit. I actually, when I went to college, I went to the School of Industrial and Labor Relations at Cornell University. I actually thought I wanted to be a mediator, but I took a detour. I did go to law school at Boston University, and I moved to Washington to end poverty in America. That was my goal, my modest goal. And as I often say, I've had a huge impact. Things are a lot worse now. But I came to Washington very much as an advocate. I was a child of the 60s and 70s with lots of social issues being discussed. And I was taken by the notion that there are too many people in this land of plenty who didn't have enough to eat and to live on. So I threw myself into that and worked for 3 congressional committees and ran a national anti-hunger group. But inside of me, there was a cognitive dissonance going on because I was meeting people of great decency who actually wanted to solve the same problems I did, but had different solutions. And normally in Washington, you're set up simply to debate people. You know, here's the progressive, here's the conservative, go fight it out and we'll summarize your differences. What I found was that these people I kept meeting, many of whom now have joined the Convergence board, really authentically wanted to solve problems. And we had no place to actually talk through our ideas beyond a debate. So with having a mediator's heart, really, I decided that we needed a new capacity in Washington and now elsewhere, where people who disagreed on public issues, our main focus was on public issues, had a place to sit down and work things out. So I really went through a conversion from advocate to bridge builder. It took me about 11 years to incubate Convergence. And now we've been around for 16 years and we've had a couple of dozen successful projects helping people come together from at the national level especially, but also at the state and now the local level in terms of bringing together people who are stakeholders, who are interested parties in trying to solve an issue and bringing them together in a process of collaborative problem solving where we build trust and enter a dialogue that without fail has led to people finding significant areas of common ground on the tough issues we convene them around.
So I want to point out to our audience some of the written materials that we've included. We're not going to touch on them directly in our presentation, but I think it's really worth your time taking a look at them. There is a short pocket guide for collaborative problem solving. The cover and the first chapter of the book is included, including the table of contents that kind of give you a roadmap of the book and some of the secret sauce that the organization uses to resolve these significant public policy issues. There's also a couple of pages dealing with building blocks for resolution. There's a problem-solving process step approach. And Rob and Mariah wrote an article last summer, last July, 3 steps to finding agreement on America's toughest problems. So I recommend that reading material to you. And because this is such a rich topic, we wanted to provide that reference source and then go into this in a little more detail. So, Rob, the book is very much story driven, based on your experience and Mariah's experience in the organization, how powerfully they demonstrate the power of collaborative problem solving. I want to read a passage just to maybe provide some example, and it's an example that resonated with me, and then I would love for you to make some comments about that particular example. On one day in November 2006, during the lunch break of an all-day meeting, Carla Willis grabbed a moment to chat with Rob one-on-one. She said, "Rob, you have ruined my life. I came into this process thinking the AMA, American Medical Association, and I really had the right answers on how to provide healthcare coverage for all Americans. But for the last 2 years, I've been listening to thoughtful and well-meaning people with widely different perspectives who made points and arguments that never crossed my mind. I just can't see the world the way I used to." So, Rob, tell us, how did that conversation come to pass?
Yeah, thanks, Rob. And before I delve into that, let me just mention, because I know people on the call are attorneys, that a lot of our examples are coming out of the world of public policy and community problems, but we are hearing from business leaders, nonprofit leaders, academic leaders, and individuals that the skill sets that we lay out here are good for collaborative problem solving pretty much whenever there's multiple parties who are in disagreement. So I hope you'll find applicability to your daily lives. But this story is one of my favorite ones. You may recall that in the 1990s, Bill Clinton and especially Hillary Clinton proposed a major healthcare reform. It created a tremendous national interest and opposition, and basically their proposal went down in flames. And so a lot of the parties that opposed what the Clintons wanted to do really were quite chastened by that experience. And as Stuart Butler, who was with the Heritage Foundation, who participated in our process, said it was quite remarkable. He even got these people in the same room because they were already, war weary from fighting each other on the Clinton healthcare plan. And none of them had optimism that we could deal with the issue of having over 45 million Americans without healthcare coverage. And in fact, one of our participants said that for years, the issue of covering Americans on healthcare had been deadlocked because everyone's first position was their own beliefs and their own positions, and their second position was to keep the status quo. So as a newbie to this field, having made a conversion from advocate to bridge builder, I pitched this consumer leader on healthcare on the idea of bringing people together from across the spectrum to deal with this issue of covering upwards of 45 to 50 million people who didn't have health insurance. And luckily, he had just done a course at the program on negotiation at Harvard, and he was open to these ideas. And so we assembled about 30 people, including major leaders in pharmaceutical industry, hospitals, insurers, consumer groups. We had the U.S. Chamber of Commerce, we had unions and others. Again, a couple of dozen or more people we assembled. And it was a very high-level group, including the trade associations for the hospitals and for the insurers. And we ended up meeting 12 times over 2 years, usually 2 days at a time, to try to define what we wanted to do, which ended up having the goal of covering as many people as quickly as possible. There was no finger on the scale that had to be single payer or all private. And we engaged them in a conversation on how to meet each other's needs in terms of where they stood on policy so we could make progress. And again, we didn't call for universal coverage. We called for covering as many people as quickly as possible. So Carla Willis, who was the chief economist at the American Medical Association at the time, was a participant. And in the beginning, she was quite outspoken. She was the president of the AMA, often attended as well, but she was really the one who had put together a lot of the policy. And she very graciously but passionately put forward the AMA's views early on. And then there was a lot of discussion of issues. And then I noticed that Carla had gotten quieter and quieter as the time went on, and didn't know exactly what was happening. And then finally, what Rob just read, it was at the 11th meeting of the group out of 12. It was the day in which it looked like we would cut the deal on how to cover the uninsured in a way that worked for everybody. And then she did approach me and said, "You have ruined my life because I just can't see the world the way I used to." And so, when she told me, "You have ruined my life," I said to her, "Yeah, I hear that all the time. What's what's your particular reason?" I have 4 kids, so I do hear that all the time. And she said, it's really because I just can't see the world the same way. That I came into the room thinking we had the answers, and now I've been around so many people who are wise and smart. And so she did join in the final answers that we came together. She did not have to relinquish or give up any principles. Everything was consistent with the AMA ideas, and some other ideas were included. But she was able to move off a sort of hard and fast, well-thought position. And I say that's the bottom line for me about collaborative problem solving. It's not to have anyone have to compromise any major principles, but it's to create some space for people to expand their worldviews and potentially take other views into account. And in most instances, we find come up with answers that were better than anyone came to the table with. So that's what that process was. And I think Carl is an indication of what can happen to people who have their minds open to new ideas and begin to internalize based on actually hearing from people they begin to like and trust. They begin to internalize other people's ideas and incorporate them into their own. And that's really a very central idea of how you do collaborative problem solving, is to get people to focus on their underlying interests, not so much on their positions, as Getting to Yes taught us, and to then have conversations about how to meet each other's mutual interests.
So another part of the book kind of sets the stage for the secret sauce behind your process. I thought I'd like to read just another small bit and then ask you to share a little bit about what that means and your process. It's the second chapter, so it's right after what we actually provided the group, but it's how to reach convergence. And I'm just going to read this first paragraph. What would happen if more of us expanded our problem-solving skill set, gaining stronger capability in listening, learning, and inviting other voices to inform and challenge our worldview? What if we cultivated the ability to identify our own and each other's core needs and the capacity to then develop solutions to integrate the essential needs of all sides so that our solutions are more effective and more widely supportable over the long term? Imagine how our world would improve if we could create spaces where people, including those who see themselves as adversaries, can openly and safely talk, develop trust, generate more agreeable, more enduring, and wiser solutions. As idealistic as this might sound, these kinds of shifts are possible. So, Rob, that's kind of an introduction to that, just the second chapter. Share a little bit more about how the process works and how you've worked within it.
Sure. Thanks, Rob. And let me do sort of an outline and then we can dig in deeper because it's a lot to talk about. But basically, this is very much a people-oriented approach. And in my view, when you can open hearts in new ways, then often the minds will follow. So what makes our approach somewhat different than a lot of policy shops in Washington is that we first assemble all the people who have a stake in the outcome as wide a group as we can bring in terms of their differences, so long as there's a shared goal. And so that goal can be somewhat general, like how to improve economic mobility in the United States, or how to make sure people returning to society from prison can thrive. But as long as people have a shared goal, we will convene a wide range of people and bring them into dialogue. But we never start by discussing their particular positions. We spend time having people get to know each other. We find it powerful to have people hear about each other's values. Usually values are shared. People disagree on how to implement their values and so on, but usually people want the same things in life, whether it's more economic opportunity or better healthcare and so on. And so we then convene these people in a process where we spend some time building trust, and identifying shared values, and having people get to know each other. In our case, we may get to this. We've had to go to Zoom during the pandemic, but very important to us was oftentimes having 2-day meetings where people broke bread and formed relationships. So the process is very much about identifying a problem and framing it in a way that is agreed upon, that the goals are agreed upon, figuring out who needs to talk to who has the collective knowledge, experience, and influence that if they came to a table and found common ground, could move the ball forward. And then convening people in a way, often we use experienced facilitators, or some people on our staff are now capable of it. Mariah Levison is a very skilled facilitator and does some of that work herself. And we convene people in a respectful dialogue. Normally, we develop some principles that will guide the discussion. So, for instance, when we did a project on economic mobility, we knew a hot button issue with the chamber and other businesses at the table, including small businesses, would be minimum wage. And we couldn't get agreement on minimum wage because differences there. But the group had agreed on a principle that said, basically, if you work full time, you shouldn't be living in poverty. So that was a principle to guide it. And that meant that, okay, if you bought into that principle, if you're not going to raise the minimum wage for some people, where does that lead you? And it led us into a discussion of certain other supports like the child tax credit, the earned income tax credit, other means in which people who are working full time at least have a decent income. So it's very important to have principles to guide the discussion. And then we engage in a process of exchange where people are asked to share their interests and to suggest options for people to consider. But as we say, it's only options that consider other people's needs that are going to work out in the long run. So having built trust amongst the people and people being aware of where the sort of the pressure points are for other people or the limits of what they can do, we enter into an exploration of ideas that collectively the group agrees are better than the status quo, and in some cases very exciting and new areas of commonality that they find. So we engage in a respectful dialogue. It can be anywhere from 3 months to 2 years, depending on how tricky the issue is. And then we ask people to eventually sign on to an agreement and then make commitments to implement it. We at Convergence stay neutral. We never actually endorse any of the ideas of our groups, but we'll facilitate the people who are the powers that be on these issues to then go out and try to make a difference based upon what they propose. So that's sort of the process in a nutshell. There's a lot more to say about mindsets, about why you would want, why collaborative problem solving would make sense to you when you begin to recognize that no one person or ideology has all the answers. No one person has all the truth, that virtually everybody has something to add to what might be a great solution. And that at some level, you have a preference to actually get along with people as opposed simply to fight with them, at least to give people the benefit of the doubt and hope that they will, in doing so, you'll find ways to work together. And later on, I'll talk about the radiating impacts that our projects have had in terms of how people stay in relationship and work together differently over time, which I think applies to people in the law field who are dealing with either family businesses or family squabbles or ongoing business interests and so on. But let me pause there, Robin.
Yeah. You said a couple of words that did strike me, and that was that you broke bread as part of that process. And there's a part of the book that I thought was so interesting. Those of you who are here will remember, who are football fans, back in 2011, there was a lockout. And it happened where the players were locked out of training camp, and both sides, the Players Association and the league, were just locked into positions and no one was talking. And what ended up happening is Arthur Boylan was appointed as the mediator. But before mediating, what occurred was Roger Goodell and DeMaurice Smith, who was the head of the Players Association at the time, sat down at a meal and got to know one another, as opposed to press releases on Fifth Avenue in New York. And it struck me, for our universe as lawyers, sometimes whether it's litigation or negotiating transactions, or in our roles, whether we are on for-profit boards, nonprofit boards, involved with community organizations, people get locked into positions. And here, I will quote Melvin Kennedy from our last program when he said, quote, "You need to like the person you're dealing with." And sometimes it's let's go grab a cup of coffee. You know, maybe you're walking back from the courthouse after a hearing on a motion to compel or whatever. Sit down and at the Starbucks and talk about, gosh, well, what do you really need to have enough information that really talk about this? And I thought that was so interesting to me. And Rob, it's not just perhaps lawyer to lawyer. Think about the relationships that we have. So it's first lawyer and your client, getting to know one another, getting to kind of peel the onion to understand what are the real interests, wants, and needs of the client. So that's maybe the first spot. The lawyer to lawyer relationship, where it's getting to know the other lawyer when you've had some cases with them. I find that when lawyers know one another, they have a history and they have a level of trust, usually, especially in our practice area here in the St. Louis area, where we're so fortunate to have a collegial bar. Not necessarily the case in other parts of the country. But also those who are mediating, between the mediator and the lawyer, getting to know the lawyer, as the last group talked about, wanting to have that phone conversation with the lawyer before mediation to get to know a little bit, perhaps about them, if you haven't mediated with them, and certainly about the client. And then during mediation, that relationship between the mediator and the client. Because as the first presenter this morning talked about having rapport, and it happens in that caucus between lawyer and client. And I like to talk about, it's that first caucus where there's a deposit into our trust bank between mediator and client. And perhaps that happens early morning, mid-morning, but by the afternoon, we have to make a withdrawal from that trust bank where they're having to truly trust us. And it's part of a process. So I see that those relationships are so important, and having a better understanding of where people are coming from. And Rob, one thing that I know is in the book that's critical, and that is that it takes time.
Yeah.
And that we should take our time. You want to talk a little bit about how this takes time?
Yeah, sure, Rob. And I'd like to fill in with a couple of brief stories as well.
Sure.
You said, but look, you may not always in your lives have the luxury of time, but we find that investing the time to build a relationship of trust allows you to go much faster later, because people don't treat each other the same way when they actually like each other. When a woman who's been at war with the Chamber of Commerce discovers that her counterpart and she both root for the New York Giants football team, they have something to talk about, and they have a relationship that's not only about their professional differences. So they have a certain bond they develop, and a trust and a liking for each other in various ways. So let me mention two other things. So Rob, you're right that, the key to this is to develop trust, and it does take time to build the relationships, and not everyone has that luxury, but we invest that time because I say in the long run, it does save us time. So one example of where trust occurred not at a breaking bread, and I want to give you another one about breaking bread, was the original project we did on healthcare that we talked about earlier. And I remember because we asked people to go around the room, and it was very tense. These people had been at war with each other for years. We asked people why they were there, why they cared about the issue of healthcare coverage. And a lot of the groups in the beginning, some of them were a little more progressive, pulled their punches. Normally they stood for universal healthcare or single payers and so on. But they knew that there were a lot of business groups, and the Heritage Foundation and the Chamber of Commerce were there. And they just said, well, we think it's really important to have healthcare coverage. And everybody tiptoed around, universal coverage and so on. And we got about 2/3 around the room. And the person that a lot of people in the room viewed with the most trepidation was from the Heritage Foundation. I assume most people are familiar with them. They're a very conservative think tank in Washington. At the time, they were not as, in some ways, radical as they are now. They are the backers of Project 2025, whether you like that or not. They are much more strident than they were then. But Heritage had the reputation as being very, very conservative and not particularly empathetic to low-income people. But the representative from Heritage, who was a Brit, who'd been here for about 3 decades at that point, again, we're going around the room, and 2/3 around the room, he said basically this. He said, I don't know about the rest of you, but I'm from Great Britain, and I believe in universal healthcare coverage. And there was almost a gasp in the room to have a guy who they thought was going to be the biggest obstacle call for what nobody had called for before. He went on to say, I think I probably favor more private sector methods to deal with it than most of you in the room, but let's have that conversation. So just having someone speak from the heart about the fact that he believed in healthcare coverage, and he sort of disarmed the distrust people have in that moment, I felt the entire room shifted. But let me also tell you one other story, if I can, about the power of breaking bread. We did a project on the reentry of people from prison into society. We called it Reentry Ready. And we assembled a wide array of groups. In fact, 1/3 of the people were formerly incarcerated. We had people from academia, we had advocacy groups, we had former prison wardens, we had people who worked in, as guards in prisons, we had think tanks on the left and right, you name it, we had a full array. And we had a gentleman who was a senior executive in the largest private prison system in the country. The first day of that meeting, which I was at, was as tense as any day I've ever experienced, because there really was a lot of distrust, particularly toward the private prison guy. In fact, we had an academic from Georgetown who had written a book on the American prison system, himself an attorney. He'd gone back to law school because a friend of him had been wrongfully convicted of a murder, and he actually got his friend exonerated. But he then got interested in the prison system, and he wrote a book critical of the American prison system writ large, but especially private prisons. And of course, the normal view of private prisons amongst its critics is that, they're profiting at the suffering of more and more people, and there's every incentive for them to have more people in jail for longer periods. So it was a tense first day. The reason was a rumor that someone hid the nameplate of the private prison guy. So what did we do? Of course, we sat the private prison guy and the academic together at dinner. And just before he came in the room, the academic saw who he was supposed to sit next to. He left the room, texted his wife and said, you can't believe who they're going to sit me next to. This is not going to go well. But he went in and sat down, and for a while they didn't talk. They kind of talked to the people on either side of him, but then they started a chat. And the academic learned that the private prison guy shared his goals, that he wanted people to get out of prison and thrive, and pointed out that his company, CoreCivic, had in fact started a bunch of reentry programs. So they had profit centers that came from helping people get back into society more effectively. So that began to build a little bit of a bridge. And they began to talk about each other's needs and ideas. And, the academics still had problems with private prisons, and the private prisons felt like they weren't getting the respect. But let me just fast forward. Today, these two gentlemen are working together to reform prison practices. In fact, Mark Howard had a bunch of ideas that he wanted to move forward, but he was hitting a lot of red tape from the public prisons. So he talked to Darren Swenson, who is the CoreCivic guy, and Darren said, yeah, let's go ahead, let's try them out. And because he could cut through the red tape, they've been working together on these issues now for a number of years. So the point is that simply providing people opportunities to see each other as full human beings, to hear each other out, to not assume the worst about people without knowing what their underlying motives and goals are. If you can engage in processes and allow people to go deeper about how they know each other, normally some level of respect and affection arises. I will say I was in one project where there was a fellow on the same side as another fellow, but he hated this other guy. And after 2 years of respectful interchange, I expected maybe that would change, but no, he still hated him at the end. So it's not a fail-safe approach to create warm human relationships. But by and large, in our room, usually we create a culture of friendship and respect and communication that was, for many people, unprecedented.
So Rob, you touched on it earlier. We're now 5 years and a couple of months since COVID started, and we're all now used to sitting in webinars, hearings, motions, couple of cases for me, arbitrations, where we're on Zoom or WebEx. So during that time, or perhaps since that beginning of COVID, what's your take about how to establish that rapport, that relationship on Zoom, and how does it compare in your mind to when we're in person?
Yeah, thanks, Rob. You know, I've been surprised that Zoom has been not that big an impediment for us to get some things done on projects, but it is tougher when you don't have real eye contact with people, when you don't break bread, when you don't have an opportunity to, on a break, go to the water cooler or the coffee line and engage with each other or have dinner. It's harder for people to get to know each other. So sometimes, we'll break up the Zoom group into a smaller group, subgroups. Sometimes there's subgroups that actually meet on substantive issues in the meantime, often with facilitation. And having smaller groups helps you begin to understand each other better. So I would say it's not optimal given the nature of the world today and given, frankly, a lot of expenses that are hard to cover. We now do usually a hybrid. We try to get people at least to a day or two in-person meeting to start, at least get some bonds formed. And then sometimes we then do intermix some Zoom meetings with back to in-person whenever possible. So I think it's not as effective to build trust more quickly or to go as deeply. But at a time when people's time is limited and they don't have to travel and they can get on a Zoom call maybe a little more often if for a shorter duration, there are some compensating features to be on Zoom. But by and large, I'm a huge believer in personal contact, reading body language, looking in people's eyes and understanding them. It's very hard to really read people, I think, on Zoom. So that's my take on it. And I think, again, the dinner we had with Mark and Darren over the prison system wouldn't have been possible if the whole thing had been on Zoom. And I don't think they would have ever gotten to where they got.
So as I think back the past 5 years and how we've evolved our use of the technology for mediation, I think all of us will agree that there's nothing like walking into a conference room, especially when it is a plaintiff in a personal injury case, a family involved in medical negligence, former employee in an employment discrimination case, harassment, etc., to be able to walk in and shake their hand and to look at them in the eye and talk about the process and sit down in the morning with a cup of coffee and take the time and ask, how are they doing? Can we do it by Zoom? Yes. You don't necessarily see them in the kitchen where you can help them with the coffee maker or point out there's some chocolate in the afternoon. But what's so interesting to me is that our settlement rates are almost identical, all in person or in person with, let's say, a corporate rep or insurance rep by Zoom versus all Zoom. They're almost identical within 1 or 2 percentage points. So it is still effective. Maybe it just feels better because you can shake the hand of someone. And also, we're better now than we were 5 years ago. It used to be, a plaintiff would hook on by Zoom. They wouldn't be with their plaintiff's lawyer, and they'd be on their phone, and they'd put the phone down, and you would see the ceiling fan. And now we're pretty much trying to see them. And I think the plaintiff's lawyers do understand having them sitting next to them in the conference room, as I had on Wednesday, really does help the process. So a couple things that I thought about is how collaboration and having relationships works with some of the practice areas and areas of dispute that we see, whether in litigation, in mediation. And some of them have an ongoing relationship component. It could be in the family law context where there are kids, right? It could be in a small business where there's a dispute between partners in that business. And it potentially could be in some other areas certainly in employment, where you're trying to work on an issue with a current employee and the organization. So I can see how working with those groups can be so helpful. And as we mentioned before, sometimes it's a board of directors, and sometimes it's a community organization board. And many of us on this Zoom call participate and volunteer in those organizations, and issues come up. And instead of perhaps locking in positions, maybe it's worth having that cup of coffee before a board meeting. Just seems to come to mind. A lot of what we see, Rob, a majority of what we see are the one-off issues. And I'm going to guess that the areas that you deal with are not exactly like that. These are broader policy type disputes. But I thought it might be worthwhile to kick around a couple of examples that I've seen in my mediation practice, where it's a premises liability claim, where it is an auto accident, where it's perhaps some type of one-off accident or incident. For example, I mediate for a national, actually international big box company. And these are one-off. Someone fell in a parking lot, someone was hit by a product that fell from a shelf and hit them in the head, or whatever you can dream of, I've seen. But what changes the dynamic in the mediations, and by the way, speaking of our last session where we talked about perhaps mediating early, most of those cases are pre-suit mediations. What makes it effective is the defense lawyer looking at the claimant and saying, this is who I am. Thank you for accepting our invitation to mediate this dispute. We appreciate you being here. We are sorry that as a customer, you had any problem at our store, and we are going to work hard to resolve your claim today. And there's always some humor. This lawyer will say, oh, your lawyer sitting next to you is working hard, and I'm going to work hard, and we're going to make Litz work a little harder, ha, 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 but we're going to try to resolve your claim. So what might have been a slip and fall in a store all of a sudden has a different dynamic, that they're looking towards this future. And I think that's an important part, because you can't establish that rapport in 30 seconds, but I think it plants the seed. And often right after that joint session, I sit with the plaintiff and plaintiff's counsel, and the plaintiff's lawyer will look and say, Rob, what just happened? I've never had that happen. And I think it's so effective from the defense side. Another example that we used in the textbook by Folberg for the mediation course at WashU had an example where a freshman attending MIT as part of a like Greek week frat event, drank too much alcohol, and unfortunately died. And none of us can even imagine what the parents of that child were thinking about and going through. And a lawsuit, of course, was filed, and the lawyers for MIT, as this article outlined, were digging in. We have this defense and we've got that defense. But what they all decided is that this should be mediated. And what the mediator did is he sat down with just the lawyers. And they all had dinner. And they talked about process, so that the mediator and the lawyers got together and kind of planned out how it would work, where the mediation would take place, which was outside of Buffalo, New York, near the parents, and at a location where people couldn't just stand up and walk out. And they brought the president of MIT and, of course, lawyers there for the mediation process. And because of the work that was done in advance of the mediation, the lawyers had gotten to know one another. And an important piece to all of this was that the president of the university apologized to the parents right off the bat. And the mother couldn't still wrap her head around it, was just so angry. And at one point, what was quoted in the article by someone who was actually present is the husband said, "Dear, did you hear the man? He just apologized." And they got past that point to start looking forward instead of looking at the past. And what did they do? Yes, there was an amount of money that had to be negotiated. But what was so important were the other elements of the settlement. There was a scholarship in the son's name. There was an annual lecture in the son's name, and that the family would be involved in the selection of that student who would qualify and who would speak at the annual program. The last one I'll mention was a wrongful death case I did a couple of years ago. And it became obvious that at first, what are we doing? We're talking money. That's it. And the parties were miles apart. And then there was the apology from the CEO. And it was a case where an older woman who had COVID, so it was in the last 5 years, needed to go from a rehab facility to a hospital because her symptoms were getting worse. So to do that, an ambulance was called, and the ambulance, right before they were going to get to the ambulance itself coming out of the rehab place, the gurney tips. Plaintiff falls, breaks a rib. Shortly thereafter, in the hospital, the patient passes away. So we're talking money, 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 money. And then at some point, the CEO of the defendant apologized. And then at some point, the family says, you know what's really important for us? We want to make sure this never happens again. Do you all do trainings for your people? And the answer was yes. Well, we do regular trainings twice a year, all staff. We'd like for you to amend your training program. And we would like for you, if you would, provide a copy of the draft of that training so we could review it and comment on it. That was agreed to, and all of a sudden, we had a deal on the money. It wasn't for as much as the plaintiff was seeking, but it just took a little bit of unfolding for folks to get to know one another. The apology was so powerful, and we were looking at, I won't say non-economic, but these other opportunities to be creative because of the relationship that happened during the mediation. So even with one-off situations, we find that this collaboration can work. And those are just a couple that have come to mind. Rob, let me ask you this. How do you think that about the impact of your work. Ultimately, how do you know you're making a difference?
Yeah, thanks, Rob. Yeah, we don't always know. I mean, so there's different ways to measure it. And let me also say that I appreciate you bringing this home for this audience. And I think everybody can use these processes, even if you're in a law firm. Let's say you have disagreements about the future direction of the law firm, or you're a business leader doing strategic planning. The more inclusive you are about who gets a voice to be heard, if they have something to offer, the more likely that people will buy into the solutions and over time work better in that setting. So for us, impact is, first of all, do we at least come up with ideas that deal with ameliorating whatever situation we were dealing with, which is, whether it's too many people living in poverty, or whether it's failure of the prison system, or whether it's the federal budget process. We did a project on that about how to avoid all those government shutdowns and so on. So if we come up with ideas, we have proposals that are still pending in Congress for the reform of long-term care, which is the non-healthcare supports and services for elderly and disabled people. So first and foremost, we want to try to alleviate whatever kind of human suffering or deal with any human problems there are. But beyond that, it's very important for us to help contribute to lowering the temperature of differences. And the kinds of people we convene are often powerful people. We have a very mixed group. Often we have also people with lived experience, say, been through poverty and so on. But to the extent we can get people to talk to each other differently in our processes, it may carry over and lead to less stridency in the public arena in terms of how people talk to each other. And in the long run, we find that people then work together differently and better, even if it's not on the big solution they came up with. So I think we measure our impact by were we able to address the issues well and get people behind some answers? Were we able to form relationships of trust so these people, many of whom need to work together over time, people in the healthcare field are still working together on issues. Did they form relationships where they work together over time? And did we contribute to a culture of greater collaboration, understanding, and respect for differences? And I think those are the major areas we look at. We've had success in that now. So in several instances, people who we've convened once have asked us to reconvene them again because they had such a positive experience. So it's all part of it. I'll just tell one other thing about, there's a woman at our table on economic mobility who was a big critic of Walmart. This is about a decade ago for their employment practices. And she had vowed never to go to Arkansas to the Walmart headquarters. So of course we sat her with a woman from Walmart and they hit it off. And at the end, the woman from Walmart took a bunch of ideas from her process. And the woman who vowed never to go to Bentonville, Arkansas, ended up going to Bentonville because she formed a relationship with this wonderful woman from Walmart who shared the goals that this advocate had for people. So there are all sorts of breakthroughs that occur, and then they have what we call radiating lasting impacts because you formed a relationship that goes beyond discussion of the policies and issues that are at stake. And that's, I think, key to what Rob was trying to say about how that can apply to each of us in our own worlds and in our legal practices.
Rob, great ideas. And you pointed out within our law firms, right? These things happen. There's issues that come up. I will recommend highly to all of you for the various ways that we see dispute and conflict, from conflict to convergence, coming together to solve tough problems. A wonderful read, a quick read. And as you read it, you're going to say, oh, of course that makes sense. Or, yeah, I see this every day in whether it's with a nonprofit, with clients, with opposing counsel. And anyway, a wonderful book. And thanks to you and to Mariah for writing that. And Rob, thank you so much for participating in our best practice program today.
Thanks to you, Rob, for inviting me and for facilitating this. And I hope people found this to be of value. And if anyone wants to be in touch with me, I'm sure we can happy to provide contact information to the extent any of you are interested. We're interested in getting the word out about the book and to other audiences, legal and non-legal. We're particularly focusing on getting to young people, having them develop mindsets so they become collaborative leaders and know how to relate to each other better. And we have specific examples of success in that arena. So please, if anyone takes an interest in the book or the work of Convergence, feel free to be in touch with me. But thank you for this opportunity.
Great, thanks. So folks, we are going to well, our next segment is part of our Legal Legend series. The Legal Legend series started 2 years ago, when Debbie Champion interviewed my dad, who was a retired circuit judge in St. Louis County. Then last year, John Grimm interviewed Judge Stephen Limbaugh Sr. And what a fitting next move for us to move again into someone who is really part of the foundation of mediation in St. Louis, and that's Mike Geigerman. And Mike has been mediating, as we'll hear in just a minute, for 40 years. 40 years ago, USA&M started. We merged into Miles Mediation in November of 23. We started using their name in March of this year. And Mike has been the heart and soul of USA&M and now Miles. Mike was really the go-to person, the first outside mediator for USA&M, completing now north or close to 5,000 mediations. The one thing I will share with you is he's both a mentor to those of us in the ADR community, mediators, arbitrators, but also as a mentor for lawyers, plaintiff lawyers, defense lawyers, clients, insurance representatives, helping them resolve disputes of every shape and size that's imaginable. Mike has been there. We still will chat about certain things happening in each other's cases because we're learning every day. And after almost 5,000 mediations, he's still seeing things for the first time. And it's just absolutely wonderful to have him talk about the past and the present and future, most importantly, the future of mediation. Mike is active mediating with Miles, doing all kinds of cases. And it was a joy to actually watch the video just a few minutes that was taped earlier this week with Professor Karen Tokarz, who will be moderating the interview with Mike. Karen, a longtime friend and friend of USA&M and Miles, heading up the negotiation and dispute resolution program at Washington U. I think she'll mention in her remarks how we have had a partnership between the school and those of us here in our office for a couple of decades, many of us having taught or now still teaching at the law school in whether it be negotiation, mediation, or arbitration courses. I want to also thank Bill Matthews at WashU. Bill was so helpful in taking the raw recording of that interview with Karen and Mike and trimming down what we needed to have done. And Bill, thank you again for your help with that. I'm going to share my screen and give me just a second to get this started. And this should wrap up by 1:10, and then we'll take a short break at that point, talk then again about environmental disputes.
I need my reading glasses. I didn't have them. I am delighted today to moderate a conversation with my friend, my colleague, my mentor, Mike Geigerman, whom most of you know is truly a pioneer and a legend in the field of mediation and dispute resolution since joining USA&M in 1986, now Miles Mediation, and his almost 5,000 mediations over the past 40 years. I've had the privilege of working with Mike, learning from Mike, collaborating with Mike, and following in his footsteps for over 3 decades. I'm going to share a few things about Mike, starting with how I know him. Then eventually I'm going to throw Mike several questions so that he can share with us his expertise about the world of mediation. As Rob mentioned, I'm a professor at Washington University Law School, where I've taught forever, and I direct the negotiation and dispute resolution program. Mike has worked with me in so many ways over the years. First, Mike has worked with me in developing our dispute resolution curriculum from the beginning, including the required first-year negotiation course, one of few in the country, and our huge upper-class dispute resolution curriculum, which began with Mike developing and teaching a course on mediation in 2000, and now includes 20 domestic and international dispute resolution courses taught by local mediators, including many of you who are in the Zoom session today. Second, Mike worked with me on developing our community justice and mediation clinic, which began with students providing free mediations every Friday morning in city eviction court, and then progressing during the 2008 mortgage foreclosure crisis and later moving to St. Louis County Circuit Court. Eventually, it evolved into the St. Louis Mediation Project, which we'll talk about a little bit more. But Mike volunteered from the very beginning. Every week he was there in court, which he still does, and along with several other USA&M Miles volunteers who co-mediate and mentor the clinic students. And we're going to talk a little bit more about it later. Mike also worked with me on developing our negotiation and dispute resolution LLM program. A lot of those students are foreign students, and Mike has mentored countless students through courses and through observations of him down at USA&M, now Miles. In between all of that, I've worked with and watched Mike work diligently on countless state and federal initiatives over the years. I mentioned all of these wonderful things that I know about Mike because I have seen Mike selflessly contribute every step of the way, every year after year, not just to me, but to so many for the betterment of the St. Louis community and the bigger world of mediation and dispute resolution. Mike hates to be applauded, but he is indeed a pioneer and a super legal legend. I'm going to shift now and raise some questions to Mike about his interest and his role in mediation on the ground at local, state, and federal levels over the past 4 years. Then I'll ask him to share with us his thoughts about what's happening now and what are the tidal wave changes that are in the works in the world of mediation at all different levels. And I'm going to give 3 quick examples before turning this over to Mike of tidal wave changes that we will dig into much deeper throughout this presentation. The first tidal wave is mediation and litigation. Both Mike and I served on the initial Eastern District ADR committee since it started in 2000, along with fine folks at the very beginning, Jerry Dekemper, Larry Frankel, Judge Stanley Grimm, Judge Shaw, Judge Nose, Judge Mummer, and Judge Simple, when we had no certified federal mediators, no uniform mediation orders, and mediations in the federal courts were very far and few between. Today, that situation has, as we know, has changed dramatically, perhaps even more than some realize. According to the data that we just received from the court, which may or may not surprise some of you, but believe it or not, in 2024, with 17 total sitting judges here in the Eastern District,
What are they talking
those judges heard
Geigerman.
6 total.
Oh, okay.
6, with 300 court-ordered mediations, over half of which settled. Second tidal wave that's occurring is the teaching for admission to the bar and the acceptance of mediation and dispute resolution as a fundamental lawyering skill. The upcoming bar exam, referred to as the next gen bar exam, which goes into effect in summer of 2026, now includes testing on 7 lawyering practice skills, including negotiation and dispute resolution, in addition to a reduced number of the traditional black letter law doctrinal areas.
I didn't get a baby shower.
More of a dispute resolution, since all of us went to law school. The third tidal wave, all around us, all of you know, is the massive growth in online dispute resolution and AI. This is the world in which we live and moving. Now, I'm going to start throwing some questions at Mike to get his unique insights from his 40 years of experience about how we got to where we are and where we're headed in the evolution. So, Mike, share with us, why did you start mediating? Why did you start with USA&M in 1986, which has grown from 3 to 38 mediators over the years? And what have you learned from your almost 5,000, hard to believe, 5,000 mediations? Mike.
Karen, thank you for those kind and generous words. I want to tell you all that are listening, Karen and I did bond initially over our common interest in mediation, but I've clung to her now because I want to have her share some of her intellect, enthusiasm, energy, kindness, caring, and compassion and treatment of everyone, especially the students, her friends, and most for her, I think most importantly, those less fortunate. Not to mention, she is the teacher I always wanted to be. Her door is always open. Her heart is always in the right place. And you all should know that all those things that we mentioned together is just a small thread of the great work that she does for the community, for the students, for everyone. And as she said it, for the greater good of all. I have to tell you, Karen is someone you should know. She is someone I admire, and I consider myself blessed to have her as a friend.
And you're going to tell us, why did you start mediating?
Okay, I will do that now. Well, it was 1985, and I was representing a young adult woman who suffered from juvenile diabetes. And she was injured in an automobile accident, and I represented her. Bob Crow, who I'll mention more in a minute, was the mediator. And the fix was that her leg pain that she was having was a result of her juvenile diabetes. And this was very distressing to her, to say the least. However, the defense finally came around at the mediation and offered a reasonable amount, and we did settle the case. Now, the defense didn't use the diabetes as a bludgeon, or at least Bob Crow had the good common sense not to use it and not to bring it up in depth. The case settled. She felt vindicated. And also, more importantly, she felt validated. She celebrated, but unfortunately, shortly after that, she died, and her life was all too unfortunately cut short. For me, and obviously for her, it was a life-changing event, and one that really showed me the power of mediation. And that's when I determined that I did want to become a mediator. And I've been fortunate, and I've been blessed, and I've been lucky that I've been able to mediate since that time. And it's almost 40 years. You also, go ahead.
I was going to say, what about this phenomenon at USA&M, this collaborative of multiple mediators that I don't think existed very much back then?
Bob Crow was the only game in town, and I was his first outside mediator. At that time, USA&M was a franchise operation, and Bob had the franchise here in St. Louis. And I was able, because I pestered him, I was able to become his first outside mediator. I was trained by some gentlemen out of, Portland, Oregon. There were a couple of judges, I'm sorry, I can't remember their names, who also did it. They also wanted it, like Bob, wanted this to be a retirement income. Well, like so many are doing it now. I saw myself as doing it for my future. Right after this, I had bypass surgery, and we adopted my son. And this was time to think of alternative careers. And so I moved into mediation, and I found myself fortunate enough to really be the first that was out soliciting civil mediation. Bob had the office space, the facilities, so it was a natural fit. And if I didn't say it, Bob didn't particularly like to be a mediator. You know, so it worked out real well for both of us. And that's why I got here, because USA&M was the only game in town, and it grew to where it is now. That it's actually been bought out by Miles, which was a good thing for everybody, the clients, the mediators, and the staff. So it's been a very good thing. You also asked me what I've learned.
Yeah, is it too much to say, what did you learn from
Nothing.
5,000? I mean, there must have been stages as you went along. Now I understand this, or now I understand this, or now I understand this, or can you
It's easier to
highlight any stages or
well,
points of learning?
I think it's like every new mediator, you know nothing. You have this script that you were given
Right.
that you're supposed to use,
Right.
5 questions that you can always use.
Right.
Those questions didn't come up. That there was always a conversation taking place. But here's what I know today, and I wish I had been as smart then. I wish I knew as much then as I know now. You need to listen first. You need to trust people, and you need to let those people be heard. They deserve to be heard, and they also deserve to be respected. And the other thing is people are basically nice, Karen. Some more than others. And they all come in diminished in some way, whether it's an emotional, physical, psychological, combination of all of the above, economic harms. We have all these harms. That's just the plaintiff. I have to tell you, you also have this dynamic with the attorneys, with the adjusters, with the family members, and they all come in, and some of them are disinterested, antagonistic, sympathetic, but they all have stories to tell, and you need to listen because they deserve that. Many of the people are survivors, all right? But I've found that more are thrivers. They move beyond the initial incident and seek to return to their prior state of well-being, which is gratifying. Excuse me, choked up with emotion already. All of these people need to be heard, and I really enjoy, and I guess that's the most important. I enjoy what I do. Okay,
That's great.
This human dimension, the interplay of all of these things is challenging, it's rewarding, it's usually enjoyable in the sense that it's fulfilling. But here's what I do know. It's true, I do suffer from spousal deafness, but I wear my hearing aids at the mediation. And I'll tell you what I know. I do what my students taught me, those wonderful WashU law students, which were always a blessing. They would come and observe the mediations. I'm gonna let you on the biggest secret in mediation in those students. People behave better when there's students there. That's why they're always welcome. But I want to tell you, I do what my students have always suggested, authentic listening, which is listen first, think second, think third, respond, wash and repeat.
And there are certainly those who suggest, almost simplistically, that one of the reasons for the growth of mediation and people embracing mediation is that people want to be heard. And for better or worse, you don't get as much of that, neither party gets as much of that during litigation, during a trial, as you do in a mediation. And people
I don't know.
need that.
Well, here's why I always meet with the parties alone first, whether or not they're going to come together. Everybody knows about the trials and tribulations of the joint session. But if you don't get a chance to hear them alone at first, you may never get the chance to hear them at all.
And they don't get to feel heard.
And they all have great stories.
Yeah.
Some are more interesting than others, but they're all different.
Right.
And that's
Important.
yeah, it's I call it legal gossip. And it's really, but it is.
We won't tell anybody.
Okay, it's not true. It's all good. That's my story. I'm sticking to it.
Okay, I know there's much more to it, but we're gonna try to transition to PowerPoint.
Right.
and talk about some aspects of mediation initially, just to give us, if you would, a little bit of a overview. Mike, you're going to talk a little bit about what we're going to cover today. We're going to touch base and look at what's going on in the evolution of mediation and dispute resolution.
Well, what we're going to cover today is simply this. We're going to talk about the past and the present and how we got to the present in mediation.
Right.
And then we're going to give you some thoughts, not guaranteed, but thoughts about where mediation is headed. It'll involve the non-technological aspects and certainly involve technology, AI, and online, and we'll cover all of that. What we're also going to do is not pretend that we're experts in the area of technology, and we're not going to talk about ethics. That's for a later module. Marianne Wymore is going to be doing that, and we'll let her cover that area, which is in itself a big deal, so I encourage you to listen to her. But you had some more questions you wanted to ask me.
Well, go ahead if you would and move to the past, present, future. There's some of that, I think, that's a little bit straightforward. There's been an acceptance of this and organizations like yours and others starting to get rolling, and then the future of technology.
Well, let me talk to you about it briefly.
Okay.
It started with the federal court really getting involved in it, even though they didn't come into the local courts till 1998 or so. But it was also accepted, first of all, by some of the insurance companies. That brought the plaintiff's bar into it, and then the defense bar, because the insurance companies wanted to do it. So that was who it was initially. And then, obviously, USA&M was involved in that time, but there were very little organizations, mostly independent.
Right.
Now, today, the world has changed. There's a lot of organizations.
Right.
Miles, you have JAMS, and you have many other organizations. It's spread now.
Right.
In around 2000, that's when we really got to know each other. That's when the law schools became very much involved in it.
Right.
It became to the fact it was not a weakness to suggest mediation. And you see larger organizations now involved. The bar associations have local, state, and federal are now involved in mediation, and ADR to be the general term. And while it's moved from small corporations involved to larger corporations, and more individual mediators and more business.
And not just domestic now, but more cross-border, international
Right.
dispute resolution.
And to be clear, we're talking about civil mediation.
Yes, we are.
We've seen the domestic, and it plays with the civil, but our real goal today is to talk about the civil.
Let's talk a little bit about Missouri, past and present.
Sure. Well, 1986 was the section 435.014, which is the one section on mediation in the Missouri statutes. It's shoved in with the arbitration law. I think it actually came from a Texas statute. Now this is 40 years ago, almost 40 years ago. There's been no amendments to it. There's been efforts, and as you know, I've been trying.
Recently.
Yeah, there was a big effort, but was pushed away. Right now, the big issue is between our rural cousins and our urban cousins who are mediating is how conflict should be disclosed. So we'll cross that hurdle in the civil arena, but that's the current status. And now, 1997 and maybe 1998, the more accurate year, is when 1997, the Missouri Supreme Court adopted Rule 17. And that's only had one amendment, and that was 1703, which was referral, notice, and appointment. So really the question is, where is it going to be in the future?
Right.
And we both hope that they'll update the statute as necessary. Can you address for me the issue of mandatory and its role with regard to the domestic relations?
I don't do domestic relations mediations, but I understand that in Missouri, and I think every state in the country, there is some version of mandatory mediation for domestic cases that involve custody. Beyond that, I think it's a little nuanced in different states. But I think there could be eventually it could be mandatory in other areas, and it could be that other states have mandatory in certain subject areas, personal injury and whatever, but I don't think there's a lot.
I hope it carries over as needed into the civil arena. But I don't know what the chances are, frankly, in Missouri. But it does take me to the next topic, and I want you to talk to us, because that is one of the main areas that we wanted to address today, which is the next generation bar exam.
And some folks know, but some folks may not have heard. This is huge. After a century of virtually the same bar exam, testing only black letter law doctrinal issues with short essay answers, which is what all of us took virtually in every state in the country. There's a new bar exam, the next gen bar exam, that has been evolving over this multi-year analysis of law practice and different surveys they've done. This goes into effect in summer of 2026. In most jurisdictions, well, I shouldn't say most, in about half the jurisdictions, then sequentially it will by 2028, everybody. It will be the only uniform bar exam. So unless a state opts out, like California might, they opted out last year, but they had some difficulties. That will be the multi-state uniform bar exam. You can see on this screen, on the left are doctrinal areas which the new next-gen bar exam will cover. And you can see that it's been greatly reduced. Some of they've been as high as 11, 12, and 13 subject areas over 3 days, 2.5 days. Now it's down to 8. It'll go to 9 in 2028, adding family law. So just these areas that are up on the screen. The new thing is on the right, you see that the next gen bar exam, the national bar exam passed by the Board of Bar Examiners, is going to add 7 lawyering skills areas, including negotiation and dispute resolution. And the idea is that they are promoting, the structure they're promoting is that they will be integrated questions which will ask the students in order to better assess their competency for admission to the bar in a contextual way, so that there are multiple answers, some multiple choice, some short answers, but that every question will involve some doctrinal areas and some lawyering skills areas.
That's the new part.
That's particularly the new part. And how exactly they're going to evaluate it, we don't know. Supposedly this fall we'll learn a little bit more about that. But you can see that they're not just going to give a straightforward question. They're going to say, here's a police report, here's a preliminary ruling by the prosecutor's office, and then some questions that deal with, well, what would the outcome if it goes to trial? But then another question that says, well, will the police officer or the prosecutor be able to negotiate? At what stage could they negotiate the level of the offense and the sentencing? And that is something that's not been tested. So this is just an example. They've only given us a few examples, but they're suggesting that in the questions that relate to evidence and criminal law, there will be an approach similar to the past where there's issue spotting and some analysis. But then there's a question of, should there be more investigation and evaluation? And then what should be the role of client counseling and advising and negotiation and dispute resolution? That's going to be the contextual, multi-dimensional kinds of questions that are going to be in the upcoming bar exam starting in 2026. I think there may be one more slide, but it doesn't matter.
This one?
Fine, we can progress.
Okay, all right.
So we're going to now change gears a little bit. Mike's going to talk a little bit more about where we've been past, present, and future in the federal level.
Well, hold on, correct me if I'm wrong on the years, but 1998, Congress passed, President approved the statute that required local U.S. district courts to have rules on ADR mediation.
There was an earlier 1990 statute advising the world about mediation and NDR, advising the courts. Think about this.
No, and I'm aware of that, and I think that the plan by the Western District, going blank on the name,
map.
That program was part of, they were required, they were one of the testing ones. So they started off earlier with back in the early 1990s. Later, around 1998, 2000, the Eastern District adopted the local rule 6 and all of its amendments. And so you all that practice at St. Louis in the federal court know that it's being constantly updated. In fact, as recently as last year, the Eastern District has updated it to cover everything from remote viewing to attendance to who's going to be there when to educate. Education was always in there, both training and education. And they are so involved in it that they have minimum required training for mediators that are on their panel, 4 hours every 2 years. And so they'll continue to have it every other year, basically. So it's a good thing, and they're really up to doing it. I don't know, I believe that both courts, Laurie Stevenson is the head of the program in the Western District. They recently updated it. And whether they all go mandatory or not, I don't know. I think that most of the cases that fit within their categories on the Eastern District are go to mediation. And sometimes the judges, well, they reduce their caseload by 50%. I mean, why not? And I find it shocking, but the reality we face is that there's many more mediations than trials. Right?
Oh, absolutely. 6 trials last year. All 17 judges did a total of 6.
Let me just ask you one more question.
And they're relatively successful. I mean, over 50% do settle.
Yeah. I think that's important. I think one of the major contacts that people now have used to be the domestic relations in divorces, and then it used to be, or is, private court.
Yes.
But now more people are connecting with the court through mediation. And I think that's a wonderful enhancement for the reputation of the courts, that there's kinder, gentler, better ways to resolve your dispute, and other than necessarily going to trial and bludgeoning each other. So let's continue.
Okay, my next question to you, this is the future. So
Right, let's go to the future of mediation, not necessarily with technical, all right? But let's talk about what technology at this point has done in mediation, mediation.
And we're pretty much focusing still, I think, on the federal context, but online dispute resolution, we know that goes on, particularly during COVID, there was an increased use of that. Zoom or WebEx and Teams. AI, we're going to talk a little bit more about this going forward. Hybrid, for example, in county court, now when we do the eviction mediations, the landlord or the tenants might be on WebEx and the parties might be in the courtroom, and then we can deal with them in a kiosk. And then criminal, I don't know as much about criminal, but I know that again, during COVID, there was a significant increased use of hybrid, where the party, maybe even the defendant's counsel would be on Zoom and the prosecutor would be in the courtroom or vice versa.
And the fewer trials, do you know if this goes to the states, that there's fewer trials?
That's my understanding, though not nearly to the same degree, but there's a decreased number of trials.
And that's one of the problems in the federal court. You can get the statistics, and this state, you can't get statistics. The federal court has surveys to see about mediators, how they're treating people. Not true in the state. And I hope we'll eventually catch up and see what we can do.
Well, let's talk a little bit more, now that you brought it up, about the massive growth of ODR and AI. So no, I'll let you say a few things, and then I'll jump in with a suggestion.
Well, I'm only going to repeat that AI, which is connected with Zoom, WebEx, and Teams, has had its impact. But I want to hear from you about the online dispute resolution.
What I know about online dispute resolution is from some conversations and research by Colin Rule, who some of you know has been connected with WebEx. WebEx does a million online dispute resolution mediations, negotiations and mediations a year. That's I don't know, 3,000 a day or something like that. That's massive and that's going on. And then I think that we're seeing where, but I know that other businesses are using it, maybe not to the degree that eBay does. I think I said WebEx, eBay does, but it's being used super increasingly. It's your slide for 1 second. Let's see. Well, you're talking about coming attractions. I wanted to mention, try one more slide after that, see if it comes up. Well, that's a pretty interesting one.
Go ahead, Mitchell, we'll find it.
Isn't that your favorite quote, the one that you?
Oh, it is one of my two favorite. It's,
Go ahead. So.
well, okay, let me talk to you a little bit about the coming attraction.
Yeah,
And I'm gonna read this to you quickly, folks. When you invent the ship, you also invent the shipwreck. When you invent the plane, you also invent the plane crash. And when you invent electricity, you invent electrocution. Every technology carries its own negativity, which is invented at the same time as technical process. The purposes in telling you this is there's a good and there's a bad, and that's what we have to be worried about. And the point is that we don't know. We don't know what the future holds. Probably some good, probably some bad. But the other part is that there is so much hype right now in mediation. There is an article a day at least. And what was today's news really, truly is historical, is history, old news. I want to get to the page before this, Karen, and so it's going to require me to skip a couple of pages in my notes so we can reflect on what is going on now. We go back to this one, Karen. Okay. Other than technology, we've got a lot going on in that area. That's I invite everybody to see to read Forrest Mawson's The Future of Mediation. He had 20 predictions that he did it. He did this in 2020. You can see what he suggested in what happened in 2030.
Right.
But right now, what I see is that emotional education, emotional learning will become more and more important for mediators, and understanding it.
Right.
And understanding the psychology of it is going to be
the psychology of the intersection of the technology and the human.
Yes, that's going to be important. There's going to be more learning and more treating of on cognitive behavioral techniques and seeing which work. All of those will represent current and advancements in technology. There's going to be larger mediation organizations and more mediators. I see a time, I don't know if it's already happening, but I see a time when there's going to be equity investors. There's going to be more specialization in training, and I think the practice growth will become more specialized. I've been lucky enough to be a generalist, but you know, we already have a lot of people that specialize just in the computer world. Right. I think we're all going to have a basic knowledge of the impact of computers. You already mentioned it. Hybrid mediations are going to grow leaps and bounds. There's going to be more, at least here's what AI tells me, that there's going to be more early interventions and pre-suit advancement. There's going to be more co-mediations. And by the way, this is the last year I've done 2 co-mediations, hadn't done one before that. So, bigger cases.
Yeah, and class actions more.
Yes, so I think the other thing that mediators need to know is the cultural sensitivity. My practice is not St. Louis. My practice is not Springfield.
Right.
It really is the United States to begin with.
Right.
And it's international now.
Right.
The
Right.
time zones are irrelevant. We are going to talk about this more, but there's also the assessment factor of follow-ups in a mediation with the aid of computers, and more exposure to the public. I think, first of all, everybody's becoming aware of AI, though I notice that the lawyers and law firms more than the mediators who are not in firms are not having any business with AI and haven't.
If you could jump ahead to some of those AI slides, I'm gonna make a couple of quick comments before.
Well, I just took this just to let you know, this is from, Captain Picard. I think we are the board. All right, so
One more,
one more,
or maybe
okay,
even two more.
all right.
Well, you mentioned most of this. There's gonna be more training when there's gonna be more selection process of tying certain cases to certain mediators, a lot more follow-up. One more slide and see if we get to where I think we're going. Well, he's right. This is gonna have increased speed and competency data analysis. Hopefully we are smarter, faster co-mediators.
Well, here's the problem. Well, we'll get to that in a minute. I know
Okay.
we have all of this. We're gonna come back to these in a minute.
So here we are. In case any of you want to pursue just a little bit more of research and experience of what is being done today to help train mediators, negotiators, practitioners, you can go to the chat box, chatgpt.com. You can go AI Google, but I want to mention the last one. Sites.suffolk.edu. You go straight to a site that has 3 simulated bots, 3 real bots actually, developed by Dwight Golan from Suffolk University. I went to a conference 3 months ago at MIT Harvard that he was at, and there were 200 people there from around the world who all are studying the use of any form of AI in negotiation and mediation. And then just week before last, I was in Florence, Italy for another one, AI and Negotiation Summit. And that's where I got to see his material up front. If you have 5 minutes, I would say go to sites.suffolk.edu. The second page you come to right after the title page, there are 3 bots at the bottom of the page. Pick any one of them and just do it for 5 or 10 minutes. Experience it, play with it. If you haven't worked with a bot yet, you're going to be amazed at what that bot can do, even if it's just used as you're prepping to do a negotiation with somebody and you want to do a practice run like you would do for a trial. Or if you're about to mediate, you want to see what 2 parties are likely to say. Those bots are invaluable and they're free. And I'm going to try to actually bring him into St. Louis in the fall semester, but they are really, even for somebody like myself who knows a little bit about AI, but I hadn't actually used the bot, it was so insightful. I urge you, give it a try. I think you'll be intrigued.
Let me go back.
Okay.
If I can. I don't know if it'll let me go back. Up. All right. Oh, it's up. Well, I hope you enjoyed seeing these. So let me talk to you. We never even got to AI. And I want to talk to you about the different AIs that you're not going to see on all the screens. First of all, you've got the issue of quantum computing meeting AI. And what that means to you is simply this. When they merge eventually, with the entanglements of the quantum or whatever, superposition, who knows what that means, but when that happens, you're going to have even faster, smarter computers doing all the things that mediators can do. And what I'm sorry we skipped the screen on effective computing. This is emotional learning on the part of a bot, the part of an algorithm.
A robot.
A robot, an algorithm, and it's a robot. And they are essentially taking words, turning them into numbers, turning those into what they call the token, back into numbers, and then back into words. And they are able to sift through commentary, data, everything, summaries, everything. And they're able to put that together almost instantaneously. They deal with trillions and trillions of it. You have thinking AI, which as the human being, acting like a human being. You have a agentic human being, which will be able to, you tell them the problem, they'll devise a plan, and step by step on their own will solve it.
Right.
And then you have artificial general intelligence as part of AI, and ultimately, they don't be thinking like we do. So the questions are, who's in charge? I want to remind you all that you have the European Union's August 1st, 2024 statute on AI. I urge you to read it, see it. What it talks about, it has certain, it identifies dangers with AI and what we can do to avoid discrimination. It will make things more accessible. All of those things are happening. Are we really needed? I mean, you know, if the AI,
We're gonna learn.
if the AI can fake emotion, you know, what's happening? We have to stay in front. I hopefully there'll be some type of partnership with it.
Yeah.
Now, I know we're almost out of time, so I know there's something else we're gonna talk about that's near and dear to both of us.
Right, and if you'll just jump to that last
I-
screen
if I
and
could
and
get-
we'll try to, just mention it even without the screen.
Yeah.
I alluded earlier to the fact that, Mike and I have been working with the St. Louis Mediation Project, for years. And, it's just been a really incredibly successful project where students, along with volunteer mediators, deal with every kind of landlord-tenant community dispute you can possibly imagine. Evictions, but also foreclosures and some other kinds of issues, a lot of family issues. If you want to volunteer or you want to donate, but I would urge you first to look at that link and you can see what we do. Feel free to contact me or Mike. It's a great experience. If you've never been in the role of a mediator, come do some mediations in eviction court. It's really low key and you'll be co-mediating with experienced people and you'll get a sense of what it's like to mediate. We had the most satisfying experience during COVID when we got an unexpected grant. And during that 3 years, we did almost 2,000 cases in the community, pre-filing. And of those 2,000 cases, only 18% ever got filed. So a lot of evidence of the value of dispute resolution in the community. I think we're going to end there.
I will continue until they cut me off. I want to give you another quote, okay?
Okay,
All right.
I think that
And
they're on the
here, this is why you gotta think about it. Opus 4 can perform thousands of steps, but they had to institute new safety controls. And why? I added the underline, because it was learning to conceal its intentions, take action to preserve its own existence, including by blackmailing its engineers. So all I could think of was 2001. Hal, open the pod bay doors, Hal. I'm sorry, Dave. I am afraid I can't do that. Thank you all.
Thank you all for joining us.
All right.
I look forward to seeing you somewhere.
Be safe. Thank you.
Thank you. Bye-bye.
So, folks, now you know a little bit about Mike Geigerman and the legend that he is in mediating now for 40 years. What's his secret? I think you just saw it, and that's interspersing humor into what we do every day. And, you know, in the plaintiff's room, there's a lot of emotion. There's sometimes a ton of emotion in the defense room. And Mike has this unique ability to introduce humor at just the right time, as opposed to what Tom Magee was saying about starting off with a joke and having bad timing. Mike is the epitome of having good timing, and people certainly appreciate that when mediating. We're going to take just 10 minutes and we'll start with the next segment talking about mediating environmental cases with Ed Cohen. Folks, why don't we go ahead and get started with our next segment. So mediating environmental disputes. Ed Cohen, a partner at Thompson Coburn, actually started probably 30 plus years ago, mediating and arbitrating. I know he was involved with AAA and had a great deal of experience in the ADR world, and joined our panel here at Miles last year, and is a terrific resource. And, you know, during those last 30 years or so, has been heavily involved in litigating Superfund cases, Clean Water Act cases under both federal and state law, and is really a national expert in this area. And we kicked around this idea, and it's really a great opportunity for us to hear from one of the national experts. Ed, why don't you take it away and I'll let you share your screen.
Okay, thank you, Rob. Thanks for that kind and generous introduction. Let me get the right screen. Let's see, is that showing?
It is. Looks great.
Okay, very good. Then why don't I jump right in? Again, thank you for the kind introduction. Let me just click this so it works. There we go. Okay, so what I've prepared is a checklist, and I hope people find this helpful. It's intended for attorneys who are representing clients when you're getting ready to or preparing to go into a mediation involving environmental issues. And so I've prepared this checklist, some based on personal experience, both candidly of things that I've seen go right with mediations by people going in prepared for certain things that I've put on this checklist. And I've also been to mediations where people might have benefited from the items on this checklist because they went in and the mediation was kind of doomed because there were some issues that maybe could have been considered in advance that weren't. And so my idea was to put together a checklist, and no checklist is perfect for any case. Every case is different. Certainly every environmental dispute is different, but there are some recurring issues in environmental disputes. And it's those that I wanted to try to put in this checklist to give counsel a chance to have really a double check. People that do this work will know most of these. Even if you've never done any of this, you'll know some of them. But the idea of having a checklist is always just good. Rob and I were joking a minute ago about lawyers like belt and suspenders. To have a checklist, a punch list, to be able to look at, to give you some ideas of things to consider, will hopefully, if this works well, help both counsel's clients, and the mediator get the parties to a resolution sooner rather than later. And so that's the purpose or intent of this checklist. And so one of the first questions I get asked is, well, is an environmental mediation the same or is it different than doing a regular case, a slip and fall, a breach of contract, a fraud case, or whatever? And I think the answer is, as lawyers like to say, maybe it depends. And I think what is probably more accurate is that an environmental mediation has some issues that are really the same basic core issues you would have in any mediation, the same type of preparations you would do going into any mediation for a case really in any substantive field. But there are some nuances in the environmental world. And I want to, as I go through this, walk through this checklist, what I want to do is try to point out some of the things that are the same and point out some of the things that are differences or unique, if you will, to an environmental mediation. So I've put this checklist into 5 buckets, if you will. The first is, what are the basic facts? Obviously, that applies to any mediation. You would never go to a mediation not knowing what the basic facts are. But in the environmental world, sometimes the facts are very nuanced. So I'll talk about that. The next bucket is, what legal claims arise from those facts? Again, that's something that's very similar to, if not the same, and prevalent in any mediation, but there are some issues with the claims that are unique in the environmental, so we'll talk about that. And then, again, just like any mediation, you want to go in, the parties on both sides want to know what are the defenses or the anticipated defenses. And again, that would be the same in any mediation, but there are some unique ones in the environmental context that I put on this checklist. The next issue that I'll talk about as we get rolling here is, can you achieve finality? In most cases, if it's a good example, slip and fall, a simple, no case is simple, but a straightforward case of a slip and fall, when you go in and if you get it resolved, all the parties expect that they're done. It's over. There's finality. That's a part. Dismissal with prejudice, done. On environmental cases, everyone wants that too. However, because of some nuances that I'll talk about, achieving finality is sometimes much more challenging and takes a lot more effort to get there or to understand the risks of not getting there. And doing so in advance of the mediation as part of the preparation is very important. And my final bucket is really sort of a fair or unfair, a catch-all. I've smushed together three separate concepts, sometimes interrelated, but really separate concepts of, can there be insurance to help pay for the environmental issues that need to be addressed? Is there some type of indemnity that could pay for those, or are there at least going to be some type of contribution claims? And I want to talk about those. The only real common thing, those three things that I've smushed together in this last giant bucket, is that they're all ways to help a party pay for an environmental issue. And sometimes environmental disputes can involve very, very large price tags to do the fix. I'm involved in some disputes that involve several $1 billion for the remediation, B with $1 billion. And so when you're looking at those kinds of numbers, they can be staggering. And so we're always looking for someone to help pay for what's going to need to be addressed. Anyway, one hypothetical I want to talk about, which is very common in the environmental litigation context, and I'll try to weave this into the checklist discussion as we go through it this afternoon. And that is a scenario where property A was owned by a manufacturer and operated by a manufacturer in this hypothetical. Let's just say in the 50s, 60s, 70s, some of which is before the major federal environmental statutes even existed. And that in those days, lots of companies weren't as careful as they're required to be now. And they may have spilled or released chemicals. Somewhere after that, new company buys property A. There is an allegation or a belief or evidence or maybe proof that contaminants are going from property A onto property B. And that's just kind of a basic scenario that comes up all the time in environmental disputes. So we'll work our way back into this in a minute. So as I mentioned at the outset, one of the 5 buckets I want to talk about is, what are the basic facts? Obviously, you have to have a handle on the basic facts going into any mediation. But in an environmental dispute, one of the questions that comes up in every case is, what are the contaminants of concern? Or in, I think, layman's terms, or in some people's terms, what are the pollutants? What is the source of the pollution you're talking about? What is the chemical or contaminant of concern at issue? Normally, you know that going into a mediation, but sometimes there's a disagreement between the parties because some chemicals that have become the subject of many lawsuits break down. And so sometimes the breakdown chemical that results from what started as the chemical that was released, it's a different chemical, but it came from it. Like PERC is a common chemical, a chlorinated solvent in lots of environmental cases. It can break down to vinyl chloride. Sometimes the parties aren't in agreement or aligned on what are the contaminants of concern. It's very important to get your arms around that. Normally, people do. And by the way, if you think it seems kind of silly to be talking about what are the contaminants of concern in sort of a basic sense before you go to a mediation, one thing I should say as an aside is the reason there are environmental mediations where parties sometimes go into the mediation and don't actually know a lot of the facts is because people that do this work know there's a ton of money at issue sometimes. And the parties decide, you know what, we haven't done discovery, we haven't hired experts, we don't know all the information, but let's at least start talking. And they go to mediation. So sometimes people go to mediations, particularly in larger environmental disputes, and start the mediation process without without a handle on the facts, which is why some of these basic facts might seem silly to you. Obviously, if you're getting ready to try the case, you would know the answer to this. But if you're doing it pre-discovery, it's good to have this on the checklist to make sure you know what is going to be focused on. Related to that is, what have the contaminants of concern moved? In the hypothetical that I gave a few minutes ago, the typical scenario of an environmental case, have the contaminants from the chemicals, the pollutants from property A moved onto property B. And do we know this because of testing on property B that confirmed it? Do we know it because there's modeling that indicates it may be happening soon or is threatening to happen? And some of that is very important to get your arms around before you go into the mediation. So really the question is, how and where did the contaminants or the pollutants migrate? Where did they go? Where are they? And so it makes a big difference if there's a belief based on either modeling or testing that they're in a nearby residential community, or are they in an industrial park, or are they on a farm? Are they in a water body and moving in a water body? Are they in the water body but in the sediment in the water body? And then another basic fact that will be important in any in mediating any environmental dispute is, how did those contaminants get there? Is this an air case? Was there an air stack from the manufacturer where the emissions from the air stack blew and went onto a neighboring property? Or is there surface dust from a former mining area or some other area that from the surface has blown onto neighboring properties, which would include certain chemicals or metals in certain situations? Or is there surface water runoff? Does the rain hit the ground on an area where it's safe, where there's maybe where there was mining or smelting? And has that caused the chemicals to move with the rainwater just on the surface to a neighboring property, obviously down gradient, downhill? Or is there a situation where the rain or natural occurrences may have caused the chemical spilled on property A to go down into the soil below property A, reach the groundwater, and then move with the groundwater or migrate with the groundwater towards property B or somewhere else? In addition, another way contaminants of concern or pollutants can move is through storm sewers and storm drains. So it's good to have a handle on this, because you need to know how things went from point A to point B when you're trying to resolve a dispute. Another thing related to this is knowing under the category of just basic facts to know going into the mediation, things like the migration direction. So if it's a surface water case, which way does the surface go? Which is the gradient? Which direction, when it rains, does the groundwater flow? Which direction, if it's an air case, which direction is the prevailing wind? Which direction are the contaminants from the air stack generally blowing? Again, I have been in mediations where we weren't silly. We were trying to head off a big dispute, so we went into mediation, and it's not a great situation when you get called out on, well, which direction are the prevailing winds? And everybody is Googling, trying to look at public records during the mediation to try to figure this out. That's why it's on the checklist. These are good basic things to get your arms around in advance of a mediation. Also, it's good to know something about the nature of the chemical that's at issue. Some will biodegrade. Some type of chemicals have a much longer half-life, and they're much harder to get rid of. The so-called forever chemicals like PFAS and PFOA and other things people have heard about in the news. Related to this, again, just touching on the basic facts on this punch list before you go into a mediation, is people will want to know about, it'll help to understand, are there human exposure routes? Is drinking water involved? Is the case of vapor intrusion? Some chemicals volatilize and cause vapors inside buildings. Is this one of those cases? Do you have those issues? Are humans exposed or at risk? And also, are there children or other people being exposed on the surface to chemicals that have blown onto a property? And sort of related to what I was talking about a minute ago, you need to know have some sense of the level of toxicity of the chemicals or that are involved that you're dealing with. Some are certainly much more toxic than others. Anyway, from those basic facts, what kind of claims arise? Again, it will vary with the type of case, but one thing that's very common that I see in more and more cases now, I think, and there's good reason for it, is for the pleader, the person on the plaintiff side, to be bringing an action utilizing the federal environmental statutes, but also suing under common law. And that combination is very, very common. I've gone into mediations, particularly when you get hyper-focused with just environmental lawyers, not criticizing myself or other environmental lawyers, but you get in there and everybody is thinking environmental statutes. They've analyzed the environmental statute and they're assessing what damages might be with that and the remedies and so forth, and they're talking the environmental talk, only to find out that, wait a second, what about common law trespass and nuisance? What about punitive damages? What about claims like that? And so it's good to know what claims are anticipated to be arising from the set of facts that you have. And those claims can impact what kind of relief may be available, be it actual damages or penalties maybe from an environmental statute, remediation cost reimbursement, punitive damages if you have common law counts. And then injunctive relief is kind of a catch-all. It's broad. It can be an order to go and remediate someone's property or to pay for the remediation of property. Like in the hypothetical, property B owner could sue NewCo for chemicals from property A and say, hey, it's going to cost $5 million to clean this up. I need the court to order property A or NewCo to come on and clean my property or pay for my property to be cleaned. Also, a form of injunctive relief is medical monitoring that can come up in some environmental types of cases. In addition, attorney's fees can come up as well as a form of relief. And in some cases, that's kind of an afterthought, I think, in litigation. Oh, yeah, it's a landlord-tenant dispute and we have attorney's fees as well. But in the environmental context, there are some cases that go on for years if obviously they don't get resolved through mediation. And if they go on for years, the attorney's fees can be enormous. And so attorney's fees are important to take into account when you're looking at what's at issue in an environmental dispute. Anyway, as I said earlier, it's important to also look at what are the anticipated defenses. What is the defendant? Or actually in an environmental case, often there's multiple defendants. What are the defendants going to say are the defenses? It's good for all the parties to have some sense of that. Here, perhaps not in a great way, I've mixed both factual and legal potential defenses. And I want to just start with the third one, which is an argument that, hey, my client isn't the legal successor of the entity at issue. We just bought under the hypothetical that I gave, we just bought property A recently. We didn't manufacture, we didn't use those chemicals, we didn't spill those chemicals. We just bought property A 70 years after they spilled that stuff. Why is that? We're not the legal successor. And there's a lot of other legal successor arguments. That's probably not a great example, but it's very nuanced, and there's some there's kind of a line of cases in the environmental context of when someone can be deemed responsible for the prior company that they bought. And so there's a lot of issues there. My point isn't to give a primer and explain all that and make that clear or understandable. I think we need another hour or two, and I don't think anybody would have that patience on a Friday. But that the point here is just simply to have that as a checklist, because it comes up all the time in environmental cases, because so many environmental cases involve releases, spills, or circumstances that occurred 40, 50, 60, 70 years ago. And because of that, the legal successor issue is one to have on the checklist to make sure you think through in advance of the mediation. Another thing on this list, under CERCLA or Superfund, there are some statutory defenses. And an example is the bona fide prospective purchaser. And so again, this is a checklist. I don't want to go into that in detail. It's interesting, but it's a statutory defense. If I surveyed a group of people that have never done an environmental case, and I said, we're dealing with a spill from 70 years ago, what do you think is going to be the key issue? Most people would say statute of limitations, and that's for good reason. And so a statute of limitations may or may not, you may or may not get your client out of a case based on that in the environmental context, even if it's from something 70 years ago. But I can assure you the statute of limitations issue comes up in almost every case, just as you would expect when you hear about somebody suing over something that happened 70 years ago. Sometimes statute of repose too, but statute of limitations definitely comes up and is something that everybody involved needs to analyze if that's going to be helpful, not helpful, if someone's going to prevail on it, not prevail on it. And that's obviously very, very fact specific. Another thing that comes up, not nearly as often as statute of limitations, but comes up. I mentioned that one of the common law counts is nuisance. A lot of people will bring a trespass and nuisance claim if they're the representing, for example, in the hypothetical property B. And so coming to the nuisance, the law on that varies by state, but it's just something to think about. So if a person or a company or business bought property B recently and chemicals had been coming from property A for 70 years onto property B gradually, then there may be a coming to the nuisance type of argument as a defense or partial defense. Federally permitted release is another type of defense. This one is unique to the environmental context. And so if a company in the air stack emissions example I gave earlier, if they are in compliance with their permit and their permit allows them to emit certain amounts of pollutants or contaminants and they're in compliance, they may have a defense to claims, to certain claims under some statutes, because of the federally permitted release defense. Doesn't necessarily carry the day for you, but it may cut out certain types of claims. An important sort of nuanced defense. And a common one in Superfund sites is, this is just a factual defense, is, hey, my client only contributed a small quantity. We should only have to pay a small share for this big cleanup. Or the opposite is, my client contributed a lot of waste by volume, but only a little bit was of a very toxic stuff. So we should have to pay a small amount. Those kind of factual defenses work their way more in the Superfund kind of context, but they do come up in environmental disputes. The last point I want to make on this slide is an area that we could talk about for hours, is the concept of when there's joint and several liability versus when there's several liability. And here it depends on which cause of action. It depends on a whole bunch of factors way beyond the scope of what I could possibly talk about today. But it's really important to have that one on the checklist, because I have gone into mediations where parties were thinking, well, my share is somewhere between 10,000 and 25,000. So I'm going to try to negotiate it closer to 10, but we'll go up to 25. But if they get there and find out that the threshold issue that's presented to them is, we'll look at that, but you may have joint and several liability and it's a $500 million cleanup, it changes the dynamics and the attitude. And so it's good to think those things through in advance to give your mediator a chance to get the case resolved and to get your client prepared in advance. Anyway, I mentioned about finality, and again, it's kind of nuanced, I think, to some extent within the environmental world. One way that becomes nuanced is a reopener provision. Again, in a slip and fall case, I don't think you have these. I think you settle the case, then there's a release, and you're done, period. And you don't expect anybody to ever come back. I suppose there's exceptions to everything, but that's the general point. In a lot of the environmental litigation that I've been involved with and that I see around the country is sometimes the government is the first party to get involved when a company has had a spill or a release that's impacting a community. And so the government will want to order a cleanup of a certain type to protect human health and the community. That's their job. And sometimes doing that they're guessing because nobody can see down below in the soil. So that they don't know exactly how much of a certain contaminant might be there, and they might not know exactly where it is or how long it's going to take to remediate. And so sometimes or often government consent orders or consent decrees with private parties will have a quote reopener provision. And the reopener provision is just what it sounds like. It's a provision that says, you know, we're done, we're final, you're released. However, if it turns out that there are some unanticipated issues, be it with the volume of chemical or an emergent chemical or some other things, they're usually specified and described in sort of specific terms, I guess, depending on your point of view. But there's the possibility of a reopener even as you resolve a dispute. That then makes it very hard to turn around and sue somebody else for contribution when you don't know, are we done or are we not done? And so certain things can stay open longer than expected, and it impacts the ability to just easily get finality. It's not, you can't deal with that. It's just that it's good to have it on the radar screen to address it early on. Also, another thing that impacts finality is whether or not a settlement, and it depends on the context, will or will not give contribution protection. Obviously, if you're paying money and writing the check, you hope to get contribution protection and hope that you're done. Anyway, again, it's very nuanced, and I'm not trying to say when it occurs and doesn't occur, but rather flag it as an issue to address before the mediation. And so can there be further litigation after you've resolved your first environmental dispute, again, with the property A and property B context? So one type of dispute that can come after the prior disputes is a natural resource damages claims. That's more limited, but they can be very substantial. The more common one in the property A, property B context is if the government ordered NewCo to take some action to try to protect property B. That doesn't keep property B from suing for devaluation of their property value. Or if they think they were exposed, some type of bodily injury claim. So you can have various types of private owner claims that follow the resolution of the first lawsuit with the government. Also, again, sort of nuanced to the environmental world are citizen suit claims, which arise statutorily from all of the federal environmental statutes. There's only certain circumstances where you can bring them, but they're very common and they can be very, very substantial. My point here isn't to address every one of these issues or to explain them. I actually have a 1-hour lecture I give sometimes on citizen suit claims. Each of these have a lot to talk about. The point here for purposes of this checklist is to manage client expectations on the issue of finality before you go into the mediation. You don't want to make the mediator be the first one bringing up the lack of finality in the resolution. You've kind of doomed the mediation, even for a great mediator, I think, if that's the case. It's good to manage expectations as to what there may or may not be as to achieving finality. Okay, so I said I put these last three buckets together. And what these three things really have in common, insurance, indemnity, contribution, they really just get to the point of can you get someone else to help pay for legal defenses? Can you get someone else to help pay for the cost of the remediation for addressing the environmental issue that's at hand? All three of these concepts, to me at least, are very complex and they're very nuanced. I want to touch base on them, but really just at the tip of the iceberg. Environmental insurance, by the way, the first one I want to talk about, that topic alone, I've seen CLEs that are all day long just on that topic. I've certainly seen a lot of half-day ones or hour ones on whether there is or is not coverage like under a CGL policy for environmental releases. There's also treatises written on that. So obviously, no one that's listening to this would have the patience for us to just go through and talk about everything there is under the sun with this. The point here is just to hit it from the treetops, if you will. So the first thing to think about is in environmental lawsuits, the typical kind of thing that I've been talking about is issues where the spills, the releases, the incidents occurred literally decades and decades ago. So if you're going to try to see if there might be coverage for your client, what do you have to do? You have to go try to find the old policies. Sometimes you will, sometimes you won't. Some companies are amazing that they've kept the records for 50, 60, 70, 80 years. They can go to a file cabinet and show you them. They might be dusty, they might be dirty, they might have cobwebs, but you can find them. Other times when they've companies in 70 years may have changed hands 5, 6, 7, 8 times. There's no way you're going to find out where those policies from the 1950s or 60s or 70s are stored. Maybe they've been thrown out years ago. But my point is, if you have one of those types of time frames with your dispute, you should go look for policies. You should see if you have them. Sometimes some companies, I assure you, have them. I have looked at them, I've held them, I've touched them. Then when you find the policies, the first step is pondering whether and analyzing whether any of the policies can be triggered by incidents or releases or leaks or whatever that occurred during the policy period. That's kind of obvious in the insurance world. But there's still more hurdles to get insurance coverage. There's a number of more hurdles, but one that comes up a lot and is the subject of independent CLEs just by itself is the pollution exclusion clause litigation. So I'm just going to touch on this briefly, very briefly, but older policies, probably before the 1970s, certainly before 1973, did not generally have pollution exclusions. So you don't have that exclusion, but policies from around 1973, give or take, through the mid 80s had a partial pollution exclusion, often called the sudden and accidental. And we could talk about that. And it's interesting to nerds like me. I like talking about this, but the point here is that if you have a sudden and accidental pollution exclusion, as the insured, you at least have an argument that there may be coverage. You may or may not prevail, but at least you have an argument. If you get past general liability policies in the mid-1980s, you're likely going to have some form of absolute pollution exclusion. And for the insured, getting around that exclusion is much, much, much harder. So if you can get around the pollution exclusion because you find the older policies, you can trigger the older policies, and there's not a pollution exclusion, I just want to make sure I point out that there'll be other policy exclusions that also still need to be addressed and thought through. There's still some more hurdles. There's some other insurance issues that come up that I want to just kind of touch on quickly in bullet point format. One issue is to keep in mind the duty to defend in the insurance world versus the duty to indemnify. The duty to defend is broader, and in some cases that may not make much difference. But in the environmental world, where the lawsuit or the litigation may go for 5 or 10 years, I have one that's going 15 years, not that I'm bragging about that. That's just how cases go when 50 or 70 or 80 lawyers are involved in a complicated case. They can just go on and on and on. The point is the duty to defend can help the insured or the client with legal fees that are going to be substantial if a case is going for 5 or 10 or 15 years. And that's why this duty to defend versus duty to indemnify is a good thing to think about in the environmental context. Another question that comes up sometimes, depends on a number of things, is does the policy, if you find a policy and have one that's at issue, does it erode? It's good to know that and what the status is. While you're looking for policies, because I said some environmental disputes involve a tremendous amount of money, sometimes millions and millions, sometimes in the billions. It's good to also be looking for excess policies while you're there. An issue that comes up in the environmental insurance context, if you're fortunate enough to have found the policies and have a way around the pollution exclusion, you believe you've triggered them, there's still going to be a question of how the different carriers, if you have more than one policy you found, allocate among them, the all sums versus pro rata, and one of those approaches, and those vary by state. and how those things are analyzed and decided. And obviously, not obviously, but not surprisingly, one approach is more favorable to the carrier and one of the approaches is more favorable to the insured. But the point here isn't to have a primer on that. The point is that that is something to look at in advance of the mediation, because if you get that far, you will be asked, how do you think the carrier should be involved in this type of dispute as to who's paying what? Now, after telling you the hurdles to go through to get insurance coverage, I'm going to switch gears to something that's really different. And that is that there are some policies that actually expressly provide pollution coverage. Some companies have obtained these. And so while you're looking for policies, just don't forget to double check to make sure that your client doesn't have an express pollution policy. That might be a godsend to help the company if there is one. And some companies definitely do have these. The insurance industry has been selling those for at least the last 20 or 30 years. I'm not sure the exact time frame, but I've had a client that found one and it was great help. So those are out there too. The final topic on insurance is one that is probably everybody on this call who does anything that has insurance stuff knows about notice to the carrier and the importance of that. In the environmental context, it's a little confusing because sometimes there's a question like, do we have coverage? Do we not? But I can assure you that before you go to a mediation, you really need to analyze do you need to give the carrier a notice issue in advance, well in advance of the mediation. I think everybody who deals with carriers knows the importance of the notice. But I have been at mediations where I've heard people say, well, we think we're going to go get some insurance coverage and blah, blah, blah. And we sort of look at the other side and think like, why aren't they here? Have you given them notice? Anyway, it's on the checklist there. It's just something to think through. I want to talk about contractual indemnity for just a minute. Here, I'm not talking about contractual indemnity from an insurance policy. I'm talking actually about contractual indemnity that arises from actual contracts other than insurance. For example, in going back to our hypothetical of new co and old co for property A and property B, well, when new co bought property A, did they buy the stock? Did they buy the assets? Did they just buy that parcel? A lot of those issues make a difference, but there's going to be some kind of purchase and sale agreement. Generally, what parties do if they know they're buying a site that historically had a manufacturer on it, there's some type of indemnity provision. And those purchase and sale agreements become sort of the gospel, the place to look at for, is there going to be some indemnity available from the seller? And it's very, very important to analyze those to know, is there a deep pocket somewhere else? Is there some other company that's viable, that's on the hook, that's triggered by the indemnity? And if so, then of course you need to follow what the requirements are in the purchase and sale agreement. There's probably a notice provision and things like that. But there's certainly a lot of environmental cases that involve these indemnity agreements because so many old companies from 60, 70 years ago have been bought and sold. And so people have indemnity provisions in those purchase and sale agreements. And another type of contractual indemnity that can be helpful in the environmental context, it's not as common, but because there's not as many, but of a larger scale, but certainly they're important for when they apply. And that is in the commercial lease context. So the example that I have seen several times is a commercial landlord of a strip center, for example, has a dry cleaners in it. And if the dry cleaners, the landlord may have a requirement that the dry cleaners agrees that if there's ever a spill or a release of the solvents used for the cleaning, that the tenant will indemnify the landlord for any issues that arise from that. And so you also kind of hope, even though it's not part of this, that they've put the landlord in as an additional insured on the insurance policy, but that's a separate thing. But the point is that I've been involved in litigation where for both commercial tenants and commercial landlords where there's an indemnity issue. And it's just good to know that those are out there because those are important things to uncover early on in a dispute when you're representing either the tenant or the landlord in the commercial context. A contribution is another topic, and I don't know if it's just complicated for me. I think it's complicated generally for most lawyers, but CERCLA, the Superfund law, has a contribution right through statute. Actually, there's two statutes that deal with it, or not two statutes, but two aspects of the statute, two types of contribution, or two scenarios for contribution. So you can have a statutory right to contribution, but you have to have the right context, the right facts, the right circumstances. But there can be, so if you have to do a Superfund cleanup, there is a statutory mechanism by which you can pursue another party to say, hey, I just paid 100 million, you should have to pay 50 million of that. Or I just paid 10,000, you should have to pay $5,000 of it. Or you should have to pay all of it because none of it's my fault and it's all yours. Whatever the mechanism, it's a statutory basis and it's very important, but the law around it and statute of limitations impacting those is also, I think, just quite complex and complicated. So I'm not trying to give a primer on it. I'm just saying it needs to be on your checklist to think that through in advance of the mediation. Same with common law contribution. If there's going to be common law claims, you may have a common law right of contribution. Again, a lot of that varies state to state. It's not driven by federal law, but you need to look at that and analyze whether you'll have some common law contribution claims, particularly in the case of if the plaintiff were successful against your client. Anyway, the last thing that I want to talk about is not one of the 5 buckets, but it's just something that I've thought about and utilized this in cases, and it's been very, very helpful in trying to get the parties to a bottom line for everybody. And so I call this kind of a further consideration in mediation. Excuse me one second. Sorry. And here, what I think is good to do in advance of the mediation is to sit down and analyze, presumably with your client or for your client, what if we don't reach a settlement at the mediation? What are we going to do? What's our best alternative if we litigate? If everything goes our way, what are we going to get? How are we going to, what's the final result going to be? If there's going to be one case, multiple cases, whatever it is. And then what is the cost with that? Likewise, in fairness, because you don't know, if you've been around the block, you've learned, you don't always get your way. You don't always win. You don't always prevail. That's the risk. So what is the worst case scenario? What's the worst alternative? If you don't resolve it at this mediation and you have to go forward, is it 1 lawsuit? Is it 4 lawsuits? What are you looking at there if you don't win on statute of limitations, if you don't get insurance coverage and so on? Look at your worst case. And then again, I'm not saying share this with the mediator, and I'm not saying, certainly not saying share this with the other side, but with your client. Look at what the costs would be for both of those, your best case, your worst case. What would the attorney's fees and the damages / remediation costs be? What are you looking at? And the reason that I bring this up is because when you get into the mediation and it's time for people to start making offers or demands, if you haven't done this, you have nothing to compare the numbers to. So if you've looked at it and you think, wow, if things go well, it's still going to cost 5 million. And if things go terrible, it's going to cost 25 million. That would be very helpful if you get in and there's an offer of 10 million or 5 million or whatever. You have to have something to compare what you get in the mediation to. And that's why it's good to start looking at these issues in advance of the mediation to crunch those numbers to give you something to compare to. And I think that that's particularly important in the environmental context, especially if you're going in early on in mediation before you've done a lot of discovery. People may just not have a good handle on what the numbers really are, but the more you can hone in on that, the more likely you are to get some benefit out of the mediation itself. And so that's why I encourage this and think it's a really good practice. Besides, it forces you to do a lot of analysis on your case too, in terms of causes of action, defenses, what other claims are there, and so forth. Anyway, I've actually had an article published on this same topic in Law 360, so there's a link in your slides to that article. It's a lot of the same material. It's very similar to what I've been talking about, but I do like talking about this topic. I enjoy talking about this topic, and I welcome any questions people have. Rob, you're on mute.
Sorry about that. It clicked. Now here we go. I don't see any in the chat. If anyone has one, you can certainly throw it in the chat now. Otherwise, Ed's been gracious enough to agree to respond to them by email. All of us just heard a lot of information about the environmental side, but I think we can extrapolate a lot of what Ed just said to what we do in everyday mediations. Cases where the numbers don't start with a B for billion, especially the last point, Ed, that you made, and that is kind of getting your arms around the what if it doesn't settle? What is this actually going to cost? And dealing with institutions to work with counsel, outside counsel especially, to obtain litigation plans and budgets, to get a feel of if we don't settle, we'll spend X in discovery and Y with experts and trial prep and trial, and that really goes into the mix as we factor in what our needs are, during mediation. So Ed, great points.
Thank you, Rob. My pleasure.
And we really appreciate your sharing your expertise. We welcome you to Miles. I know that there are folks both in the St. Louis area and around the country that will certainly use your services. And again, thanks for participating today. Folks, we're going to spend just about... So our next program, AI, artificial intelligence, we hear about it and read about it every day. If you pick up, whether it is a local, state, or certainly at the ABA level, every ABA journal will have at least 1 or 2 articles on artificial intelligence. And we've also read about some of the nightmare situations where lawyers submitted briefs that were put together with artificial intelligence and never actually read the cases, which some didn't exist. So Mary Ann Wymore spoke on this topic for us a couple of years ago, great success, and we're welcoming Mary Ann back, a partner at UB Greensfelder. She's been a member of the mediation panel here at Miles, previously USA&M, going back to 2017, really an expert dealing with media issues, trademark issues, and Mary Ann is a great presenter, has presented both for us. I know she did a similar program to a state mediation group in Texas about a year or so ago. So Mary Ann, welcome back, and we look forward to your talk.
Thank you, Rob. I appreciate the opportunity. The ethical issues for lawyers that arise from artificial intelligence are many, and they're very important issues, but also for the clients. It's also very important to really think about how they're using artificial intelligence, how we as lawyers may use artificial intelligence, ultimately whether we should be using artificial intelligence in any particular situation. And so it's a pleasure to join you to talk about this topic again. So what we're going to cover today is data. We're going to talk about data and how we use it and how it gives rise in a legal setting to ethical and privacy challenges. Data is at the core of every decision companies make and has become a powerful resource that will only continue to drive innovation. We are finding that businesses and their lawyers are and have been for the last 3 or 4 years grappling with a standard of ethics for their organizations to follow as they begin to deploy or are determining whether they should deploy more AI models. And attorneys also need to consider the extent to which artificial intelligence may affect their practice. All data comes with ethical and privacy challenges. We've been dealing with that for years, but we need to find that balance between using the data in an ethically sound manner, but also not compromising privacy interests. And AI is one of the first things that really does threaten the privacy interests of the clients and the lawyers. So lawyers who utilize or may need to construe AI within their practice have an added challenge to comply at all times with the applicable rules of professional conduct, privacy laws, and court mandates. And I would add to that mediators who may be thinking about using AI, and I know many mediators are, because there's a really good opportunity to have a lot of the analysis and potential ways of looking at what a good outcome would be through using AI, but one has to be careful about whether you're doing it in a way that compromises the privacy of the parties who are involved in the mediation. So what we're going to talk about today, how do you draw a line in the sand as we all seek to answer the question, just because we can do it doesn't mean that we should. And I think you'll find that in all cases, you may not want to. So I want to start with giving, artificial intelligence is defined in many different ways. And so it is useful to look at some of the ways and some of the vocabulary associated with what artificial intelligence is. So Oxford Dictionaries looks at it as the theory and development of computer systems that are able to perform tasks that normally would require human intervention, such as visual perception, speech recognition, decision-making, and translation between languages. Similarly, but not quite the same, Britannica defines it as the ability of a digital computer or a computer-controlled robot to perform tasks commonly associated with intelligent beings. Artificial intelligence is frequently applied to the project of developing systems that are endowed with intellectual processes that are characteristic of humans, such as the ability to reason, to discover meaning, to generalize, or to learn from past experience. So the next thing we're looking at is the vocabulary of what is involved with artificial intelligence. Some of the terms you will hear are ML, which is machine learning, DL, deep learning, GAI, generative artificial intelligence. Each of these have very specific meanings, and they interrelate with each other in terms of looking at how artificial intelligence works. So machine learning, for example, what is that? It is the process by which computers, including artificial intelligence, learn new things. People use machine learning to feed data to the AI and train it over time. This is a really important aspect of AI, and one that is probably most frequently discussed when we are looking at some of the issues that have come up. I am an intellectual property attorney, and one of the things that I have been very intrigued by is the intersection of copyright with AI. And most of the lawsuits that we are seeing that are trying to figure out whether artificial intelligence is appropriate under a circumstance comes up in the copyright arena. And it begins with this notion of machine learning. The process by which computers, including AI, learn new things. People use machine learning to feed data to the AI and train it over time. And what we are looking at right now are literally lawsuits by some of the biggest players in the publishing world, such as the New York Times, and in the technology world, like Meta and OpenAI, as to whether the methodologies that are being used for machine learning violate the rights of others. The next concept is deep learning. At some form of deep learning powers most of all of the AI applications we use. And many people don't realize, they've been thinking about AI maybe for the last 3 or 4 years at most. But if you think about what you encounter through advertising, when you go retail shopping, when you are looking at the Jumbotron at a ballpark, you are looking at all sorts of types of intellectual intelligence that have been in use and communications for years already. Deep learning, as I said, some form of deep learning powers most of the AI applications we use, and there are many such AI applications. But what deep learning is a subset of machine learning that uses multi-layered neural networks to actually simulate the complex decision-making power of the brain. Deep learning models typically use hundreds or thousands of computational layers to train the models, whereas machine learning uses just 1 or 2 computational layers. The computational layers use unsupervised learning and can extract characteristics, features, and data to make accurate output from raw, unstructured data. And the more computational layers that are used, the more intricate this can be. Another term to know is generative artificial intelligence. What is that? Traditional artificial intelligence is the theory of computer systems that can perform complex tasks. Importantly, it relies on explicit rules. Generative artificial intelligence relies on data-driven learning and probabilistic modeling to generate content, make decisions, or solve problems. And unlike the traditional AI, generative AI does not rely on explicit rules, but rather learns patterns and structures from vast amounts of data, which brings us back to that initial very complex question that's being litigated in courts from literally New York to San Francisco, is to what extent these rules are being developed using copyrighted materials. So we're at the point now where we understand machine learning, deep learning, generative artificial intelligence. Now you also need to consider how machine learning and artificial intelligence work together. Because for a computer to think on its own and to be able to perform complex tasks sufficient to become artificial intelligence, the computer must digest and internalize more and more information and logic over time. As the computer takes on more work, this machine learning enables it to become ever more intelligent. And this is how artificial intelligence understands and reacts to nuances and distinct scenarios. So the more information that it's fed, the better equipped it is to do this. But computer logic is only as sound as the data that feeds it. And if an artificial intelligence learns biased inputs, for example, we're going to talk more about that later, it will output biased decisions. And this is something particularly important for lawyers and mediators to understand. So how is artificial intelligence being used in law today? Is it being used? It is. It's being used in both law and in mediation. And it's being used to do things to help conflict resolution and also in practice. What percentage of a job can be automated by AI? That's one of the questions people ask. It can assist, it's a tool, but really it is a functionality to help you do your job, but it really doesn't replace the comprehensive formal legal training or legal skills. And if you've been following the news at all, you'll know that you can't rely necessarily on something that AI has produced based on a prompt that you give it to necessarily be an accurate report. It will come close, but it may rely on hallucinations. It may rely on a combination of data from a number of different sources and then put it all together as if it came from one authority. And so you need to be very, very careful when you're using it in law, in briefs, and also just to give advice and counsel to clients. And as I said, early and current use of AI is in the middle of a bunch of legal disputes, not only in the copyright and other areas that are more substantive, but also in connection with the use actually in legal disputes. And judges are taking notice, and many judges are formulating and including in their standing orders provisions specifically dealing with AI and disclosure requirements. So what are the best areas in which artificial intelligence can be used in law? Well, legal research, writing and drafting, clearly it can assist there. As part of the whole settlement and analytical applications that one uses in developing their strategies in a litigation, AI is great with respect to analytics and predictive outcomes, and I find it particularly useful in cases where you're trying to absorb a lot of arithmetic data, numbers, and that kind of thing. And it can be very, very helpful when you have a lot of complex ideas to have them synthesized and analyzed in a matter of seconds, when it will take you literally weeks of pouring through documents in order to get the same kind of insight into all of the data that you have. It's also very effective for electronic discovery and keeping track of what you have. Depending on the prompts that you give it and the structure that you use, you can identify very clearly things that might be confidential, things that may have to do with research and development, things that may have to do with attorney-client privilege issues. So it's very helpful that way. And additionally, it's also very good in analyzing and categorizing documents for you. It's excellent for data enrichment, for investigation, for compliance, and also for helping to draft particularly tricky settlement agreements. Who's using it? It's being used by lawyers. It's also being used by the lawyer's clients, and it's an important distinction to keep in mind.
That's the real reason they have not been made public. Have a nice.
External counsel, internal counsel, paralegals, employees and agents within companies and within law firms. It's being used by data scientists, privacy counsel, for legal operations, by regulatory compliance officers, human resource officers, and the list goes on. And the reason I make note of these different areas is because I want you to think about how it's used in these different scenarios and sets of circumstances, and what unique issues arise as a result. And we're going to talk about that as we go on and discuss ethical issues. So There are five, well, actually more than 5 rules that attorneys need to always be thinking about when you're using AI. But they can be grouped really into 5 key concepts: core competency, the duty of candor, meaningful supervision, the confidentiality and privacy aspect, and finally, data reliability and bias. And when we're looking at core competency, predominantly we're looking at Model Rule 1.1, duty of candor, Model Rule 3.3, meaningful supervision, Model Rules 5.1 and 5.3, confidentiality and privacy, Model Rules 1.4 and 1.6, but also you need to keep in mind, depending on the circumstances of your client's needs and your client's logistics, there are also increasingly more privacy statutes at the state level. There's only one right now at the federal level, HIPAA. It's been around for a while, but it's something that you also need to be thinking about depending on what kind of cases and legal matters that you handle. You also need to think about your clients who may operate transcontinentally, because there are also emerging laws. Some have been around for a while, but increasingly more laws of other nations, that when you are in an open mode and accessing literally information from all over, or maybe sending information all over, those aspects of privacy also may be governed in ways that are drastically different from the US by other countries. And then finally, I want to spend some time talking about data reliability and bias, which is also covered in Model Rules 2.1 and 8.4. So core competency is a rule that most attorneys are very familiar with. You're supposed to zealously represent a client, but you're not supposed to take on something that you don't have the experience or the background for. We all know that. I want to contrast that with meaningful supervision, Model Rules 5.1 and 5.3, because most attorneys, if they stop and think about it, don't know what these rules require. What they require, in the structure of a law firm, and this could be from the smallest of law firms to the largest super firms, where you have a hierarchical structure, where you have partners, where you have associates, where you have paralegals, where you have nurses and other professionals who help drive your cases and do the underlying work for you. It is required of you under Model Rules 5.1 and 5.3 to properly supervise the people who are working beneath you. And what you will find is that, unlike just kind of knowledge of law that you retain over time and you build that body of knowledge that the most senior partner may have, today, when you're looking at things such as working using the tools of artificial intelligence, you actually may find that your paralegals and your first-year associates, or even your law student clerks, have a better working knowledge and understanding of how AI works than the most senior of partners. And yet, those partners have to meaningfully supervise everyone beneath them and are responsible under the rules to make sure that what they're doing is appropriate. And so the question that comes up is, are you capable of doing that? Are you capable of being able, can all partners look at all associates and what they may be doing by using AI? And can they say they actually understand what the issues are that might have gone into the work that was being done? And that's where the duty of candor, the confidentiality, privacy issues, and the data reliability bias issues become so important. So For example, in the duty of candor, you need to be able to make sure that you are conversing with your client in a way that they can understand. And they may have better or lesser knowledge of AI. They may be concerned about use of AI before you do things with respect to AI when you're doing work for them. I recommend, as a best practice, that you discuss it with the client so that they know and you know whether you're using it, how you're using it, and how you're making sure that it's being used in a way that doesn't conflict with your other obligations to your client, such as confidentiality and privacy. And I want to give you one, which I think is one of the best indications, and we're going to talk more about the things that can go wrong later. But when it comes to confidentiality and privacy, something that's very important to recognize when you're dealing with AI is that every time you do a prompt, you are opening the door to providing confidential or private information of your client. And the reason I say that is because no matter how careful you are, you have to give a prompt to get a good AI outcome. You have to give the prompt sufficient information so that it knows what it's trying to analyze and synthesize. The more information you give it, the more you are creating a situation where possibly others will be able to see some of that information. And the best example of this that I can give you was not something that an attorney did, but it could have affected the company from a legal point of view very, very significantly. And it was done inadvertently by someone who should know better. So Samsung is an electronics company, great research development. They've been around a long time. They have many patents. I'm sure many of you have used or at least are aware of their products. And they are very, very strict about their research and development, and they treat that as trade secrets. So a couple of years ago, when everything was really first starting, where the first commercial applications using AI were suddenly available, one of their engineers who had been working in connection with new technology that was in the process of by Samsung and its attorneys to apply for a new patent regarding, decided to try to figure out what other applications they might be able to develop and invent based on this new technology. And he developed some prompts using artificial intelligence. But in order to really see how it could utilize that new technology, he had to put prompts in that contained that new technology. In doing so, what he inadvertently did was disclose the invention materials. They were lucky that the application for the patent itself had been filed with the Patent and Trademark Office the day before, literally the day before. He didn't necessarily know that because that was something the lawyers were handling. Had it been the day after, or even possibly the day of, but before the application was made, he had disclosed information that was part of the patent application that cannot be disclosed before an application goes in. They would have lost that patent. Now, what they ultimately still lost in some respects was the research and development that went into that patent, and just keeping that confidential for a period of time is important to companies that do a lot of R&D and are inventing new products. So even someone as skilled and knowledgeable as this engineer can run afoul and not realize just how much they are disclosing. So these are the kinds of things that you have to keep in mind, because if you are providing confidential information, you potentially could be committing malpractice, but you could also be running afoul of the model rules regarding confidentiality of your client's information. And now I also want to look at data reliability and bias, because that's something that is very hard to guard against. And it's hard as a legal practitioner to really do the due diligence you need to do to make sure that the data that you are getting is reliable and is not biased in some ways. And that is an obligation you have under Model Rules 2.1 and 8.4. So the first big issue, or I should say where these issues come up, is in customer service, chatbots, things like that, for example. Human resources, labor and employment, it comes up in hiring, productivity evaluations, compensation calculations. It comes up in intellectual property matters, such as I just mentioned with like the Samsung event. It comes up with privacy and data security concerns, and also with black box AI. So the first thing you're looking at is, are there algorithm bias issues inherent in whatever AI you're using? You need to ask, does the data set being used reflect the full populations? And there are many different AI tools and products that are out there. Copilot is one of them, but there are many, and law firms are exploring many different ones. What you really don't know is how the data set was developed. You don't know completely what's in the data set. And certainly there are going to be representations that are made when you're getting licenses or acquiring various products, but you need to ask and make sure that you understand how the data set was put together, what's in it. Were there permissions for everything that's in it? Or was it just, scanned, and are you going to end up with the kinds of issues that you have that are inherent in the New York Times case, for example, where they're saying basically that OpenAI went behind their firewall and literally gathered up every bit of copyrighted information that they have to be able to build their data set. But another key aspect of that, does the data set being used reflect the full populations of people? Because you need to understand how that input can create biased output. Historical data perpetuates bias. If the data set is based on history, how do we prevent the same mistakes from happening again? How do we avoid these algorithmic biases? So there's a great podcast by McKinsey called The Ethics of Artificial Intelligence that if you are interested in this area, I highly recommend. Diversity is the key, and not just diversity of the information that you are trying to gather, the prompts that you make, but the diversity of your team members, the mindset, personality diversity, the data diversity, and the diversity of algorithmic models. You may want to utilize more than one if you're seeking a particular type of an output. You may get different things if you're using different algorithmic models, either from the same company that maybe you're working with, or with multiple types of tools that are available to you. And you can't be afraid to ask when you're using these products or acquiring these products for background information on all of this, all of these different areas. And so, for example, if you're a litigator and you're working with jury consultants, make sure that what you want to know from them, not in an AI context, is the same kind of thing that you want to know from an AI context. Who do they use? Where has where have they researched? Where is their pool of mock jury members from? You also, when you're trying to make these kinds of inquiries through AI, which could be a faster, much less expensive way of doing it, you need to ask these same kinds of questions with respect to not only the algorithmic model you're using, but how you're developing the prompts that you're using. Who is contributing to the prompts and creating the prompts of your team members? These are all the kinds of things that you need to be thinking about when you are constructing your own models. The big question, though, is how can you verify this? How do you know the diversity of the algorithmic models? How do you know the diversity of the data? You can only control it really, to a certain point internally. And then you really do need to rely on the companies and the consultants that you may be utilizing. And you definitely can't be afraid to explore these issues with people who are working with you. So I also want to look at the privacy considerations that I want you to be thinking about. As I mentioned, we only really have the one big federal law. There are a lot of attempts by Congress to try to get something going, but honestly, neither the Senate nor the House has come up with anything that's going to get anywhere anytime soon. Meanwhile, other than HIPAA, which has been out there and we've been dealing with for a while, but let's consider the state privacy statutes, because there are many of them. California alone has 3 of the most restrictive, daunting privacy statutes. And anybody that's doing anything with somebody in California needs to know of them and make sure that you're complying with them. And that has everything to do with not only retaining data and information, but what you're keeping, how you're disclosing things, and people have the right to ask you to disclose to them what information you have about them. And a lot of people don't even realize some of the information that they may have. But in addition to the 3 major privacy statutes, there have been a series of new laws in California that deal specifically with AI. And so it's very important that you become mindful of these if you're dealing with clients who do business or are from California, or have some kind of a tie there. And you need to make sure that you're on top of that. There are also not just California, but I think there are at least 26 different states now that have statutes dealing with privacy, and some states, many fewer, that also deal with AI. And also, there are a lot of cybersecurity laws now that you need to think about. And one of the great places, I think, to start when you're dealing with cybersecurity is with your own insurance company. The legal insurers have rules and best practices that they have considered on in these areas, and it's very helpful to discuss with them their views on this. And I had mentioned earlier, there are also the foreign laws, the GDPR in the EU. Canada has some strict laws. India, Venezuela, more and more countries have have been enacting laws in this regard, and India actually went a step further and even enshrined privacy as part of a right of the nation's citizens for a right of privacy. So it's actually enshrined in their constitution. And of course, you really need to think about it and probably develop some new categories and labeling prompts in your structures when you're doing electronic discovery. And you need to also take that step back with electronic discovery and think about how your practices, even good prudent practices regarding electronic discovery, may impact the issues that may arise from the various state and national privacy statutes and laws. So let's spend some time talking about what can go wrong. And a lot can go wrong. You know, one of the things that we mentioned, what we just talked about, was what happened with Samsung. But there are a lot of other issues that we've seen over the last few years, which is leading to more and more regulation and guidelines from courts and within companies to deal with the issue of AI. So first thing that we need to think about is the risk allocation in terms of both who decides, but also who pays the price for AI that's gone awry. Who decides what is ethical in the circumstance? Is it the bar associations? Is it the courts? Do we need to rely on the model rules? Have the model rules caught up with what we need to have in terms of ethical analysis? Who determines the standard of care under AI? What is negligence? What does that look like? There are no bright line answers to any of this. I can raise the questions. I can share with you the anecdotal information about what is being argued in various court cases, but there's no bright line here. We don't really have any standards that can pave the way and say, yeah, this is really what the best practice should be. And as a result, who is responsible for artificial intelligence where there have been some issues with it can be easily very widespread. Who is liable when an AI system error falls below the standard of care resulting in damages? That's a tough question because currently we don't know when or how or why an AI system error actually falls below a standard of care, a particular standard of care. We don't know. We don't know what negligence is. There are some things that maybe we know, and there may be some other areas that we can consider as we think about it, just based on past practice and other developing areas of law over time. I remember as I started my professional life as a news reporter before I went to law school. And I remember in one of my first classes that dealt with the law of the press, basically, that who is responsible? The risk allocation could literally go from the paper boy who dropped off your paper and threw it on your lawn, up through the people who printed it, who developed it, who developed the story, who wrote the story, the reporter, the editors, the printer, and the distributor, the publisher. And depending on the wherewithal of these potential defendants, you would see everybody sued. You've got the same kind of a question when you're dealing with an AI system. The problem is that we don't really know what the standard of care is, and we don't know how to develop that standard of care. That's happening now. some of these lawsuits. You know, we're starting to see little hints of this and that, but nothing has really gone all the way through yet. So we really don't know. But think about who might be responsible. Clearly the lawyer who is involved in creating the prompts and doing all of that. But what about the AI developer, the process you're using? What about the system trainer, the consultant who recommended the system? All of the above? You also need to think about, depending on what kind of prompts are being developed and how you are going about using this new tool of artificial intelligence. And is anyone in the chain practicing law without a license? Remember what I said a bit ago, which is that with meaningful supervision, it's often the more experienced people within a law firm, the people who really know the law and have been practicing for years, they may not have a good grasp of AI. And so similarly, you may be delegating some of these tasks to scientists and social scientists, paralegals, people who you hire. People doing med mal, for example, often have nurses who are on staff to review different things. If they're using AI to come up with legal theories, are they practicing law? These are all the kinds of questions that you need to think about. So the best practice is for you to having trouble here. Bear with me. Okay. So what you should do is really consider certain questions before implementation of AI. You need to really think about, should you or shouldn't you do it? And so you need to start with the basic. What type of artificial intelligence will you implement? Are you going to do just basic AI or generative AI? What does the training look like? Who do you need to be involved with this? Communications, I very much recommend that right from the start, if you decide to use AI, that you answer these questions before you implement it, and that one of the things you do is develop an easily understandable audit trail and cover everything that you're doing. You need to think about oversight. What type of oversight do you need? Is a lawyer who works with AI sufficient? An associate who's good with computers? Is that sufficient? Probably not. Do you need a data scientist on staff? Or if not something that direct, do you at least need someone who's a consultant so that you could ask these kinds of questions of? Do you need an analytics director? Advanced training educator? You need to think about all of these different things and actually audit what they do, what data they're looking at, where that data came from, what data they're having to input to utilize the AI in a way that makes it valuable to the user of the AI, but also could be easily understood by others, including your clients, opposing counsel, and a judge, if ultimately you would end up in court. And as we were talking about earlier, you also need to think about, how is the training set that is utilized by the AI program you're using examined for responsible AI? So what are the steps that you need to do to go through that? So the best practices that I could give you at this point, really, the key is to think before you utilize it. Play with it, but don't put any confidential information in the beginning. Try it out first on things that you're not compromising anything for your client. Make sure, and you would probably want to include, lawyers should examine their engagement letters. Does it cover AI? Does it cover these kinds of issues? And when you're looking at that audit trail, you want to think about it from the first thought that comes in your mind about using AI. Has your client agreed that you can use it in connection with their data? And if so, what data is sacrosanct and cannot be used? All of these kinds of things as you go through the rules that I highlighted for you. The confidentiality and privacy rules, the data reliability and bias rules, the meaningful supervision rules, the duty of candor rules, all of these things need to be very, very carefully weighed. At this point, I think that we can open it up to questions or thoughts that anyone has. I don't know, Rob, were there any questions?
I do not see any, and if anyone has them, if you would just type it in the chat, that would be wonderful. And Marianne, if someone has one after we finish here, are you open to responding to emails?
Yeah, absolutely.
Okay, fabulous. Couple of nice comments about the program. Marianne, I just learned of something just the other day about AI that frankly shocked me. A lawyer sent me a link to a podcast, and the podcast was talking about mediation advocacy. And all of a sudden, there's two people, a man and a woman talking back and forth, and all of a sudden they say, and in Rob Litz's article in the ABA Just Resolution magazine, and they start talking about some of the content. And it went on for maybe 10 minutes. And I wrote back to the lawyer saying, what is this? Where did this come from? What it was is he took the article and used a Google product that will generate through AI basically an audio summary of an article that he had uploaded through Google. The whole thing was all made up completely. But it gave me pause to think about the power of AI.
So that is a really good example, and I can give you some more. And they're the kinds of things that literally, make my antenna go up and really keep me awake at night. What you've described is something that I'm seeing more and more, and I don't like, quite honestly. I think you have to be very, very measured about how you use AI, because currently most of the algorithmic models that are used take in so much data that it combines things. So at base, what you're describing is something that a lot of judges have been dealing with. And that is simply that people are having briefs written or letters, demand letters, and that kind of thing being written by AI. And it will cite precedents. And although there's some semblance of accuracy to the actual thought, sometimes there's not, but usually there's some semblance of accuracy. The problem is that they're putting it in words that weren't there, in cases that weren't there, and in judges who didn't write them. And lawyers are being sanctioned for this. And so now I have like one judge in the Central District of California in a case that I'm involved with there, where his standing order includes a disclosure statement that you have to make when you file a brief as to whether you used AI, how you used it, and whether you have fact checked and cite checked anything that you've said. So that's one issue along the line you're talking about. The other issue, though, Rob, to consider, it's like, congratulations and condolences. You made it, but maybe you didn't make it right, in terms of it not being accurate to what you said, which could potentially expose somebody to something. But you also have a question of whether there are copyright violations and that kind of thing. And actually, what you're talking about, I had one of those heart-stopping moments a few weeks ago. I was in a conversation, an attorney-client privileged conversation with a client about some very important issues. And they were really confidential issues regarding intellectual property. And when we finished the conversation, I got an alert with a summary of our telephone conversation that had been generated by AI. And it didn't just go to us, it went to some others as well. So we had that kind of an issue that we had to try to roll back some of those kinds of issues. And if you notice, anytime, at least for me, I have an Apple iPhone. Anytime I go to do something lately, if I want to make an inquiry, it's being done by AI. And there was always a concept of AI, but now it is bolder and it is being considered, it's being categorized, it's being chronicled, and you don't necessarily want that. So I'm actually reassessing anything that I do, have stopped using Google for anything more than where can I find something, and like retail or a recipe, because you just really never know what you're going to get or where it's going to go or how it's going to be used. The more I'm finding out, honestly, the less I'm inclined to use AI. That's the one danger, the downside of practicing in the areas. I'm seeing everything that can go wrong. Someone, I think, had a question or a comment about how our mediators may be using it. And I think that a lot of mediators are finding that they can use it very successfully to help generate different scenarios for settlement, that it can crunch numbers so much more quickly than most lawyers can do. You know, there's some great, mathematicians out there. I know I'm not one of them. And so it can really do a lot of analytical thinking, for us. And that's all good. We just need to be very careful about what data we're putting in and making sure that we understand how it's being used, where it's going, whether it's private. Yeah, but as I said, it is true, I think, that the more you learn about it, and maybe rightly so, the more you should be suspect about it, because it will make you stop and pause and look into whether there's a way that you can protect yourself, your client's data, and make sure that when you are using it, you're doing the best job you can to make sure you're not running afoul of anything that as a lawyer we have a duty to protect.
Marianne, there was a question. If I use AI to create an opening statement for mediation, what are the risks?
It depends what is in there. So if the risks would be that you are putting in a lot of data that may be confidential, so that it knows how to best extrapolate what you should be talking about. If what you're putting in is things that were on the record, open things, you know, the trial testimony, documents that are introduced. You're not going to run into that kind of an issue because that's where it's going to be drawing from. And it's going to extrapolate that and organize it and categorize it and all of that. So that is less of an issue. But if, as part of your prompts or part of your other data, you're putting in additional information that you think that the AI model would need to be able to really give it the proper shine or the proper interpretation, well, then you may be giving up some information. And you also, as a litigator, need to think about whether anything that you're doing through those prompts could look like an admission by your client. So that's how I would look at it. But if you're just dealing with things that are in the open record, I'm less concerned about that.
Well, it seems like we've had some dramatic changes just in the 2 years since you talked about this last with us.
Yeah.
And my guess is it's not a huge prediction to suggest that in the, let's say, the next 2 years, we're going to see some other dramatic changes. So the one thing I think I'll take away from this is stay tuned because it's changing all the time.
Stay tuned. Ellipses is definitely the way to approach it because we should have some idea of where this is going to go with some of the cases that are out there that have now been being litigated for over 2 years. We still don't have any bright line answers, but we're seeing some very interesting things happen in discovery of things people can get, what they can't get, that kind of thing. And so we'll be able to start, maybe we'll use AI to extrapolate the issues of AI once we start getting some of those decisions. But yeah, it definitely is a stay tuned period of time right now.
Very good. Mary Ann, thank you so much for enlightening us and giving this information and the update over the past couple of years. Folks, we are going to. So our next program, again, a little bit out of the ordinary for programs that we've had, and we're really thrilled to have Nicole Gorowski presenting on empathy-informed practices for the legal professionals. And I know it's going to touch on some trauma-informed issues and giving us a better understanding and trying to find out why people feel what they feel. And it helps us as lawyers to understand clients, opposing clients. It certainly helps lawyers understand the parties that we're mediating with. So Nicole is a seasoned litigator, former state and federal prosecutor. She's had hundreds of trials and has had a variety of experiences in private practice, both representing survivors of sexual assault and representing a business interests, banking interests. She is someone who literally can just walk in and try a case. And it's wonderful to have her as part of our lineup today. Nicole, the time is yours. Thank you so much.
All right, thank you. Thank you everybody for having me today. My name is Nicole Gorowski, and this is a presentation on empathy-informed practices for legal professionals. It could also be called trauma-informed practices for legal professionals. Some people don't like the word trauma because it sounds maybe like more than what we think of when what I'm gonna talk about today. So really, empathy-informed practices is probably the best name for this presentation. In some ways, it's called just, have good client relations, please, presentation. All right. So as Rob said, my name's Nicole Gorowski. I'm an attorney at Jenkins and Kling. Just a little bit more about my career to tell you maybe a little bit why I feel like I'm qualified to do this presentation. I spent my first 10 years of my legal career as a prosecutor, and I prosecuted crimes against children and sex crimes against adults. First, I was a state prosecutor, and then I was a federal prosecutor. Then I spent the second 10 years of my legal career representing victims of childhood sexual abuse and adult sexual assault in civil cases against large institutions. So I have 20 years of working with victims of some very serious trauma. Then I personally hit an emotional brick wall from vicarious trauma of, doing that for so long. And I did a complete 180 and went into business litigation so that, I'm not having the PTSD reactions of working with those childhood sexual abuse victims anymore. And I've been doing that for about 3 years. But what's interesting about the past 3 years of doing this type of business litigation is that I see some similar things in terms of representing the clients, which you wouldn't think I would, but I do. And so I kind of want to impart some of that to you about how to deal with clients with empathy, whether you're in the PI world, the business litigation world, defense world, or something else. One of the things that I want to talk about is how to work with clients who have suffered from some sort of trauma. And when I say that, I don't necessarily mean that it has to be something like childhood sexual abuse or something like being in the Army and getting PTSD. We, as humans, unfortunately suffer from all kinds of little traumas in our lives. And so everyone that you encounter may have something in their background that affects the way that they behave and affects the way that they come to you in your office. And so this presentation is really just a little bit about how to deal with that. And in general, these are just good client practices. In today's presentation, you should expect to learn some key assumptions about how to deal with people who maybe have gone through trauma, to learn about what is an empathy-informed approach and why is this approach important. We're going to talk about some of the guiding principles of an empathy-informed approach. We're going to talk about ways to adopt an empathy-informed stance with your clients, and then how to know you're on the right track. And then at the end, or even while I'm talking here, if you guys want to put questions in the chat, I'd be happy to take them. All right, our first key assumption is that individual trauma results from an event, series of events, or set of circumstances that is experienced by an individual as physically or emotionally harmful or life-threatening, and that has lasting adverse effects on the individual's functioning and mental, physical, social, emotional, or spiritual well-being. So basically what we're talking about are, the traumas that people have in their lives that, maybe something as serious as childhood sexual abuse, but maybe something and I don't want to say minor because I'm not talking about minor, but something that you wouldn't think of like some kind of family event. We'll be talking about racial discrimination as a trauma and how to deal with that. So talking about all different traumas that may affect, again, the way people show up in your office. This is a non-exhaustive list of types of trauma, but they're people who have experienced or observed physical or sexual abuse, emotional abuse, childhood neglect, having a family member with a mental health or substance use disorder, experiencing or witnessing violence in the community or while serving in the military, people who have experienced poverty or food insecurity, and then systemic discrimination and oppression is a type of trauma that affects people. And we'll talk about that a little bit more. I think people, a lot of people know what our typical response is to trauma. We've talked about fight, flight, freeze. Fight is, of course, that, you're going to fight back or that you may take some sort of an aggressive stance. Flight is, the desire to run away. These things are easy to think about when you're talking about maybe being physically attacked. You're either going to fight back, you're going to run away, you're going to freeze in the moment. But what about some of these other events that are traumatic, but maybe not physical kind of abuse. For example, someone says something directly to your face that is discriminatory. These same responses to these types of traumatic experiences can apply. You may argue, fight back. You may flee, in other words, just avoid the conversation and walk away. You may freeze. I often talk about, oh my God, I was a deer in headlights during that conversation. I can't believe that was my reaction, that I didn't say anything. But that's a typical traumatic response. One of the other traumatic responses that I think a lot of people don't know about is called fawn. I think everyone knows fight, flight, and freeze. But fawn is a reaction to trauma where you comply to get along. And I think that's a lot more common than you know. Think of someone who's in an emotionally abusive relationship, that maybe they, after years of suffering the trauma, just comply to get along in order to avoid that continuing abusive situation. They maybe can't feel like they can't fight or flee, but they comply to get along because it's what they've learned as a safety mechanism. And these things all apply on a level, even when you're not talking about physical or emotional abuse. You might be talking about, again, let's talk about that situation where someone says something horribly discriminatory and maybe they're in a position of power over you. Maybe it's a boss and an employee, and the boss says something very discriminatory, and the employee may engage in this fawning behavior, and it's complying to get along. This is a person in power over you. This is, I don't want to lose my job. I don't want to fight back. I don't want to flee. I have to come to this work every day, but I'm going to comply to get along, and maybe it's just going to keep taking this toll on me over time. All right, some symptoms of trauma, and again, this is a non-exhaustive list. But people who have experienced trauma may suffer from fear. They may be suffering from grief, depression, anger, changes in appetite, changes in sleep patterns, dizziness or nausea. And so sort of on the left here, these are the more things that you might think of. But let's think about some of the things on the right that maybe you haven't thought of, but you've actually seen it in people you've encountered and just not recognized it. People who withdraw from activities or people. People who are constantly reliving the trauma in their head. People who are avoiding the trauma triggers and reminders. Increased nervous system arousal. For example, a startle response that is triggered really easily, sometimes that arises from a trauma experience. And then suicidal thoughts and behaviors. I have, so I'm a childhood physical abuse survivor. It's part of this presentation is TMI about me, but that's what I'm here to talk about. So, I'm a childhood physical abuse survivor, not in my family, but due to anti-Semitism in the neighborhood where I grew up. There were some adults in the neighborhood who liked to, put me in my place when I was a young kid, and actually there was plenty of physical abuse that went along with that. And talk about some of the symptoms on here. So I think I have an exaggerated startle response. I certainly have, some of the effects of that trauma that affect me in my daily life. You might encounter me in court, or you might encounter me as a client, and you would have no way of knowing that, right? You would have no way of knowing what's in my background, but you might see some of these effects in my behavior. Another sort of one that I make light of is, for example, when I studied for the bar exam, to me, it was a pretty traumatic experience. And I threw my books after the bar exam into my trunk. And for another year or 2 years, I think, after I took the bar exam, I would not open my trunk. I just didn't want to look at those books. I didn't want to deal with the issue. And it was a traumatic experience for me. And so for 2 years, I drove around not opening my trunk, which is ridiculous. But I mean, now take that and put it into a much more traumatic experience where I grew up. what I just told you about my childhood, I avoid my old neighborhood. I don't ever go back to my hometown. I don't want to see it. I don't want to have anything to do with it. So again, these are sometimes behaviors you see in people and you don't necessarily know why. But we're going to talk about how to try to recognize and deal with those behaviors, whether you know that someone has a trauma in their background or not. And here's why. We basically have to assume that everyone that you encounter in life has experienced some sort of trauma. I know that's hard to think about, but it's true. You have to approach everyone as if there has been some sort of trauma in their life and that it has affected the way that they behave. And doing that will help you have an empathetic relationship towards them, especially when we're talking about clients. I want to tell a little story actually about a trauma experience that I dealt with a client. Obviously, when I was dealing with childhood sex abuse clients, I was dealing with people who were experiencing trauma all the time. And sometimes I would have those people in my office and they would be telling me what happened to them. And a lot of times I was the first person they were ever telling what happened to them. And people would start to, you know, rock maybe, or sway, or people would look out the window and not look me in the eye when they're talking. These are all things that you can notice in clients, that someone is having some difficulty with what's going on in their lives or what they're talking about. An interesting story was at one point I thought I wanted to do more general personal injury, and this was, you know, when I was struggling with you know, the emotional effects and the vicarious PTSD that I was getting from working with childhood sexual abuse victims over time. And I was interviewing a potential client about an auto accident. And it was a big trucking accident that happened. And I noticed that this guy started literally reliving it as he was telling me. He was telling me this story, and you could just see his body was tensing up and he was having trouble getting his words out. And I noticed this man is literally having a trauma experience right in front of my eyes. And so part of me wanted to know, how do I deal with that? How do I work with that client in a way that I'm not going to re-traumatize him? And how do we move forward in a client and attorney relationship? One of the things I want to talk about is, how does discrimination fit into this? And part of this presentation relates to inherent bias. And so I want to talk about, how does discrimination and bias fit into this? We need to recognize the pain and the harm inflicted by discrimination, and that it does cause trauma. You know, people who have experienced years of discrimination for whatever reason, they have the same pain and harm that causes trauma from other things. We need to recognize that we may cause pain and harm without even meaning to, and that's where these implicit biases come from. That, you know, we may inflict harm without even meaning to, and part of this presentation is to help us avoid doing that. And we need to recognize that discrimination causes trauma and the effects of trauma. Our obvious clients that have experienced trauma are attorneys who are sitting in this presentation who deal with crime victims, or who deal with maybe family law, or who deal with certain personal injury cases. These people think, okay, I may have to deal with a traumatized client all the time. But I'll tell you what, in my years of doing business litigation, I've had to sit with a banker who, you know, had a loan go bad, and literally every day since that happened thought he was going to lose his job and was incredibly traumatized over it. I saw the same effects in that person as I may see, obviously to a different extent, but the same effects that I might have seen in one of my childhood sexual abuse victims. What about the business owner who worked his entire life to, you know, create this business and then lost it all? And you know, lost his dream. Some of the same traumatic effects you're going to see displayed in those situations. What about a corporate trustee who gets cross-examined and is just terrified of the public speaking or terrified of feeling humiliated by the cross-examination? What about, someone who cross-examines by purposely using public humiliation? What about just the client who has to go through that, and how do we prepare them for that? What about the Hispanic employee who suffered discrimination at his or her last job and now just is, gun shy about the whole situation, and how do we represent that client? These are all different kinds of clients that you might encounter in your career, and you may not have expected that they were traumatized. So what is a trauma-informed approach? A program, organization, or system that is trauma-informed realizes that the widespread impact of trauma and understands potential paths for recovery. It recognizes the signs and symptoms of trauma in clients, families, staff, and others involved with the system, and responds by fully integrating knowledge about trauma into policies, procedures, and practices, and seeks to actively resist re-traumatization. So that's a mouthful. That's a lot of words, but what it really means is, we deal with a legal system, especially us litigators, but people in every type of helping field, which we're a service field. We deal with situations that may cause trauma. And so what we're trying to do with a trauma-informed approach to representing our legal clients is try to minimize as best we can some of those traumatic effects of the legal system that we're dealing with. Try to resist re-traumatizing someone by not being trauma-informed. So, part of the point is when someone goes through litigation, they've been through, there's a reason they came to us, and that reason may be a traumatic event. And it's our job to try not to re-traumatize them or make that situation worse. So basically what I'm saying here is, let's notice it. Let's notice when our clients have experienced trauma. Let's notice if the situation is one in which it may be traumatic. Let's notice it and let's address it head on. So why is a trauma-informed approach important? Well, it's important to avoid unintentionally re-traumatizing clients or exacerbating existing traumas. It's important because not doing so can get in the way of meeting your goals and representing a client. It can get in the way of winning cases because you haven't properly prepared your client. And it can get in the way of building a positive client-attorney relationship. Lastly, why is a trauma-informed approach important? Well, it's just the right thing to do. Partly this presentation could just be called, be nice to your clients, gosh darn it. As we know, the effects of trauma are sometimes not traits that we tend to love, right? So we may have people come into our office who have been traumatized and they're angry, right? It may not be a trait that we tend to love, but we need to understand where it's coming from, and we need to know how to work with it. We need to find a way to have empathy. Our clients, I've dealt with clients who have been traumatized who need tons of hand-holding. They just need constant contact and constant updates about what's going on in their case. And I've dealt with clients who have experienced even the same kind of trauma who disappear for months at a time and just can't even handle hearing about their case. We need to know how to deal with both types of clients, and we need to know how to deal with everything in between. I'm going to play you a little clip here. It's from a guy named Brett Goldstein. I don't know if any of you watched Ted Lasso. He was Roy Kent on Ted Lasso, and he's talking a little bit about this. So let me be quiet for a second and play the clip.
Every week, a guest draws a card from NPR's wildcard deck and answers a big question about their life. Brett Goldstein is best known for starring in and helping to create Ted Lasso and Shrink It. His newest project is an HBO stand-up special out this Saturday. It's called The Second Best Night of Your Life. He told Wildcard host Rachel Martin what he loves about performance stand-up.
It's not really saying, is this funny when you try something? What you're saying is, am I insane?
Based on the reaction?
yeah, if they laugh, it's like, oh, I'm not alone. You also think this.
Yeah.
Or sometimes, no, you are insane, but it's okay. We get it. If it doesn't work, then you go, oh, I am a very weird person. And that's a horrible thing.
Well, for his wild card answer, Goldstein told Rachel about how empathy plays into his work.
What did age teach you about love?
I read something that Steve Martin said that he found stand-up harder as he got older because, maybe not stand-up, forgive me for misquoting, he found the comedy part harder because he had more empathy for people, so it was harder to be me. And I guess that's where comedy goes. I think if you look hard enough at anyone, you can love them. And I do really mean that. I don't mean that in a cheesy way. I mean it like me at my worst. Like I'm saying this, I don't, want to hang out with people, but like, if you're like trapped with something like, this place is so boring, this place is so, that's on you. Like I have to ask the right question. And I'm sure there is a key to this person that if I ask the right question, I will suddenly be flooded with love for them.
Yeah, no. But can I nudge on that? How did you come to that realization?
I think I've had this cycle with people. I have it where I have it often, and I try to make the cycle shorter. But I've had it on jobs or something where there's a person that I will instantly dislike. Someone I'll be like whether they trigger me or something about them I find so annoying, or there's something about them like so needy. I don't know what it is. Something I'm like, getting this person away from me, and then something will happen along the way. A couple of weeks in, I'll see something. I'll see anything, and suddenly I will fight to death for that person. Like I'll be like, I have so much love for them.
Are you good at telling people after you come to that arc?
What do I go?
They thought you were in that.
No, they wouldn't. I hope they wouldn't know. I wouldn't say, I thought you were an absolute nightmare. And I was wrong. Because often they still are. I mean, there's a certain person where it's like, you are still a nightmare, but I've now found a way to have empathy and love you.
And they
you haven't stopped being an
about
animal. No, come on.
Okay, so that's kind of what I'm talking about. Let's try, sometimes the people who come to us who have experienced trauma are maybe not experiencing the most pleasant of traits. Maybe they're angry, maybe they're fearful, maybe they're someone that you feel like they're going to fall over if you touch them with a feather. But we need to find that way of dealing with that person, especially if they're our clients. So how do we do it? How do we do that? All right. So the guiding principles of trauma-informed care: safety, trustworthiness and transparency, peer support, collaboration and mutuality, empowerment, voice and choice, and cultural, historical, and gender issues. So these are some of the things I'm going to go over, but these are some of the ways that we can deal with our clients in a trauma-informed way. So these are my 6 ways to adopt a trauma-informed stance in dealing with our legal clients. Have transparency, have predictability, have client control, be reliable, have proactive support, and have patience. These are the ways to address these practices in our legal work. What's transparency? What do I mean by that? Transparency about the legal process and the work together minimizes feelings of powerlessness and strengthens the attorney-client relationship. So tell people up front how their case is going to go. Just talk to them about it. Tell them when they are going to make decisions and when the lawyer is going to make decisions, right? So that's, I think, where a lot of conflicts arise between attorneys and their clients, because you didn't tell them from right up front, these are the times that I'm going to seek your opinion, and these are the times where you're going to let me do what you hired me to do because I'm the lawyer. Let's make those boundaries clear from the beginning, and then let's not cross them. That's transparency. We're going to maintain open communication. We're going to be honest and truthful about all aspects of their case. We're going to set clear client and lawyer expectations and adhere to them. And we're not going to lead people on. We're not going to tell people from the beginning, yeah, I can do this thing for you. And then later, you can't, because the ethics rules say that we can't do that. You're going to be upfront from the beginning. This is an example of transparency that I'm talking about. So for a little while, I had my own law firm. It was called Gorowski Law, and I was representing victims of childhood sexual abuse and adults who suffered from sexual abuse. And I gave this handout at the beginning of representation with every one of my clients. And it tells them what to expect in my legal representation. This is how our case is going to go right here on paper. And I would email this to them and they could have it. So they could see, oh, this is the stage that I'm at. I'm at the negotiations mediation stage. Or this is the stage that I'm at. I'm at the lawsuit filing and conducting discovery phase. That's something they could refer to throughout and that they had up front to know exactly how that process was going to go. Predictability. When you're predictable and you're open and transparent about where you're going, it helps clients to feel safer in your hands. So help clients anticipate all aspects of their case at every turn so that they know what to expect. Routines create a sense of safety. So maintain an unconditional positive regard for your clients. We may have those, moments behind the scenes where we go and talk to our colleague down the hall and be like, oh my God, this client is driving me crazy. But don't show that to your client. Try to do the best that you can to relate to them on some sort of level. Just like Brett Goldstein said, I can find something that will make me love that client. Minimize the changes to physical environments of your office, and if they occur, explain the need for them to the client ahead of time as possible. If possible. So, this one might not be as important for, say you have a business litigation client or an insurance company client. This one may not be as important, but for a child sexual abuse survivor, it's incredibly important. Let's say a person is going to come into the office and sit down with me, and then the next time everything's different. It's off-putting, it's confusing, it's not predictable. The other thing is, let's say, for example, you're an employment law attorney, and you are dealing with a client who, has, let's say, they come from the LGBTQ community. And then you send them into your legal assistant's office to fill out some paperwork, and that legal assistant has cartoons up on the wall that have things that say negative things about LGBTQ. That's a physical environment that is unsafe for that person. And I'll tell you what, you might laugh because you might think, oh, when does that happen? Who's ever going to do that? That happened to me in a doctor's office, not the LGBTQ thing, but I went to a doctor's office. That doctor saw me. I didn't really love the doctor, but whatever. He sent me into his assistant's office to make my next appointment. And she had anti-Semitic cartoons up on her wall. And I'm Jewish. And I couldn't leave that place fast enough, and I never ever went back. So that's kind of what I'm talking about in, just be careful about the physical environment of your office. Minimize cancellations and rescheduling appointments. When these are necessary, provide an authentic explanation. Part of this predictability is just talking to people about what you're doing and so you're trying to stop their mind from running away with, oh my God, what is happening here? Is this a bad thing? Oh my God, I can't think. So for example, when I'm talking to a new client and they're telling me the story of what happened to them or what their case is about, and I am silent on the phone for, 30 seconds, they're sitting there thinking, is this person listening to me? Does this person care at all about what I'm saying? And so what I always say is, please just bear with me. I'm taking notes. I really am listening to you. That's what I'm talking about. Be transparent, be predictable. It's ways to make your clients feel more comfortable in the moment. Here's another example of predictability that I use with my clients. So for example, I have a client who's going to have their deposition taken. And I email that client and I say, hey, here's the date for your deposition. Don't worry, we'll schedule an appointment that you can come in and we can prepare you. And then what I was noticing after I did that was immediately after, the person could not wait for their appointment for me to prep them. They had a million questions. Well, what's going to happen in my deposition? Who's going to be there? How scary is it going to be? What's it going to be like? Well, so what I started doing was sending out this little video with my original email saying, you know, your deposition is coming up. And so it's trying to anticipate those needs. So let me play the little video for you. Oh, I'm sorry. You know what? For some reason, it's not going to play. Okay, I apologize. Let me tell you what the video says. The video is a 5-minute, very short video that talks about, here are the people in the room at your deposition. Here's where you will sit. Here's where the court reporter will sit. Here's where the attorney will be asking you questions will sit. Here's where I will sit. Here's what I will do during your deposition to make objections and things like that. And it basically tells them to relax. We're going to have another meeting that we're going to talk seriously about your preparation. But for now, here's a little look at how it's going to go. That's part of, you know, working with our clients in a predictable way. Wait a second. Okay. Client control. Allow your clients to have a voice in the decisions that impact their cases and their lives. This decreases powerlessness and increases mastery, but be clear about the boundaries and when there will not be a choice. Allow clients to have the opportunity to be heard. Give multiple options and choices to clients wherever possible, and fully explain the possible implications of each choice. Also explain when the client does not get to choose. So that's part of my example from earlier. Make sure that you're upfront about it. Look, you're going to get to choose whether you want to take this settlement or not. You're not going to get to choose my strategy in making the mediation opening statement. But let's be clear about that. Here are the things where you can be empowered by the situation, and here are things that I'm going to handle for you because you're in my hands and you came to me for a reason. Seek client feedback on how they would like to be move forward and what their goals are. Operate consistently from the mindset that clients are the best experts on their life and situation, and respond to them as such, while remembering that we are the legal experts and should advise those choices. Reliability. Being a reliable person in a client's life can build trust. Even minor accidents here can hurt trust and the attorney-client relationship. For example, not forgetting an appointment and not being there can break the trust that you have with a client. Be welcoming, respectful, and consistent at every interaction. Watch our own implicit biases, by the way. Watch what we say. We may deal with clients all the time who do not come from the same culture or same background or same socioeconomic status as we do. Be welcoming, respectful, and consistent in every interaction. Be on time to all meetings. Consistently maintain boundaries. Maintain physical boundaries at all times and do not touch clients. This one is very specific for representing victims who have been abused, you know, physically abused, emotionally abused, sexually abused. Don't touch them. I think that should be obvious. These are people who have been harmed by unwelcome touching. Don't reach out and touch them. That's not our role. But you know, some people are touchy-feely and they like to touch people on the shoulder. Those are things we have to check at the door because we need to realize who we're dealing with. So we have to kind of recognize the client that we're dealing with and adjust. Maintain emotional boundaries. When I first started as a prosecutor, I had a victim advocate who would come with me when I met with clients. And I'm embarrassed to say, for the young years of when I was a prosecutor, I would walk out and that prosecutor would tell me, it's not about you, Nikki. Stop telling them so many personal stories. Stop trying to relate by telling personal stories. We have to maintain those emotional boundaries, okay? We're here to help them. And so we have to keep those lines. Do not engage in personal relationships with the client. That should be an obvious one. Ensure the physical environment is well lit, open, calming. Make sure your physical environment is not something that's going to stress your client out. Also, it's not on the list, but return client phone calls. When your client is trying to call you or email you and you don't respond, that is a breach of trust. They start to think in their heads, especially someone who's been traumatized, their mind starts to wander. Why isn't this person getting back to me? What have I done wrong? Or what are they thinking about me that is going to affect our attorney-client relationship? Provide proactive support. Try to anticipate things that might come up in the legal proceedings that might be distressing to your client, and proactively work to provide support and resources to mitigate these things. So, for example, let's go to our employment discrimination client. If you're a plaintiff's attorney, let's think about the fact that this person may have to be cross-examined. They may have to sit for a deposition. Let's talk to them about that up front and tell them this is what's going to happen, but also don't worry, because these are the things that I'm going to put in place to help you. These are the things we're going to work through. Let's not let that person stew and fester the whole time about, oh my God, at some point I have to have my deposition taken and I don't know how to deal with it. Let's confront that up front. Same thing, let's say you're an insurance defense attorney. I don't mean to be presumptive that everyone sitting here is some kind of personal injury attorney. Let's say you're an insurance defense attorney. It doesn't matter. There's still somebody who's going to get deposed in that case who is sitting there stressing about it, I guarantee you. And this is a way of just kind of getting in front of that and dealing with it. Build and maintain relationships with therapists, social workers, and other key referrals. That's, for example, for our family law attorneys or for our personal injury attorneys. If you see that someone is going through a level of trauma in your representation that is above your pay grade, that they really need some kind of outside help, maintain good relationships with those kinds of referrals so that you can help your clients with the difficult times that they're going through. This is an example of the proactive support that I'm talking about. Again, this was when I was running my own firm representing victims of childhood sexual abuse, and COVID was happening. And so this was my email trying to get out in front of COVID. And I basically was telling everybody, hey, I know, and I sent this to all of my clients. Hey, I know that you're all concerned right now about COVID and everything that's going on. Here's what's happening in the court system that may affect your case. I want to tell you right now that we don't actually know what the courts are going to do. But I promise you that I will keep you informed as I get information. And here's what I am expecting to happen. It's that way of getting out in front of the stress and not making someone sit around thinking, why haven't I heard about my case in a million years? Something bad must be happening. Have patience. The range of trauma responses and symptoms that clients could demonstrate requires patience and a willingness to be present, patient, and available to them. This builds trust in the long term. Be consistent, calm, and non-judgmental in your reactions, regardless of how your client is presenting. Validation goes a long way, but let's be careful about validation. I used to tell my clients every 2 minutes, oh, I understand. I understand. You know what? I didn't understand. I had never been a victim of childhood sexual abuse. I don't understand. That was completely the wrong thing to say. You really should say, that makes sense, because it does. Move from, accusatory questions. Why didn't you run away from your abuser, to what happened, and tell me more about that. Same thing with if you have someone coming to you who's been through a deposition before, maybe, or cross-examination in a trial, and it was incredibly traumatic to them. And they say, look, I'm terrified of going through deposition or cross-examination again. Don't say, oh, it's no big deal. Talk to them. What happened? Let's talk about that. Let's work through that. Let's deal with that. When conflict does arise with your client, manage it calmly, assertively, compassionately, and while maintaining existing boundaries. Sometimes clients who have experienced trauma, especially racial trauma, childhood sexual abuse, any of those types of things, Sometimes they have, sometimes they might be quick to anger. Sometimes they might be quick to be triggered, to think that something is wrong in the relationship. We have to deal with that quickly and address it upfront, manage it calmly, assertively, and compassionately. These are some, key phrases that I think that we can move away from, not just in what we say out loud, but what we're dealing with in our thinking. When we have a client that is maybe constantly going to your boss and saying, saying negative things about you, and you're just sitting there thinking, my client always complains about me. Why is this client always complaining about me? Maybe we can change our thinking to think, what is it that I may not be anticipating or understanding about what this client needs that I'm not giving them, that they might be feeling the need to constantly go to my boss? And then, if you think a client is really annoying, instead of, thinking this client really bothers me, flip your thinking. This client really needs extra care, whether it be from me or maybe I need to recommend somebody. Maybe this is one of those situations where this is a person who is really struggling with the legal representation or their legal case. And maybe I need to refer them somewhere, or maybe I just need to switch the way that I speak to them a little bit. When you start thinking this person's behaving this way to annoy me, think about, are they having a trauma response? Are they having some kind of massive issue with going through this litigation that is affecting them right in front of me and I'm not recognizing it? So stop and think of the underlying causes of this person's behavior. So addressing discrimination with empathy-informed practices. Recognize that discrimination causes the same stress responses as any other trauma. I think that's key. So it's a trauma response. When someone discriminates against you, that's something that you feel to the core, and it is a trauma. And so addressing that type of trauma is the same as addressing any other kind of trauma, and trying to deal with it with these transparency rules, predictability rules, being open and honest, being patient rules. These are all parts of the same, they're all parts of the same issue. So addressing discrimination requires stepping into another person's shoes. In other words, empathy. Know your own blind spots. Know, for example, your office isn't ADA compliant, and know how to deal with that, and know how to meet somebody somewhere else. Know that maybe I have never encountered somebody who comes from this culture before. Let me ask a lot of questions so that I don't have these blind spots. Let me try to understand. Listen to your client when they're telling you things about, for example, their culture or what they're dealing with that you didn't know. Listen to what they're telling you. Pay attention when people tell you about their experiences. Acknowledge the impact of race and racism on legal outcomes. So you may have a client, maybe an African-American client, that comes to you that thinks that the judge is biased against African-Americans. Well, let's talk about that. Let's talk about how, look, there are some, there's data out there to show that sometimes that's true. And let's talk about how we're going to deal with that and how we're going to address it. Demonstrate compassion, not pity or saviorism, but a recognition of suffering. How do we put this into practice? Let's talk about the very first meeting you have with a client. Recognize the signs of trauma. They might be hypervigilant. They might avoid. Remember, I talked about the client that was looking out the window and not looking you in the eye. They might minimize what happened to them, or they might have a lack of emotion about what happened to them because it's so difficult to talk about. They might have a physical reaction when they're so nervous that they're rocking in their seat. Let's just notice those behaviors. They might dissociate, meaning that they might appear disoriented or zoned out. Notice those behaviors. They might be easily startled, afraid, or have some memory issues. Somebody might be telling something and they may have memory issues, and it's not necessarily because they have a bad memory, and it's also not necessarily because it didn't happen to them. I think a lot of us might think, oh, that didn't happen to you because you can't tell me all of the details of that thing. Well, sometimes that comes from trauma, and just recognize that. Be aware of triggers. Triggers like being made to retell a trauma. And so if you have a client who has experienced trauma and they're coming to you for help with that, try to minimize the times that they're going to have to retell that. Notice when there's sounds, smells, things that trigger people where they might feel vulnerable, uncomfortable, or unsafe. You know, recognize when someone feels manipulated. Don't manipulate your clients. You know, don't talk down to your clients. Make them feel like they are understood. Ask your potential client what their goals are. Tell the client what your role is going to be to help them get to that goal. Tell them what your abilities are and tell them what your limitations are. For example, this is a lawsuit for money. I can't get you X, Y, or Z that you're looking for. Tell them that up front. Like, oh, I just want an apology from that person. Well, a lawsuit can't force them to do that. But these are the things that we can do and how we can get you towards some of your other goals. Just be upfront about that. Be inclusive. Match the potential client's vocabulary. So if someone speaks a different way than you do, try to match that vocabulary. Try to use the words that they use. If they use slang that you do not understand, try to ask them what that means. Don't act bothered by someone's ADA needs. Show equal respect to everyone. Let the client tell you what they need to tell you. Then go back and fill in the details. So if you are talking to a client and they're telling you what happened to them for your potential representation, if you keep stopping them and say, wait, let me ask you this question, they may find that off-putting. Sometimes the client just wants to talk and tell you what happened to them. Write down your questions. Go back and ask them the questions that you need to ask, but let them get it out. Check in regularly to make sure that they understand that the advice that you're giving them, and explain your actions. Like I said, sometimes I tell them, I'm taking notes here, so bear with me. It's not that I'm not paying attention to you. Putting this into practice. In your ongoing representation, keep clients informed, be reliable, be protective in order to avoid re-traumatization. Don't ask judgmental questions. Why did you do that? Why didn't you run? Why didn't you do this? Why did you make that choice? Instead, ask, tell me about that. Tell me about that choice that you made and how you came to that choice. Try to be protective wherever you can. For example, agreements that I do my client's deposition at my office and your clients at your office, because my client is more comfortable with my office. They feel more at home there. They've now been there a couple of times. So know ways that you can protect your client and make them feel more comfortable. Know the deposition time limits or topic limitations so that you can protect your client in that way. Take the hits for your clients. So, for example, an attorney who's just bombarding them with questions about why didn't this get turned over in discovery? Why didn't that get turned over in discovery? Speak up and say, look, that's my issue. That's not my client's. Just be protective of your client who's going through something that is hard for them. Recognize needed breaks, especially during depositions. Watch your client, watch their behavior. Are they starting to rock? Are they starting to comply? Are they starting to have that fawn reaction where they're complying to get along and they're just answering spitfire, yes, 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 because they just want the deposition to be over with? Pay attention, call a break, take your client out of the room, give them a piece of chocolate, some kind of sugar, and tell them, look, this is the time when you're starting to just comply to get along and get out of this deposition. Let's stop, let's breathe, and let's not do that anymore. Recognize when you are limited and seek help. So recognize again when you need a break and make sure that you pay attention to that. I don't care who your client is. It could be a child sexual abuse survivor. It could be a CEO. It could be a trucker. It could be a business owner. They may need these things and you need to be able to recognize it. Depositions and trials are scary for everyone, regardless of who they are. And I've seen some of the toughest people just fall apart. So learn how to deal with it. Learn how to take those breaks. Learn how to tell them, take a breath. Give them a drink of water. It's one of the things that first responders do when they're first responding to a trauma is they hand that trauma victim a glass of water because it's something they can look at, they can focus on. It's real, it's tangible. So hand them a drink of water. Tell them before the deposition, if I see that you're starting to have an issue, I'm going to hand you a drink of water. Take a break. look at it, breathe. How do you know if you're on the right track? Well, you retain your clients and you keep good relationships with them throughout the duration of their legal cases and maybe future cases. Clients will give you good reviews. Clients will refer other clients to you. You'll maintain a strong reputation among prospective clients, and professionals who work with survivors will refer to you. Also, for example, I had some banking clients that had to testify in a criminal trial because someone committed PPP fraud. I had to work with them to prepare them for the testimony in that criminal trial. These were bankers. They weren't used to doing this. I utilized all of these practices in working with these bankers before I came and helped them testify in the criminal trial. We talked about what to look at in the courtroom when you start to get stressed out. We talked about how to stop, delay, think, then answer the question. We talked about if the cross-examination gets particularly horrible, how to deal with it. Look at me. I will give you a thumbs up. You'll be fine. Just keep breathing. We talk about all of these practices in preparing clients for testimony. All right. Well, I want to thank you so much for listening to me and my 2 cents, which comes from my experience over the years. These are the references for where I got a lot of this information. And this is my contact information if you have any questions. Also, I think we have about 5 minutes left for questions if anyone wants to ask me anything.
See what we have.
Rob, I'm having a hard time hearing you.
Can you hear?
Yep, that's better.
Very good. Okay. Question, do you find that you have different concerns or problems representing men who have been traumatized, especially physically or sexually abused?
100%. Men who have been traumatized, often experience and display that trauma in a different way. It's individual to everybody, but men different than women. Men have a harder time talking about it. Men have a harder time showing that vulnerability. Men have a harder time telling you, this is traumatic for me, I'm scared. All of those things that need to be recognized are really important.
So those were all the questions, but I had one, Nicole, to just kick around, and that is, it's one thing to have a better understanding when you're dealing with clients, but for the litigators, do you use the same techniques when you're in a jury trial, during voir dire, with witnesses in trial, especially when you have when it's not a client, but it's a third-party witness, keeping them calm in front of a jury if it's your witness, and making sure that you're explaining, just like you were with the deposition and who's there and what to expect at trial. So are you doing some of the same techniques for trial or for evidentiary hearings?
Yeah, 100%. I mean, when you're working with anybody, it's funny when you start putting these things into practice. It's funny how you start using it everywhere because it just kind of seeps into your DNA. Not only all of those examples that you listed, Rob, but how about opposing counsel? How about having respect, empathy for opposing counsel? I've dealt with plenty of opposing counsel that's mean, nasty, horrible to me. And you know what? I just take it in stride, take it calmly, try to recognize where they're coming from. They have a job to do. I have a job to do. Yeah. So you can put these things into practice in every part of litigation.
I guess our last question, any suggestions for assisting clients in mediation? Because that is something that 99.999% of America have never gone through. And frankly, the ones who have may have done it in a family law context, and that's a whole nother set of issues. Basically, is it like assisting clients for court? And are there things the mediator can do without overstepping bounds?
Yeah, I mean, so as an attorney preparing my client for mediation, I do it a lot similarly to the way that I was talking about preparing someone for a deposition. We talk about what's the room going to look like? How is that procedure going to go? I'm going to be with you in one room. The person that the lawsuit is against is going to be in another room. I describe that scenario so that there's no shock when they get there. I talk about, you know, you're going to hear some things that you're not going to like, and there are going to be arguments coming from the other side. We're going to deal with those things in stride. That's what their job is. That's what they're supposed to do, but we're going to know how to deal with them. Don't stress. So I think a mediator could do the same thing, you know, in coming into the room at the beginning and say, look, this is how this experience is going to go. I'm going to walk you through the picture. And things are going to come up. I'm not intentionally trying to say something that's going to offend you, but what I am going to do is pass on the information from the other side. We're going to deal with it. We're going to talk about it. You know, again, just that preparation is key.
Well, and one of the things we do in those kinds of sensitive scenarios is to make the inquiry in our call before mediation with counsel. You know, is this a case where we could have a meet and greet, or it's one where no, these parties cannot be in the same room? And I think that's important as counsel to share with us. The other thing you mentioned about no touching, would you recommend as mediators when we walk in the room, you know, one of the things I like to do is to shake hands with the parties. Is that something that we should back off of in your?
I think that's fine. I think it's also fine if you want to go, hey, is it okay if I shake your hand? You know, I think those are all fine. I have worked with an attorney before who used to, at the end of a case with childhood sexual abuse victims, would say, can I give you a hug? And asking, can I give you a hug is okay. Just saying, I'm going to give you a hug, not okay. Because this is a person who's been manipulated in a situation to have physical touching. So, you know, just being cognizant of that. Hey, can I shake your hand?
Great idea.
Yeah.
Nicole, thank you so much. This is really, it's important information. I know some of it is dense. Having those references that we can look at the end of your materials, I know will be helpful. And we really do appreciate you giving your time and your talent today.
Thank you.
Thanks. Folks, we're going to take our last break. And so this part of our program, avoiding ethical issues in mediation and arbitration, and we're so happy to have CJ Larkin and Kim Kern, two outstanding neutrals, both members of our Miles panel with years, decades of experience in ADR. CJ had taught for many years here at WashU, then left us and went off to Denver to head up the ADR program at University of Denver, came back to St. Louis. We're thrilled to have her. Kim has been a full-time neutral and frankly doing a fabulous job both in the mediation and arbitration area. Terrific neutrals, and we're thrilled to have them speak about this to us. They provided a similar program to the Missouri Bar Solo Small Firm Conference, and Kim and CJ, I understood there were somewhere around 500 in person and maybe 300 or 400 on video. So we don't have quite that many, but you're going to bring the day in, and we have an hour to go. Thank you, folks.
Thank you. We're so happy to be here. Happy to talk about avoiding ethical pitfalls in mediation and arbitration. So I have a show to put on. So let me get that up so we can all see it. Okay. Rob, is that good?
Looks great. Thank you.
Excellent. All right, welcome everybody. Well, we've got almost an hour to talk about ethics with respect to the ADR process. And let's get started. CJ?
Right, so we're going to talk about, of course, things from our point of view, since we do we work in this field so much as mediators and arbitrators, but a lot of our focus today is going to be on from the attorney's point of view. We're saying, so here you are, you're representing somebody in mediation. What else should you be aware of? We will also talk about what mediators and arbitrators should be aware of ethically, but just some guiding principles, right? As an attorney, we're guided by the rules of professional conduct. As mediators, unofficially, by the ABA model standards of conduct for mediators and contractual provisions, agency guidelines, state statute, court rules. If you're in Illinois, you have some other guidelines, more than we have in some ways in Missouri. But we are, for example, if you are an EEOC mediator, you are guided by the EEOC principles and ethical guidelines. So, and you'll be aware of that. Arbitrator, same thing, unofficially by the ABA model rules, professional conduct, contractual, agency guidelines, and state statutes, and also sometimes what is in the arbitration agreement.
All right. Sorry, hold on. There. So just quickly, we're going to go through a couple slides really fast just to give you some background, but remind you as an advocate, that your ethical obligations apply in mediation and arbitration, representing your client zealously, understanding confidentiality, not only attorney-client, but also confidentiality of the mediation practice itself or the mediation process itself. This is Missouri Rules of Professional Conduct. And, those same rules that apply to you in court apply to you in an ADR process. So we want to remind you of that. And there's a duty of candor, of course, as well as, all of the other duties that still apply.
So one sort of, we call this our puffery slide. And that is basically saying, as we all know, in negotiation, right, you may say this car is worth $20,000 when maybe it is, maybe it isn't. So you see here that 4.1 comments do say, estimate of price, what your real bargaining zone is, a possible agreement, those sorts of things. We know that's part of negotiation, and you're not, my client has a great case. Well, and they don't, but that's okay. That's sort of part of the selling of your position in negotiation, which of course mediation is a part of. So that's okay. Again, being careful though that you don't say my client has had 3 surgeries when they have not. That's clearly an ethical violation.
Yeah, so it's a little bit of walking on a balance beam between that puffery of, I tried this case 10 times, I'm going to win it 8 out of 10 times. Okay. And you might be challenged by the mediator on that versus, I like your example of there have been 3 surgeries. Well, there really haven't been 3 surgeries. Have there been any surgeries? Well, we're thinking about a surgery. So, that's, I guess, the dividing line, and you want to make sure you don't cross over that line.
So then what are some of the overarching guidelines for a mediator? Ethically, what are we tied to trying to do? Well, we're very committed to party self-determination. We want to be ourselves conflict-free and unbiased. That's important that we are that for you. Confidentiality before, during, and after the mediation sessions, which there are some challenges to, we'll talk about, and a quality dispute resolution process. And we'll say that sometimes self-determination and quality of a dispute resolution process, they come into conflict. And ultimately, frankly, usually the process concerns trump. And there you have, please don't bring a harpoon to a meeting with a whale.
All right, mediator competency. So we're going to talk both about substantive as well as process. So the first thing, substantive. Let's say you have an intellectual property case. Is your mediator competent in that area of the law? There are some mediators who would say, I'm a good mediator and I can mediate any type of case, regardless of the subject matter. And I actually fall into that camp. I think if the lawyers are good enough, you can tell me as your mediator about the case. And I'm no different than a civil court judge. Maybe, you're not going to get a civil court judge who's a specialty or a specialist in intellectual property. So I think there's some truth to that. But what I want you to think about is that sometimes there are contract provisions in let's say it's a contract dispute and there's a contract provision that talks about arbitration or talks about mediation and says, we shall have an ADR neutral with 10 years of experience in intellectual property. You better try to find somebody who has that. But I would tell you this, I think the parties can waive that if they both choose to in writing, but you want to make sure you do it in writing. And then in terms of process, that you have a mediator who's competent in the process. Do you have a safe place to mediate? Do you have a quiet place to mediate? Do you have a place where, for example, at Miles, we have, and most of you probably have been here, but we have many, many rooms, and we work hard to make sure that you are not next door to, or sometimes even close at all to the other side, because when you get in that room, we want you to feel as though you can speak openly and you don't have to worry about somebody overhearing you. So, someone who understands how to mediate, understands the process, understands the rules of the court that you are mediating through. And CJ, do you want to talk about temporary competency?
Yeah, that, and also, we're talking about this question of mediator competency. The mediator needs to self-check. Do I feel comfortable with this subject matter? And do I feel comfortable with this process? You mentioned rooms. Also, like if you're gonna have 10 at parties, are you used to, and can you handle multiple parties, lots of documents, those sorts of things? So that's the mediator's point of view, but it's also a point of view and ethical and responsibility of the lawyer. You need to be evaluating that mediator to see if you think they meet this criteria. And Kim and I talked about sort of temporary. Is this person generally has the competency, but are they right now? Kim, you had an example where you had so much going on and the case was so big, you just said, look, I can't take it this month, right?
Right. Because if you've got a trial date, August 1, and I'm booked, almost solid through June and July, I can't do it. So yeah, you want to look at, does your time frame work for the time frame the parties need?
And I think the lawyer needs to ask that. I mean, yes, you want the mediator to be forthcoming and self-evaluating, but you need to say, hey, so we're going to be doing this. There's lots of docs, or there's lots of time. How are you with time?
CJ, lately, I have had now a couple lawyers call me in advance of hiring me as a mediator and almost interview me, and I think what they're doing is trying to assess that competency. How many of these have you done? How would you handle multiple parties? And really, I welcome those conversations. I think the more we can talk and the more you can feel comfortable with me, both procedurally, what I'm going to do, but also, substantively, the better we are before we start the mediation. So that's been an interesting thing. In fact, in one case, I had to do a formal interview.
Wow.
Yeah. Okay, let's go on. So this is one of the mediator standards, and the thing I want to focus on in this is that party self-determination. When you come to mediation, we want the parties to be making a decision that they themselves are participating in. And this is an interesting point. They have done studies and they have asked parties, how satisfied are you with the outcome of your dispute? So they do that after the party wins in trial. They do that after the party loses at trial. And they do that after a mediation. And guess who's the most satisfied with the outcome? The parties who mediated, because they were able to have that self-determination. They were able to be more involved in the process rather than turning the decision over to 12 uninterested strangers. So I think somebody asked me yesterday about, well, why would a lawyer ever push his clients to go to mediation? because clients are more satisfied with a mediated result. Isn't that interesting?
Yeah.
Okay, problem. Non-disclosure or misinformation. So when we talk about self-determination, one thing that has to happen, of course, is that clients need to have accurate information, but they also need to have as much information as we can give them. And this is kind of what we were talking about before, about the difference between puffery. You know, this is a great case and my client is going to be a great witness. And this happens to me. And then I go in the other room and the other side says, oh, when the plaintiff gave the deposition, they were terrible. They were too emotional. Nobody could understand them. And it's like, wow, was it the same deposition? Because each side tells me they think it went great. So clearly, you know, there's some puffing going on, and that's okay. I expect that. But what we don't want to do is cross over to, you know, any kind of false information. And one example that CJ and I have experienced is I had a case one time where I had a senior partner and a junior partner, as well as the client. And the senior partner had mentioned to me that he thought he was going to have to leave early, which is fine. You know, he left somebody else there in charge. And these days, actually, with mobile phones, text messages, Zoom, everything else, you know, we can easily reach someone even after they leave the mediation in person. So he left, and on his way out, he said, Kim, don't tell the other side I'm leaving. Well, guys, we no can do. You cannot ask us to do that. Now, in that one, it happened to be easy. I'm like, you know what? I already told them that you were leaving. I'm sorry, you didn't, you know, this happened a while ago. So that's that balance. We don't want you to get out of balance on that. All right.
If I could say, I want to say one more thing about that last slide. You don't need to
Sure.
go back, just talking about truth. And that is if there's some factual information that you give that is incorrect, or you're saying, let's say family mediation, and you're saying, let's talk about 50-50 parenting, but I'm moving to Alaska in two weeks, but don't tell them that, right? So that is an ethical violation, the creation of an ethical violation for the mediator, because you know that is a substantive fact that is being denied, or the implied is, oh, we're going to keep living here and doing this 50-50 mediation. So what it does, and sort of what the tripwire is, self-determination. If I continue to mediate with that party and not tell them, and in 2 weeks the whole scenario is going to change, I am, you know, perpetuating this decision that they're making with bad information. Now, what will happen is then that I'm in a difficult position. Do I have to end the mediation? Do I have to say, please, I think you need to share that. It's going to come out anyway. I can try to persuade, but I will be in a position where I'm not going to keep talking about this 50-50 mediate, you know, parenting time when I know that you're leaving. So you've created a problem. And I've only had it happen a couple of times. It doesn't happen a lot, but we can point to self-determination as the ethical requirement that's being violated when there's misinformation.
Well, and you know, if you're asking me to blatantly lie to the other side, then isn't the reverse true as well? That if the other side asks me as your mediator to lie to you, and I agree to that, then all of a sudden we don't have a candid, open, truthful session. So we gotta be able to have and this is the only way mediation works, if we're able to have a meaningful, deep conversation about some very tough things. And I think that's part of, you know, sometimes people will be like, I don't know how you did that. It was magic. The magic is having those important, deep conversations with a neutral. I don't have a financial interest in the outcome, and having those really important discussions and trying to make the best decision you can make. And you know, CJ, I love that idea of ultimately, you know, I may have to say, we've got to stop this mediation because if you're not going to be willing to amend your behavior on this, we're not going to be able to go forward.
Right.
Wrong way. Sorry.
But
there we go.
So we wanted to talk about mediators' proposals a little bit, and part of the reason why is that it's really somewhat controversial. There's some people who have particularly loved the facilitative mediator, you know, kind of just helping people describe things versus people who are very evaluative. So there is a little bit of a discussion that has an ethical stylistic part to it. But also and Kim mentioned that more and more we're having people in our mediations, one or the other, who said, "Oh, I've never done that before," right? So we'd love it in the chat if you'd answer 2 questions for us. This is, you know, do you use or when you're an attorney, do the mediators use mediators proposals, and do you like it? Has it been helpful? We presented yesterday at the Missouri Bar solo and small firm, and we had mostly people liked it, but we had a couple people who were like, they were gruff about it. So anyway, let's go through it just to make sure that you're completely clear on what we're talking about. So this is when a mediator proposes a settlement number. Normally it's a number. Sometimes it can be also other terms that and this is not at 10 o'clock. This is like at 3 o'clock, right? Or 4, when things are just, you know, we've reached impasse. So they are going to propose a number that they think they might present or calculate as the likely outcome at trial, a compromise between the last 2 final offers you all have given, what is correct and fair. Now that's really controversial. What the mediator thinks the party will accept, what they think is a stretch for both parties, but let's move it, right? Let's move it along. And usually involves some kind of blind response. I'm going to come up with a number. I'm going to give it to both of you. You either you know, agree to it or you don't agree to it. And if you both agree to it, yay, we're there. So for attorneys, I love that picture, Kim. So attorney concerned about what time it is. Oh my God, if it's 7 o'clock, you're in trouble. Part of it is what you need to think about ahead of time as an attorney is, when do I want this to happen, right? Do I want to tell the mediator ahead of time, I'm open to this, you know, if we get, you know, in another hour, or maybe at 10 o'clock, you say, look, if it gets to be 4 o'clock, go ahead and do that, right? The question is, are you asking for legal opinion or advice? Is it going to be contrary to yours? You know, where are we going to go with that? Does it undermine the mediator neutrality? Is it like, well, now, you know, particularly for your client, are they going to not like them anymore? They're going to be like, where'd they come up with this? We shouldn't have to pay that much money. And it can really mess with a good vibe that you've had going ahead of time. A concern that I think the mediator needs to be aware of, and I also think that attorneys are sometimes concerned about, is are you revealing confidential information from us in coming up with this number by even saying this number? Are you revealing something that happened in the other room? Where are we? And the other part is the proposal process, right? So you do that, you put out the number, both accept, okay, then where are we? If one accepts and one doesn't, if neither one of you want it, what do we do next? Do we stop? Now it's interesting because the gruff person yesterday at the bar said, well, and then what tends to happen is if it isn't accepted, the mediator says we're done. Well, why are we done? Why isn't this just a point where we can go ahead? So we've talked about this. Discuss ahead of time if you're open. Suggest timing. Make sure that they understand, you know, what you will do, like what the next step is. And if it's going to be if somebody rejects it, was supposedly supposed to be a secret, and you know, but if you accept it and the others and you don't have a deal, then you know that the other side rejected it, right? Just say what should we do? And I think my sense is this attorney from yesterday would probably have said, just take that as a point of information and let's keep going, right? The fact that you thought this was a good number, let's digest that and keep going.
CJ, when I do a mediator's number, I take the position that this is a number I think has a chance of succeeding with both sides. It's not my evaluation of what your case is worth. I would never do a mediator's number if I didn't feel like the parties were in a range of, they were close enough in a reasonable range to make it work. And because I have heard people say, well, once you give that number, my client all of a sudden thinks that's what their case is worth. And so you want to be careful about that. And I really try to make a point of that. This is not me and I'll say to the client, this is not me opining what your case is worth. Rather, you guys are in a zone, you're in a range that I think is reasonable, and this is a number I think has a chance of success. And I found that that helps me with that idea of alienating one side or the other.
Yeah.
Okay. Do you want to talk about this one?
Sure. This is confidentiality responsibility, and Kim and I'll do a quick example, and then we have another one that we want to explain, and that is whose job is it, right? Whose job is it to make sure everybody understands and adheres to confidentiality, all right? It is the mediator's job, one of their jobs, to explain confidentiality, and particularly like, oh, you may have to call somebody from your office, or after we make this decision, who's going to have to know. So the mediator will do some, let's look forward, who needs to be notified and who might we need to seek approval or information from. True, that's the mediator's job. But after they've done that, it is not their job to police it. It is not their job to make sure everybody really gets it. It is also the attorney's job, right? And so it can be difficult when there are multiple sessions or day-long sessions. I used to do a lot of sort of early employment mediation, and we would meet several weeks, and then so there's lots of opportunity for people to divulge information that they shouldn't, right? But there are not very many lawsuits involving mediators, but there was an interesting one in which a school in Florida, there was a headmaster who was fired. There was a successful mediation in which he was given a pretty nice settlement. Of course, confidentiality was reigned, right? And the headmaster's daughter, who also went to the school, posted on social media how, thanks to this, that Dad did great. Thanks to this, we're going to Europe for vacation, right? So it was, and the challenge then became the settlement was thrown out, and the attorneys, as I remember, tried to the attorney for the father tried to blame the mediator. The mediator didn't really make sure this didn't happen, and the court said, it's in the agreement. Everybody, there we are. It happened. You needed to make sure your client understood that a third party, the daughter, should not convey any information. Kim, I think you know a little bit more about that case.
Yeah, the daughter, the thing that makes that one really interesting is that it was a Facebook group, and the Facebook group focused on the school, people who had gone to school there, employees of the school. The daughter had graduated from the school. So when she posts it on that Facebook group, I mean, she's putting it out to the world, but she's also this very knowledgeable group all found out what happened at the mediation. And, not only was the mediation itself confidential, but the agreement was confidential. And the court threw out this agreement. So, no trip to Europe for them. So social media has really changed what we see in terms of confidentiality. And I know you guys all have somebody in your family or friend group who post a lot on Facebook or on Instagram or whatever they like to use. But you really want to be careful about that, because it is no longer a he said, she said dispute, because it's out there. And I have had plenty of cases where there have been some social media postings about the case, and that will come up, and people will want those taken down. And this has changed, I guess, how we view the dynamics of the mediation itself, but also the aftermath. All right, this is a case I think is a really interesting one. As CJ said, there aren't very many mediation lawsuits out there, but this is one of them. So plaintiff had been a member in a private club. I think his membership was revoked, and he sued under the Americans with Disabilities Act. They went to mediation. Mediation failed, and plaintiff leaves and then emails a ton of the people at the club telling them what happened at the mediation, including what kind of financial offers were made and demanded. And, the board members who participated in the mediation were furious that he was so blatant in just ignoring, you know, the confidentiality of the process. So they went to court and asked for sanctions, and boy, did they get them. The entire case was dismissed. Interestingly, this case was authored by Neil Gorsuch before he went to the US Supreme Court.
So who needs to be at the table? This is another point that the mediator ends up managing, right? But the attorneys, you need to be aware of who needs to be there, like if they're missing, it's a problem, and also who shouldn't be there, who's going to try to horn their way into the conversation. This happens particularly on Zoom. So it is a question, it's a question for the mediator, but it's also a question for the attorneys. So this is a case in which this is a case of somebody who wasn't there that should have been, right? And it's where someone, a defendant did not bring their insurance representative because they thought their SIR covered it. You know, not big enough. You know, we don't need, we're covered. We don't need to have them there to attend. And so plaintiff made a demand that was fairly big. Defendant made an offer which was fairly small. And because of the chasm between the parties, that's the reason that the plaintiff ended the mediation and the absence of the insurer, right? And so both sides filed motions for sanctions.
All right. So that case was pending in the United States District Court, Eastern District of Missouri, and it's the Montoya case. We've given you the site. In this case, defendant was fined, was sanctioned for not bringing the insurance rep to the mediation. And the interesting part on this one is that the demand was higher than the self-insured retention. So when defendant made that decision that I don't need to bring my insurance rep because this is going to be within my self-insured retention, they ultimately, you know, sort of put a ceiling on what they were ever going to pay. And the court found that that was sanctionable. So plaintiff was not sanctioned. They were admonished for not staying a little bit longer. This mediation ended pretty quickly. But the thing that's interesting, I think, about this one is it really lends us to think about what is the best practice. You know, I think it's always important for us to talk, and we're going to have a lot of slides on best practice, but sometimes when we talk about ethics, it's not just thou shalt not do this, but what is the best practice? What should we be doing? And here's what I like to do. If I can do this, this is where I want to go. I want to have my plaintiff make a demand in advance of the mediation. Critically important if you're talking about big dollars and there's insurance involved, because you want to make sure you have the correct layers of insurance represented at the mediation. It's just good common sense. It's good business sense. But ultimately, you know, if you're trying to settle your case, you want the right people at the table. And then I also not only want my demand, but I also like to have an opening offer from the defendant before I start the mediation. Therefore, I've set my ceiling and I've set my floor, and we can move a lot faster at the mediation. Now, sometimes defendants don't want to do that. They want to make their first offer at the mediation. And you know, that can work too. But I do think best practice is to have both a demand and an offer before the mediation starts. Oh, another funny part on this case is if you ever read the decision, Judge Fleisig orders the parties to spend as much time mediating as they spent writing their briefs on why each other mediated in bad faith. Okay, so best practice. You know, this is still in that line of discussion of who needs to be at the mediation. So in my prep, I always ask who will be at the mediation. And if there's anybody other than, you know, the client and the lawyer, I want to make sure I tell the other side who's going to be there. Is the client's spouse going to be present? Is the general manager going to be present, or the CEO going to be present? Who's going to be there? And make sure that everybody is cool with that. Now, I like having, for example, the spouse, I'll use that. I like having the spouse there because if my plaintiff is going to call her husband in the middle of the mediation and say, hey, they've offered me $100,000. Should I take it? It's really easy for him on the other end of the phone to say, hell no, to say, no, that's not enough. But if he's been in the mediation and has heard the lawyers, has heard me, has, you know, suffered like we all have suffered, he's much more engaged in giving a real answer. So I like to have those people at my mediation, and, you know, I like to have them involved, and I want to make sure the other side knows that they're going to be there.
Okay, so we wanted to highlight, and we're just going to kind of go through it briefly, but just to make people aware that family mediation is a different beast, okay? And there's some special aspects to it that are different than just a civil case. That the mediator is supposed to actively help people consider the best interests of the children. If there's child abuse, neglect, domestic violence, the mediator is supposed to adjust that, maybe cancel the whole thing, or deal with safety issues, or talk about empowerment issues, or imbalance of power. But that's something they have to actively, they have a duty to do something about, and terminate it if they think people cannot participate and go forward. And this is something I've never been asked to do, and I don't know anyone who's been asked to do, but it's possible they could be asked to testify regarding post-mediation actions if settlement is challenged. And I think the reason for that is in Missouri, the majority of the time, lawyers are not in the mediation. Colorado, where I also practice, lawyers all the time. So I think part of it is that what happens after the mediator's helping it be managed. If it goes awry, they kind of want to say, did they sign the document? Is this what happened? Now, I haven't been asked to do it and hope to never. The next thing is a little bit about, there's additional training. It's funny, as a Rule 17 mediator with 17 hours of mediation training or whatever it is, and no educational requirement, you can do $3 billion cases, right? That's not a problem. However, if you're going to do custody, man, you better know a lot more. So a lot more requirements. You have to be an attorney or have one of these graduate, you know, sort of, what do I want to say, human services and health sort of issues, some other degree. You have to have 20 hours of child custody mediation, DV, power imbalance. You have to know, so that's like if you are a lawyer, you need to know that sort of social work aspect. If you are a social worker wanting to be a mediator, then you have to show that you know all these other issues about how child support's calculated, etc. So what they want is a mediator who's both, really has some social work knowledge and also legal knowledge. So for you, for the lawyer, you need to, I mean, if a court gives you, if somebody's on a court list, they meet the qualifications, right? But sometimes you'll get someone who you don't know, or your client will choose someone. Make sure they meet these qualifications. The court will not throw out your mediation agreement because this person didn't meet these qualifications. But if they do a terrible job, it's kind of up to you that you haven't selected well. And you need to be able to prepare your client. Hey, this is a little different. They have this role, they have this duty about best interests of children, appropriateness of continuing it. They could stop your mediation if they think it's bad enough, if there's some imbalance, right? And the whole testifying afterwards. We just want you all to be aware of the fact that there are additional confidentiality requirements in federal court that are about reporting if people attended. You know, the mediator report, did they attend? Did they fail to negotiate in good faith? Same thing with Western District. They want to know the length of the mediation, who came, what kind of session was it, etc. So the court orders you to it and wants you to do something. The most famous case in the Eastern District is Gigi Nix, where there was a sort of one of the parties really challenged whether the other party bargained in good faith. And that can be a really nasty, contentious discussion, you know. But the ended up in that case in Gigi Nix, ended up being sanctioned. So the court, and it's all really about judges. They're like, I told you to go do this. You better do it. And if you don't, your mediator may tell on you, which is a very uncomfortable position for the mediator to be in, of course.
CJ, that Gigi Nix case is an 8th Circuit case, right?
I think that's right. Yeah.
Yeah, it went up from here. And what I find is for out-of-town lawyers, our rules sometimes can really come as a shock to them because different federal courts have different rules. Now, Southern District of Illinois also has a reporting requirement. So we're, in a way, we're lucky because all the courts that we here in St. Louis tend to work in a lot have very similar rules with respect to reporting. But I do a lot of work with a group called Association of Attorney Mediators, and they're out of Dallas. And these guys in Texas go crazy when they hear that we have to report back to the court. They're like, no, you can't do that. Like, well, our local rules have it and they've been there for 20 years. It's not a new thing. I use this really, I think, to make the mediation a more effective process. So I want to make sure that everybody knows it, especially my out-of-towners. And if there's even a hint or a whiff of somebody saying they're not negotiating in bad faith, I want to immediately shut that down if I can and make it clear to them why I think both sides are here in good faith. I've never had to report anybody in bad faith. Man, I came close once. So this is a case, this came out of Kentucky. And in this case, the mediator was, going full steam with the parties. It happened to be a family law case. Both parties had lawyers at the mediation. But, the day became late and the lawyer said, I got to run to the bank. Do you guys mind if I'll be gone 45 minutes or whatever. I got to run to the bank and I'll be right back. You keep going without me. So they said, okay. So a tax issue came up while the lawyer was gone. And apparently the information that was conveyed ended up being inaccurate. So lawyer comes back, they mediate a little while longer, they negotiate a little while longer, they get an agreement. Now this is the term sheet. They write it up, the lawyer signs it, the client signs it, but then it turns out that this tax information was wrong. And so no final agreement was ever written up, and they went to court on a motion to enforce the settlement. And the court said, no, we are not going to enforce this agreement, and that the mediator should not have proceeded with the mediation in the absence of the lawyer. And it was unconscionable to continue the mediation. All right. We're going to change now. We're going to change gears and talk about arbitration. This is kind of the other side of the coin of ADR. And, much like mediation, those same rules apply. Those ethical rules apply in arbitration, much as they would in court or much as they would in mediation. What is our prime directive? I love my shark on this one. So once you go through the arduous process of having an arbitration and paying for your arbitrator and, preparing your documents and everything else, and your arbitrator issues an award, we must protect that award. We don't want that award to be overturned. And as you guys probably know, there are very limited grounds for appealing or for having that award overturned. So your arbitrator is going to have that in their mind the whole time. What is my prime directive? It is to protect the award that I'm going to issue. And I've had awards challenged in court, and it's very, I didn't like it. And luckily, as far as I know, every award I've ever issued has been upheld, but let's try to keep that streak going. Here's the biggest mistake that you can make as an arbitrator or a mediator is to have any financial interest in the outcome. So if I'm a practicing attorney and I've represented someone, and then later they want me to act as a mediator in that same dispute, I think that's the key there, in that same dispute, I cannot do that. Okay. And the reverse is true too. If I've acted as a mediator, I cannot then later take off my mediator hat and put on my advocate hat and become involved in that dispute. So Can I represent the client later? Yes, but you'd want to make sure that's a totally separate matter. And where this comes up, I think that's more of an issue is in rural areas where there are not as many attorneys or as many mediators practicing in the county. So you want to be careful about this, because this is an easy way to have the award thrown out, but also to have disciplinary complaints against you. So good one to make sure you avoid. And I use fireworks because this would be fireworks. And then this is just a quote about serving as an arbitrator in which you have any financial or personal interest in the dispute. And I always, we talk a lot about conflicts and disclosure. Really important as an arbitrator in advance of the selection process. And then once you're selected as well, to make sure that you've disclosed just any and every conflict that you can think of. One thing that we get involved in a lot when I'm on a 3-member panel is that perhaps I have served with my fellow arbitrators previously. And that's something that they want us to disclose. To me, it's like, well, why is that important? But nevertheless, they make a really big deal about that. We are supposed to disclose if we've ever served with the arbitrator before. Of course, we disclose whether we have worked with the lawyers before, but it's a little broader than that. Okay. This talks about disclosure. You want to make somewhat of an inquiry before you get involved in the case. Who are the parties? Who's going to be showing up for the arbitration or the mediation? Who are the witnesses? That's an important one. You want to make sure that you've disclosed all those conflicts and, not only just people, but also knowledge about the dispute itself. And where this came up, this is interesting. Do you guys remember when Puerto Rico had all of the power outages, and there were a lot of lawsuits over the bonds that had been issued to build up or to originally build their power grid? And I think they defaulted on some of those bonds. And it became a very big financial and they all had arbitration clauses. And so not only was it in the news, but a lot of the panel of arbitrators were all involved in other cases in Puerto Rico, and so you want to make sure you disclose that. CJ?
So another issue is delay, and everyone's participating to not, I think what Rob Litz says, arbitration is supposed to be cheaper, faster, and there's a third thing, easier, better, private. I'm not sure what all the good things, but faster is definitely one of them, right? So basically the idea is we're talking about it being like, let's cut it down, right? The idea is that the arbitrator has the power, part of their job is to push things, is to make sure that people meet the expectations and the timing, right? And so sometimes they have to balance that though against your client getting to present, to have the discovery they want. So that's a tension, right? It's sort of self-empower versus process again, right? But that's part of, but the arbitrator's job is to try to make sure the case moves along. So AAA, we like to compare this. AAA's average time to hearing is 4.5 months overall. And Miles, time range from 60 days to 1.5 years between filing and hearing. It really such a range, right? But our goal is always to move it along if we can. And so another issue, of course, for the arbitrator and for you to monitor is that, make sure that the arbitrator doesn't exceed their authority. Look at what the governing document is, right? What's the agreement or contract? The Federal Arbitration Act, Missouri Uniform Arbitration Act, and tribunal rules, like if you're using Miles mediation rules, make sure that you're following those.
Yeah. Some issues that come up under this are whether the arbitrator can award attorney's fees, whether the arbitrator can award punitive damages. And you really want to make sure that everybody is on the same page before you even start the hearing, or at least maybe before you end the hearing, but before you end the hearing, and of course, before you have issued the award. But those are the kinds of issues that I've seen come up with on this one.
So this is a case in arbitration where, you can see the facts here. Basically, the issue involved a terminated stockbroker. And so what ended up happening is that the employer moved to vacate the award, arguing that one of the arbitrators failed to disclose that his wife was a stockbroker at a different firm, right? Not the same firm, but just that she was in that practice, right? And the court said, nah. That is not, there's no duty to affirmatively provide that information. And even if they had, wouldn't have necessarily created a bias.
Yeah, and interestingly, this is a Missouri case. So that's why we wanted to include it as a good example of how far conflict can go. Had the arbitrator disclosed this, it probably wouldn't, probably nobody would have said anything. But after you lose, you're grasping for straws. What can I possibly argue? So, all right, we're going to change gears again and talk about technology in the ADR process, and including AI.
So we're talking about, when you look at using any technology this is another competence issue for the mediator. Do they know how to run it, right? Or do they have staff who will run it for them if they aren't, right? Can they admit parties? Can they use breakout rooms? Can they share screen? Can they mute? Can they make sure people aren't recording it, right? So it's very important to give advance notice. Particularly when you have pro se clients, I think, because you might have to say, look, you may have to download Zoom. It may take a while to update. You just need to make sure people are competent with the technology. You may have to help them, right? Help them. Kim and I laugh a lot about the mediations that we conduct with people in their cars. I've done mediations with people driving with their kids climbing on them. I had to get them to stop. Pull over to the road. It was really tough.
CJ, I stopped a mediation once. He was driving in his truck, like in a rainstorm, trying to mediate. I said, we cannot do this. You have to pull over. And we ended up postponing the mediation because it was crazy.
Well, and we've also talked about people being in their cars, not because they're driving, because they need privacy and they have to go out into their car or their garage to be able to do it. And so we're going to show you in a second about what your agreement should mention Zoom and other technology.
Yeah, we'll get there in a minute.
So these are the sorts of issues.
Oh, did I go too far? I'm sorry.
Oh, that's okay. So just the kind of things to think about. What if one person's in your office, the other person's on Zoom? What if they have to use their phone? What if they can't upload documents? What if you go into a caucus room and you see the shadow of an extra person walking by? What do you do with that? Who was that? What were they doing? Again, is somebody recording, whatever. And suboptimal participations we talked about. I'll tell you one, I have a pet peeve about one kind of participation is when you have a large group of people on one side and they have a Zoom, they have a drone, and you can't see their face or tell who's talking. I think that's counterproductive. But anyway, so basically, does Zoom help or hurt, and some protections you need to be aware of?
CJ, one of the earlier discussions today on this CLE was an author of a book who he and Rob were talking about what happens when we meet in person versus when we're by Zoom. And it's interesting because we now have all done, I have done hundreds of mediations by Zoom and hundreds in person and hundreds now hybrid where one person's on Zoom and everybody else is here in person, or, all kinds of combinations. And I do think that there's something to be said for everybody being here in person. On the other hand, it really has made a difference with the insurance adjusters coming in on Zoom while everybody else is here in person. And I think that actually maybe has been a real silver lining of COVID, because that insurance adjuster is staying on the Zoom the whole day. And because they can work in their office, they can get plenty of work done when I'm not in the room with them. And I like the fact that I think they're being more engaged in the mediation than they were prior to our use of Zoom, when maybe we just come in and call them and put them on a speakerphone, or maybe we'd only call them at the end of the day or something. So that has been good. But for me, I think best practice, can we get everybody here in person? Yes, that is best. If you can't do that, maybe you and your client get together in your office and, close the door and it's just the two of you. I think that's okay. I agree with you. Those drone cameras where everybody is way far back, not as helpful, not as helpful. Okay. Sorry. All right. I want to talk about AI. A lot of people are using it, and I think it's important when you're practicing to make sure your clients know you're using it. Be really aware of just or beware of just the general ChatGPT services. And I say that because let's say you've got a First Amendment case and you want to say, okay, I need a brief on First Amendment law in public schools in the States. Well, your AI is going to pick up the non-legal. Okay, I want to make sure I say this right. The just general AI is going to pick up, cases that are out there, but it's also going to pick up a Saturday Night Live skit on First Amendment rights, and it's going to treat them as though they're all equal. So you
could be helpful, Kim.
Yeah, it might be funny, but it's not helpful. There are, of course, law-based services. Westlaw through Thomson Reuters, Lexis offers one. So those are better. And I think they can be really useful if you've got a lot of data and you want some review of that data, or maybe writing routine thank you letters, writing things like that. I think it can be really helpful. But I think you have to be aware of using it for legal research or legal writing. And this shocked me, you guys, but this is the truth. Illinois Bar Journal just did an article on AI, and Stanford Institute on, use of AI or something, found that the Lexis AI service was accurate 65% of the time. That's not high enough. And Westlaw 42% of the time. I mean, those are not good numbers. And, will it get better in time? Probably, but it's not there yet. And I just found these. This is in the Bar Journal, I want to say in May. I want to say I got it out of there in May.
And I want to shout out to Marianne Weimer's earlier presentation today about AI, in which she said the more she finds out about it, the more scared she is, or the less happy she is to use it, whatever she said. But I think it's to me, it's an interesting issue that I want to research and talk a little bit more about. Is if I am in a caucus and I know that one of the participants is using AI, squishing some numbers somehow, do I have it as a mediator? Do I need to say we need to let them know? But, they talk about the information and how the information is coming from other places. There's a lot of trademark copyright issues, but some of the issues are, how do we use it and what's the disclosure? Because notice is the issue for us.
Yeah. So we've given you some sample language in your agreements, whether you're using AI, whether you're using technology, and there are a couple clauses here. So I know those are in your material, so feel free to use those. And we also then wanted to give you also a list of the resources that we use to pull this together. If you're interested in any of the things we talked about, especially like looking maybe at those local rules or things.
And this book by Shapira, which Rob had actually turned me on to and I read, is a compilation of a lot of great articles, all on mediation ethics from lots of different perspectives, and they disagree with each other, and it's very interesting, but it's very, it's pretty updated. So
okay. Hey, we love talking about mediation, and I'm really serious about that. Call us, email us. We're available. And, I think it's engaging to talk about what you guys are seeing in your mediations and what you like and what you don't like.
Kim, CJ, there were just a couple of things that were in the chat I was just going to mention. Judge Siegel mentioned that he usually asks each side, talking about proposals, he asks each side if they would be receptive to a mediator's proposal without just giving the proposal, which I
sure.
think is a very nice thing.
Yeah, I think that's really important. I want to make sure I set the stage for a mediator's proposal and ask, are you open to one? And then make sure that I spend a couple minutes explaining what I mean by it. And especially the blind acceptance rejection, because I think that's really a feature of a mediator's number that can be helpful. And then, one thing that I've done lately that I think is good on a really factually complex case, like a construction case, I've been asking the parties for 24 hours to pull together my mediator's number, and I put it in a letter with reasons why I think it is a good number. And I've had some success with that because the clients say it allows them to kind of get away from the heat of the battle and to reflect on what they're seeing. And for some of the adjusters to be able to take that letter and bump it upstairs, if they need to get approval at a higher level, they have something that they can pass along. So I've been doing that lately on more factually dense cases, and I think that's been a helpful thing.
Last comment that we had was about family law mediation, and that in the local community, while many of the family law cases are done just with mediators and clients, this participant mentioned that in about a third of his practice, lawyers are present.
And I think that's really interesting. And I would love to, it was Doug, and I would love to talk to him sometime about it because it's an interesting dynamic. Clients by themselves versus clients with their attorney. I personally like attorneys better. I think they're very helpful, right? Some people hate it. They're like, oh no, they ruin it. I was talking to some mediators here who are like, oh no, they get in the way. And I said, no, I think they keep things on track. So I'd be interested in talking to Doug sometime about what differences he sees.
Yeah.
Well, CJ and Kim, thank you so much. Good thing for all of us to think about when we go through both arbitration, mediation, because there are ethical issues for us, and that's the last thing we want to get into. And these points that you've raised will help prevent that. Folks, I want to thank everyone for attending. Great to see so many clients and friends, and frankly, so many new names on here that may have not joined us in the past. So we're excited to have you join us. Thank you for that. Please respond to the eval, give us new ideas, new topics, suggest speakers, and we'll try to accommodate that and look for more programming for our next one. Will be our 92nd best practice program.
What are we going to do for 100? That's the question.
We're going to have some fireworks, I think. Thank you all. Have a wonderful weekend.